Gerbiami kolegos.
Dear colleagues, participants of the conference, distinguished guests, hosts of this conference, I am particularly pleased to welcome you once again to mark the anniversary of the Day of the Constitution in the conference that has become a traditional one. This conference has been organized by the Seimas Committee on Legal Affairs, the Constitutional Court of the Seimas, as well as Mykolas Romeris University. This conference is dedicated to the establishment of the Constitutional Court. When last year we were celebrating the 30th anniversary of the Constitution that was adopted on the 25th of October 1992, we talked only about the Constitutional Court and the establishment of certain ideas in the Constitution. And today, we can already take a look at the 31 years to take stock of the things that have happened and to look at the architecture of the Constitution and what role it played in the life of Lithuania. Let me briefly mention a few organizational things. The conference consists of 4 parts. There will be coffee breaks and lunch and a lunch break. Although we don't have many people here in the audience, but I know that there are many people joining us online. Since the conference is broadcast on the Seimas YouTube channel, everything that will be spoken here today will be available to everyone who were not able to come to this conference in person. My colleague Stasys Šedbaras and I, Toma Birmontienė, will be moderating the first part, and therefore now I'd like to give the floor to Mr. Šedbaras. Thank you, Ms. Birmontienė. Yes, indeed, we are going to moderate this first part of the conference. Well, you are a well-known Lithuanian lawyer. You've been a long-standing member of the legal profession. You are the associate professor of the Mykolas Romeris University. Now, when it comes to the Constitution and the Constitutional Court of the Republic of Lithuania, let me say that I am particularly pleased, and I guess all the former presidents of the Constitutional Court and all the justices are very happy to congratulate each other on the 30th anniversary of the Constitutional Court. When Lithuania held a referendum on the 25th of October 1992, quite a few things were established. We have established the Constitutional Court of the Seimas, the President's Office and the Seimas, and we followed into the footsteps of Mykolas Romeris. In a sense, the President's institution and the institution of the Constitutional Court were closely related, because with the election of the President of the Republic of Lithuania on the 14th of February 1993, President Mykolas Brazauskas had to take an oath of allegiance. But to do so, he had to do this in front of society and in the participation of the President of the Constitutional Court. The first president of the Constitutional Court was Juozas Žilys, who is with us today and who was appointed as president of the Constitutional Court on the 17th of February 1992. Once the president of the took office, Žilys was offered to become president of the Constitutional Court. On the 16th to 18th of February 1992, the remaining 8 justices of the Constitutional Court were appointed. The first sitting of the Constitutional Court took place on the 15th of September 1993. To mark this date, there was a very nice event that we organized in the Constitutional Court on the 14th of September this year. I believe that to protect the rule of law, the Constitutional Court is well placed. Therefore, I congratulate everyone on the successful 30th anniversary of the Constitutional Court. Thank you. I would also like to express my words of congratulations and words of appreciation to everyone, in particular to Stasys Šedbaras, who is the person who is well aware of how the first Constitutional Court sessions looked like. And now I believe that Mr. Stasys Šedbaras sees that there are certain differences in the cases that were, let's say, some 30 years ago, and that the Constitutional Court receives now. Still, well, we know that the life is changing, so does the Constitutional Court. Dear colleagues, it is my pleasure to welcome the person who has not forgotten us and who has agreed to give a welcome address. I'm very happy to welcome Ms. Viktorija Čmilytė-Nilsen, Speaker of the Seimas of the Republic of Lithuania.
Gerbiamas Mr. Chairman of the Constitutional Court, distinguished guests, speakers of the conference, members of the community of the Constitutional Court, ladies and gentlemen, today is a special day in the context of the constitutional history of Lithuania. Today we are commemorating the 30th anniversary of the Constitutional Court of the Republic of Lithuania. Over the course of 3 decades, this court has pursued constitutional justice professionally, with enthusiasm and actively, thus case-by-case building and nurturing a democratic state. In the first part of the conference, we will hear about the origins of constitutional control in Lithuania. The honorable speakers will present to us the evolution, role, and challenges of this constitutional institution. The second part of the conference will address the concept of a living constitution, and the third will once again focus on human rights and freedoms. Constitutional control is one of the main safeguards of democracy, ensuring a balance between state authorities. It is essential that this balance is achieved not by isolating public authorities from each other, but rather by promoting interinstitutional cooperation. In other words, this vital mechanism, which guarantees human rights and freedoms and prevents the abuse of power, is designed in a way that no state power acting individually can be fully fledged. The Constitution of the Republic of Lithuania, adopted by the people in the referendum of 1992, for the first time in the history of Lithuanian constitutionalism, provided for the institution exercising constitutional control. That is, an autonomous and independent constitutional court, which performs the role of the guardian of not only the constitution, but also democracy. Today, it is difficult to imagine a Lithuania without a constitution and, of course, without the Constitutional Court, which shapes the official constitutional doctrine and adapts the constitution to the ever-changing social context. The nation developed the formal constitution, while the Constitutional Court is building a living constitution. This is a kind of perpetuum mobile we're talking about. The fourth part of the conference will offer us an opportunity to learn from others, giving us a great chance to build on the best practice of other countries and adapt their best practice and constitutional know-how. It is a pleasure to see such a list of competent Lithuanian and foreign speakers in this conference. They will certainly enrich this conference with their insights. Let me finish by expressing my gratitude to everyone for their present and future contributions. I hope that this conference will give a strong impetus to reach for greater achievements in the future and cope with the emerging challenges to constitutional law. I wish everyone to enjoy a heated debate, gain new knowledge, and learn new ideas. Congratulations once again on this jubilee. Thank you.
Thank you very much, Madam Speaker of the Seimas. The Constitutional Court and the Seimas are related by certain links because the justices of the Constitutional Court have to be approved by the Seimas. Other countries have other practices. It is a pleasure to participate in different conferences and to hear the praise to the Constitutional Court from the Seimas and its speaker. And now I would like to give the floor to my former colleague Irena Haase, Chair of the Committee on Legal Affairs of the Seimas of the Republic of Lithuania. Thank you, colleague. Madam Speaker of the Seimas, President of the Constitutional Court, participants and representatives and guests from the Constitutional Court, the Law School of Mykolas Riomeris University, and the Lithuanian Bar Association. I warmly welcome you to the annual International Scientific Conference dedicated for the Constitutional Day and the 30th anniversary of the establishment of the Constitutional Court of the Republic of Lithuania. I'm very pleased and delighted that our foreign guests have joined us in our conference and will share their insights and experience. Constitutional review is an important and necessary part of a democratic state. It ensures that public authorities act in accordance with the rules of law and respect the fundamental principles laid down by the Constitution and do not misuse their power in developing law. One of the most important means of constitutional review is the functioning of the Constitutional Court. The Constitutional Court has the opportunity to review and determine the constitutionality of legislation adopted by the authorities, which ensures that legislation and actions are compatible with the Constitution and its values. Constitutional review is an active help at virtually all the stages of the legislation, both in ex-ante scrutiny and ex-post review, and is therefore an essential role in ensuring the rule of law and preventing it from being exceeded through the adoption of flawed and unconstitutional legislation. Society can and should also play an active role in constitutional review. Citizens' right to free speech, freedom of the press, and constitutional review is thus an essential element of a democratic state, guaranteeing the accountability, legitimacy, and respect for fundamental rights and freedoms of the authorities. It helps to avoid the abuse of power and ensures that the state's actions are in line with democratic values. Once again, I welcome all the participants to the conference, and I wish the conference participants a creative debate, useful experience, and pleasant moments. Thank you, Chair. Now, due to very objective circumstances, Dean of the Law School of Mykolas Riomeris University was not able to participate here in person, but she has sent her welcome address. So now I'll put on the screen the welcome address by Professor Dr. Lyra Jakulevičienė, Speaker of the Seimas, Chair of the Committee on Legal Affairs, participants of the conference. On behalf of the Mykolas Romeris University Law School community, I welcome you to the 10th Annual Conference on Constitutional Law. This already traditional conference brings together scholars and practitioners and explores topical issues in constitutional law. It is no coincidence that this year's conference focuses on the issue of constitutional review. At a time when states are confronted with a multitude of local and global challenges and crises, the temptation to abuse the law has been increasing. Meanwhile, constitutional review, as a vital element of a democracy, is the very means of ensuring that there is no deviation from fundamental constitutional principles and values, irrespective of the laws that are passed or the political regime in power. Perhaps the only difference lies in the models and ways in which constitutional review is exercised across countries. The Constitutional Court, which is responsible for constitutional review in Lithuania, is marking its 30th year of operations. 30 years is a long time in a person's life. However, given that constitutionalism in Western Europe took centuries to develop, 30 years in the life of the court is probably just a brief period. Over the course of these 30 years, however, the Constitutional Court has established itself in the Lithuanian legal system as a symbol of stability, independence, and wisdom. It is particularly noteworthy that since 2019, it is also accessible to every individual who may lodge an individual complaint to defend their constitutional rights. Mykolas Romeris, the founder of constitutional law in Lithuania, said the following about the courts. Quote, "The court is the lifeblood of the law," unquote. One might say that the judges of the Constitutional Court breathe life into our Constitution on a daily basis by hearing the constitutional disputes. It is the Constitutional Court that ensures that the Constitution is interpreted in accordance with the needs of society and the changing realities. And that is why it is applied in a stable manner and can only be changed in very exceptional cases. As we look back on the past 30 years of constitutional jurisprudence, we can now tell the story of our Constitution and at the same time that of our nation and democracy. On the other hand, the Constitutional Court also faces much criticism because the decisions aimed at guaranteeing the stability of the Constitution are not always popular or universally suitable. Mykolas Romeris pointed out that we, as lawyers, clearly understand that the court is the foundation on which any role of law or legal acts in the state rests. We therefore are committed to strengthening the court, to enhancing its standing and to safeguarding the independence of the judiciary. My wish is that the strengthening of the court should not be a matter of interest only to lawyers. I congratulate the founders of the Constitutional Court, all its presidents, the judges and the administrative staff on this landmark anniversary. I hope that the court will continue to be a guiding star in the life of the state of Lithuania and a source of hope for justice for people. I wish the participants of the conference a very meaningful debate. Let the celebration of scientific thought begin, because scientific thought is best placed to assess yesterday, today, and tomorrow.
Thank you very much, Professor Lyra Jakulevičienė. Law School of Mykolas Romeris University is the main initiator of the conferences, annual conferences. And it has become a tradition to hold this conference here in the Parliament. At the initiative of Mykolas Romeris University, we hold conferences and we also celebrate Constitution Day today. Now, ladies and gentlemen, let us move to the main presentations and the main session of the conference. and we will be reviewing 30 years of the activities of the Constitutional Court of the Republic of Lithuania. And I would like to give the floor to Dr. Gintaras Goda, President of the Constitutional Court of the Republic of Lithuania. The floor is yours.
Gerbiamoji Seimo pirmininkė,
Madam Speaker, Chair of the Seimas Committee on Legal Affairs, distinguished organizers of this festive event, speakers of this conference, dear guests, ladies and gentlemen. Congratulations to you all on the upcoming day of the Constitution and the 30th anniversary of the establishment of the Constitutional Court. Only a year younger than the Constitution itself, the Constitutional Court has ensured the supremacy of the Constitution and law in the Lithuanian legal system and has administered constitutional justice for 30 years now, since its establishment. The Constitutional Court protects the constitutional order in a very special way assigned to it by the Constitution, that is, by handing down rulings on constitutional justice. It exercises control over compliance of legal acts with the Constitution. It also submits its conclusions and delivers interpretations of its own final acts. In exercising these powers, the Constitutional Court, as an essential element of a democratic state, demonstrates its role in contributing to the development of the rule of law and fostering of democracy in the state. Since its establishment in 1993, the Constitutional Court has become the institutional guarantor that has and continues to ensure that the government stays bounded by the Constitution, which is the undeniable essence of constitutionalism. The activities of the Constitutional Court have expressed the essence of constitutional justice, which is to guarantee the inviolability of the Constitution. As Professor has mentioned, it would be difficult to go over the vast 30-year period when it comes to activities of the Constitutional Court, so I would like to focus on some of the key aspects. First of all, it would be related to the supremacy of the Constitution. After the establishment of the Constitutional Court, we had to explain to everyone what Constitution actually meant. People of my generation were aware of the constitutional law and the Constitution. All of them had a red book in their hands titled The Constitution. The Constitution actually was that of the previous stages in the life of the state. A democratic constitution, though, was something different. So that it was no surprise that the Constitution had to explain what the Constitution actually meant, something that is understood quite naturally nowadays. For example, in one of its previous rulings, the Constitutional Court ruled that all the legal acts have to be harmonized with the Constitution, thus making sure that the Constitution becomes the supreme legal act and the basis of the entire legal system of the state. Later on, in developing its constitutional doctrine, the Constitutional Court also noted in one of its rulings that Lithuania is a democratic state that needs to ensure the supremacy of the Constitution, as well as human rights and fundamental freedoms, free and universal equal suffrage, free elections, balance of powers, a democratic election process, political pluralism, the possibility for society to develop. And 2 years later, the Constitutional Court adopted another ruling which established the Constitution-centered concept of law. We, of course, could not allow ourselves to forget the international law and the respect for international law. So, respect for international law was also considered to be a main principle of the Constitution. In order to preserve the main principles of the Constitution, A limitation of the changing of the Constitution was adopted as a key principle later on. The Constitutional Court ruled that no amendments to the Constitution can be made that would undermine the innate values of the Constitution. In the absence of those constitutions, there would be no democratic state of Lithuania. The Constitutional Court also had to explain what the Constitutional Court refers to. In 2006, a few years later, since the beginning of the activities of the Constitutional Court, the members of the Seimas found it difficult to understand what the Constitutional Court is and what it does. The date was quite easy to remember. It was the 6th of June 2006. In that ruling, the Constitutional Court ruled that it was quite surprised that the members of the Seimas approached the court with a lack of understanding as to the essence of the court. But I digress. Now, the second field where the Constitutional Court developed a very characteristic constitutional doctrine was the area of human rights and fundamental freedoms. Since the beginning of its activities, the Constitutional Court kept stressing that the constitutional order of the state is based on the priorities of human rights and fundamental freedoms. The court kept stressing that one of the key objectives of a democratic state is to defend and protect human rights and fundamental freedoms. A constitutional doctrine in this field was mainly established thanks to the petitions filed by the Lithuanian courts. It's quite a wide-ranging doctrine, so I could only focus on some of the few aspects. Although quite many years have passed, nevertheless, the ruling of the 9th of December 1998 on capital punishment is constantly being referred to. The ruling states that the human life is the highest value in the state. This ruling also looked into innate nature of human rights. The court also developed a doctrine on human dignity, on social affairs, on the protection of property rights, on the development of civil society. It is important to note that the Constitutional Court has recognized the right of civil society to express itself freely and to have the right to information. In its ruling of the 13th of February 1997, the court, when interpreting Article 25 of the Constitution, also stated that the free and universal exchange of information, its unrestricted dissemination, are a particularly important factor in democratic processes. This factor ensures not only the formation of individual opinion and subjective convictions, but also that of group views, including political as well as that of the whole nation's will. In the ruling of the 13th of June 2000, the court confirmed that the freedom of convictions and their expression establishes ideological, cultural, and political pluralism. No views or ideology may be declared mandatory and thrust on an individual, that is, the person who freely forms and expresses his own views and who is a member of an open, democratic, and civil society. This is an innate human freedom. The concept of pluralistic democracy, usually associated with the freedom of information and expression, has gradually been extended to include the diversity of religions and beliefs. In the jurisprudence of the Constitutional Court, the concepts of ideological, cultural, and political pluralism have been complemented by religious pluralism. Which was deemed an essential element of pluralistic democracy in the ruling of the 7th of September 2021. Today, we've already referred to an individual complaint filed to the Constitutional Court. This was thanks to constitutional amendments made in 2019. We've heard quite a few remarks regarding the establishment of this institution. It has been said that there is currently a lack of interest in using this instrument, but I would like to take the opportunity to recall to everyone that when people want to make use of this instrument, they have to provide evidence that a certain law that was adopted violated the rights of citizens. If you were to refer to the German Constitution, you would also to the German Constitutional Court, you would also find some information on a recent ruling regarding the violation of the citizens' rights by not providing the full possibility for the citizens to file an individual complaint to the Constitutional Court. I believe that when our Constitutional Court will celebrate its 50th anniversary, I believe the court will be able to finally say that the mechanism of individual complaint has finally gained full force. The constitutional doctrine has also been developing its doctrine on referendums. Democracy, as one knows, does not work on its own. In democratic states, elections are the main form of expression of the nation's will. So there have been quite a few rulings by the Constitutional Court on referendums where the Constitutional Court has established the preconditions preventing unfair practices in elections. The court has ruled that persons that have violated the principles of democratic elections have to be eliminated from the election process. The Constitutional Court has also adopted similar rulings regarding the single mandate constituency issues. The Constitutional Court has ruled that many of the principles that are applied in organizing referendums should be applied when it comes to organizing elections. And the court ruled that decisions that are incompatible with the Constitution may not be adopted. The Constitutional Court has also ruled that the requirements of the Constitution should not be applied not only in their content but also in their form. The Constitutional Court's input in shaping the different aspects of the principles of the Constitution is undeniable. The court has also developed its constitutional doctrine with regards to the separation of the powers of the state. In one of its rulings, the court has stated that the powers of the state had to be quite independent. However, there should be a balance between those powers at the same time. The court has ruled several times that controls have to be established when it comes to the balance of these powers, but these powers of the state have to stay independent and interrelatable at the same time. There should be mutual partnership between those states, and the Constitutional Court has also established that there should be certain boundaries that cannot be exceeded when it comes to these powers. It is precisely the limits of powers of state institutions enshrined in the Constitution that allow the Constitutional Court to clearly define the form of government of the state of Lithuania, identifying Lithuania as a parliamentary republic, with some peculiarities of the so-called mixed or semi-presidential form of the government. The Constitutional Court has also concluded that in its effort it is also protecting political pluralism, human rights and fundamental freedoms, as well as other constitutional values. These and other democratic elements have been developed in the activities of the Constitutional Court. The Constitutional Court has also reiterated time and again that the Constitution presupposes the defense of the parliamentary minority and minimum requirements for the protection of the opposition of the Seimas. The statute of the Seimas must also lay down the guarantees for the activities of the opposition. The court, in conducting its control of the legal the compatibility of the legal acts with the Constitution, has also looked into the democratic order of the state, Over the years, the official constitutional doctrine has been developed and elaborated, explaining various aspects of democracy. The court has explained the guarantees informing state institutions exercising their powers and executing other activities deriving from the Constitution, as well as the fundamentals of accountability of these institutions to the citizens and the limits of the powers of government, which represents the essence of the Constitution as the supreme piece of legislation. In particular, the constitutional doctrine has focused on the aspects of human dignity, inviolability of freedom, equality, other guarantees of human rights, and the fundamentals of citizens' participation in state government. It can be therefore firmly stated that today the doctrine of strengthening democracy developed by the Constitutional Court reflects the European democratic tradition and consolidates the European democratic heritage. We can therefore now enjoy an understanding of a multifaceted democracy that has been gradually developed and enshrined throughout the whole of the Constitution, and not only in its Article 1. In addition to the official constitutional doctrine interpreting other norms and principles of the Constitution, which is inseparable of this kind of democracy, as well as the Constitutional Court, which has become an integral part of Lithuania, a democratic state of law moving towards mature democracy. Let me just end by saying that the visibility, the presence of the Constitutional Court has grown over the years. I'm not sure how this can be measured. However, there are some of those rulings of the Constitutional Court that are more important to a certain group of society. There are people who tend to criticize public institutions or perhaps take over the power in them. We have heard some of the examples from Poland, Sweden, or elsewhere where there have been certain misunderstandings, Portugal included. There have been attempts to undermine the role of the Constitutional Court in Israel. So there are certain risks that we tend to deal with. It's a pity that we still have to deal with such things 30 years on since the establishment of our independence. But nevertheless, the Constitutional Court is an institution that defends and protects the state. Thank you.
Ir pranešimas buvo skirtas apžvelgti konstitucinį.
Thank you very much. The task was to overview the activity of the Constitutional Court throughout the period of 30 years, which is hardly possible because in all this period, the Constitutional Court has adopted a number of decisions. And another aspect of the activities of the Constitutional Court will be further discussed. Now I say thank you, and we finish the moderation of this part of the conference, and part one of the conference will be moderated by Professor Dr. Daiva Petrilaitė, Justice of the Constitutional Court of the Republic of Lithuania, and Associate Professor Dr. Ernestas Spruagis, Associate Professor of the Law School of Mykolas Romeris University. I thank colleague Toma for co-chairing this part, and I hope that we could follow the example of Israel should the situation be to the detriment of the Constitution. Good morning, ladies and gentlemen, guests. It is a pleasure to see so many of you. We still have people coming to the parliament, and many of our participants joined us online. I would like to give the floor to Ernestas to say a short welcome introduction. Good morning. It is a pleasure to see so many of you, and I'm also glad that some have joined online. While this is a great occasion of the important institution, the institution that guarantees the human rights on the highest level. And in the first part of the conference, we will have very distinguished speakers who will discuss the roots or the beginnings of the constitutional review in Lithuania, not only when the independence of Lithuania was restored, but even before that, and present some scientific ideas on this. Thank you. And now, without further ado, I would like to give the floor to our first speaker, Professor Dr. Juozas Žilys. He has made a very important contribution to the development of the Constitutional Court. He is the first president of the Constitutional Court who was in this capacity between 1993 and 1999. He also taught in Mykolas Romeris University and was the dean of the Law School of Mykolas Romeris University. He is also an active participant in different public organizations. It is important to note that Professor Juozas Žilys was a member of the working group that drafted the concept of the Constitution of the Republic of Lithuania, and also the head of the interim commission for drafting the Constitution. In 2012, Professor was given the award of the Professor of Honor of Mykolas Romeris University, and also was given Professor Emeritus degree at Mykolas Romeris University. Professor Žilys is interested in constitutional development and the theories of constitutional development in Lithuania. So we have a great chance to hear many interesting and important things. And Professor will be speaking on the fundamentals of constitutional review in interwar Lithuania. colleagues, I think that this is the easiest topic when we speak about the past. It is easier to speak about the past compared to the present, and the more so about the future. Well, the aspects, political, legal, or social, are rooted somewhere. We don't have lightning struck and things emerge. We have some roots or beginnings of something somewhere, and this is followed by something else. In this case, I'm very glad to come back and to recall the literature and the theory of the beginning of the 19th century and the beginning of the 20th century, and I will start from this. With regard to the idea of the constitutional review between 1918 and 1914 in the Republic of Lithuania, it should be noted the ideas of the pure theory of law developed by Hans Kelsen were also relevant. The question of how the guarantees of the realization of the Constitution in general and of its specific norms had to be ensured could not have been avoided in the constitutional development. The fundamental principle that laws must comply with the general norm, i.e. the Constitution, has already been proclaimed in the first constitutional acts, namely the framework of the Lithuanian State Provisional Constitution of the 2nd of November 1918 and in the framework of the Lithuanian State Provisional Constitution of the 4th of April 1919. Those documents stated that acts have to be in line with the Constitution. All state authorities could evaluate this alignment, and also some appropriate courts while ruling the cases. And there were no institution as such to perform this role. I will remind one more quotation of Mykolas Romeris during the period of provisional constitutions. I quote, "There was no and could not have been any constitutional court. There's no need to talk about this. This is still almost everywhere a luxury of legality." In Lithuania at that time, in the absence of a permanent constitution and as the constitutive powers were still in place, it would also be impossible. The further strengthening of the parliamentary direction in the order of power and the constitutional regime could not, of course, favor any reform that would strengthen the legitimacy of government work, in particular vis-à-vis the administration. The provisional law and its drafting in Lithuania after the restoration of Lithuania's independence, the provisional basic law formulated the status of the constitutional court and the necessity of establishment of one. So this is related to the theory of Romeris, that temporary constitutional status is not in favor of the establishment of the constitutional court. The way in which the legality of the promulgated laws, i.e. their unconstitutionality, was debated on in the drafting of the Lithuanian Constitution of the 1st of August 1922 and in the constitutional deliberations in the Constituent Assembly. It was suggested that the law that is unconstitutional is not only ineffective but cannot be promulgated. There were views that a specific legal framework should be laid down in the Constitution to ensure the implementation of the principle of constitutionality of laws. Consideration was given to giving the Supreme Tribunal the right to rule on the constitutionality of legal acts. The Lithuanian Lawyers' Society proposed a provision stipulating that all courts can check whether the constitutionality of laws. There were also opposing views that the legality of laws adopted and promulgated shall not be considered by the court. The content of the debate on constitutional review is also illustrated by the following passage of the sitting of the Constituent Assembly of the 8th of March, 1922. I have quoted this fragment, but I would like to remind it once again. During this sitting, Secretary Antanas Tumėnas argued for the necessity of enshrining the law of constitutionality of laws, explaining that this is intended to avoid a situation in which laws could repeal the Constitution itself. Social Democrat Kazimieras Venslauskis, a member of the Constituent Assembly who broadly supported this idea, raised the issue of its implementation and sanctions. In his view, the mere declaration of the principle does not ensure that unconstitutional laws will be precluded. Zigmas Pranas Starkus, agreeing that this issue is very relevant, called for a referral back to a commission which will propose the establishment of a court to assess the constitutionality of laws. Venslauskis reiterated his insistence on the establishment of specific constitutional procedures to deal with these issues. I quote, "I say it's clear that a body must be set up in which matters must be resolved. What should that body be? In my opinion, it must be a court." Vytautas Balčiūnas from Christian Democrats was convinced that this problem would be solved by life itself. If we keep going and looking for a control body, only one control body is possible here, namely the conscience of all the co-legislators. So these were the considerations and ideas during the final stage of the drafting of the Constitution of 1922. The Constitution of 1922 stipulated that no law contrary to the Constitution shall be enforced in the state of Lithuania. There were no mechanisms for the implementation of this provision, however. On the 15th of May 1928, the Constitution of the Lithuanian state, which introduced a fundamental change in the status of the Council of State, which was given different consideration, but this institution was engaged in drafting of legislation. In the same year, when the Constitution became operational, Romeris published the first scientific monograph about the constitutional legality issue. He spoke not only about administrative court and the necessity of establishment of constitutional court. In the foreword of the monograph, Romeris defines such court as a court for the proceedings of the governmental bodies and said, The latter court applies to the work carried out by all governmental officials and those main bodies of government which operate within the limits of the constitution of the state and are not dictatorship. In 1938, the drafters of the Lithuanian constitution and the parliament did not waive the constitutional rule that laws which are contrary to the constitution shall be ineffective. However, in the systematic hierarchy of constitutional rules, this provision was moved from the first chapter, which contained essential descriptions of the state, to chapter 13, entitled Laws. In addition, to declaring the constitutionality of laws, the first versions of the 1938 draft constitution reflected the intention of the Commission of the Council of State on drafting a new constitution, not only to declare the constitutionality of laws, but also to establish an institution to deal with issues relating to the verification of the legality of legal acts. The Commission envisaged that the Constitutional Court would be a branch of the Supreme Tribunal headed by the President of the Tribunal. However, it was soon decided to establish it as an autonomous institution. It was envisaged that the court would comprise the President, Vice President, and 3 justices appointed by the President of the Republic for a period of 7 years. The positions on the Constitutional Court were not implemented. They were removed from later texts of constitutional drafts. It was not at the will of the Commission, but this was the desire of the existing authorities. It must be said that the court would not be in line with the philosophy of the state authorities and its concept that was implemented in Lithuania after the coup of the 17th of December 1926. In view of the legal heritage of the Republic of Lithuania and the ideas on constitutional review put forward at that time, the name of Mykolas Riomeris and his reflections emerge. In seeking an answer to the constant question on the means of ensuring constitutional reviews of the legality of laws, Riomeris examined the various options and their effectiveness. This is also relevant to today's discussions and probably the future discussions on the constitutional review or justice. In seeking an answer to the constant question on the means of ensuring constitutional review of the legality of laws, Riomeris examined the various options and their effectiveness. That is to say, as if wondering whether the more complex rules for amending the Constitution could ensure its safety. He unhesitantly replied that there were no guarantees in this respect. An oath or solemn undertaking is also not an absolute prevention of the violations of the Constitution. The professor assessed comprehensively whether criminal, administrative, civil, and finally political liability could be a means of discouraging the breach of the Constitution. In this case, too, he made a negative conclusions. Possibilities of direct democracy, referenda, and the role of public opinion were debated. It was argued that, unfortunately, these factors did not in themselves guarantee the constitutionality of legislation. In Riomeris' scientific work, there were also other topical issues analyzed, namely, which institution should exercise the function of constitutional review. The conclusion was clear. Random control of the constitutionality of laws by entrusting general courts would not appear to be fully compatible with the classical constitutional construction of representative democracy, and in particular with the clear and categorical exclusion of the General Court from the sphere of government policy. In the search for constitutional safety, Romeris found a solution. I quote, "It is a separate body of the high established power set up in the general judicial system, which has a representative character, delegated on the grounds of justice, which includes, among other things, a precise review of the constitutionality of legislative acts, which is in itself more precise and serious than the random quasi-control which is practiced in the United States of America, and for which, as we have seen, disputes also arise on the European continent." To be brief, I would like to note that between 1918 and 1940, no body was established for constitutional review, but I would like to mention that before the war, the Council of State had the law on the administrative court, but everything changed due to certain circumstances. The law of 1933, there was a law on courts, and there was a tribunal that was hearing a specific case, would often present the interpretations of the constitutional text. The Council of State, which is being seen in a different light currently, some see roots of constitutional justice in this as well. The Council of State was not to the detriment of the parliament, democracy, or constitution, as Romeris said, but it could not change the bodies of political authorities. It was a modest institution that should be seen in its real service as sum cuique. There was a statutory, the idea of the statutory court was popular in Lithuania at that time, and its implementation was expressed in the law on the statutory court of the 13th of March 1935. The creation of such a court was prompted by the difficult circumstances in which the Lithuanian government sought to exercise its powers. The court would review the compatibility of legal acts of Klaipėda region due to aggressive opposition of Germany to the establishment of such a court that was not established finally. Now, the idea of constitutional review was constantly discussed by different philosophers, intellectuals in their debates. And there were propositions made that president should be given the right to change the system. Augustinas Valdemaras, former prime minister, said about the laws. He wrote in a letter to public figure Pranas Dovydaitis, the Lithuanian constitution, following the constitutional laws in the cultural states, introduces a very important concept of legality of laws. A law may be formally okay, but the significance of the law is not recognized. In some countries, let's say in France, there is a procedure to check whether the law is constitutional or not. The same has been introduced in Lithuania. All of its constitutions lead to the idea that only laws that are in line with the constitution are in effect in Lithuania. A formally unlawful law may in principle be unlawful. Valdemaras remembered the lawfulness of the law at that time when he was to be tried for his actions against the stability of the state, and Valdemaras thought that this would help to save himself. Speaking about another post-war period, I want to recall some moments here. Looking at the legal cultural heritage of Lithuania, it is appropriate to recall the diaspora's fostered vision of the constitutional structure of liberated Lithuania. The diaspora was consistently motivated by ideas about the future constitutional foundations of Lithuania. One topic of discussion was how to ensure constitutional review of the legality of laws and other legal acts. And here I will quote a meeting that took place in the diaspora front. The young generation of Lithuanian intellectuals who had developed plans on how to improve Lithuanian statehood well before the war. Citizens have to be given the right to bring cases before court on any matter that relates to their life. In conclusion, I would like to recall that in the year 1948, Lithuanian displaced persons lived in a camp in a small town in Germany. And Vincas Mašalaitis, who had worked for the Lithuanian government apparatus before the occupation in various capacities, he moved to Germany in 1944, where he participated in social activities in the camp of displaced persons. He was a member of the Supreme Committee for the Liberation of Lithuania. In 1949, he went to the United States of America with his wife and was active in Lithuanian organizations. He drafted a constitution in 1949. Eidantas published a book describing this draft by Vincas Mašalaitis. Maršalaitis was in favor of the presidential democracy and the ideas of presidential democracy, but he also proposed the establishment of the Constitutional Court as stipulated by the Constitution. That he also stipulated that any law shall be aligned with the Constitution. Laws which are contrary to the Constitution shall not have effect, followed by the constitutionality of the law is decided by the Constitutional Court. And such Constitutional Court should consist of the President of the Supreme Tribunal, President of the Council of State, one representative of the court faculties, respective lawyers, representatives of lawyers' organizations. And the President, Vice President, and other members of court should be appointed by the President of the Republic at the proposal of the Prime Minister. The President, the Vice President, and other members should be appointed for a period of 5 years. The constitutionality of the law brought before the Constitutional Court by the prosecutor of the Supreme Tribunal, a fundamental principle was established. Until the Constitutional Court has declared a law unconstitutional, nobody can plead its unconstitutionality. We might argue with Maršalaitis and his ideas and proposals, but these were his proposals. The fragmental view of Lithuania's legal cultural heritage, and only insofar as it concerns the current state of the Constitutional Court, there's a presumption that this heritage has influenced the constitutional creation and development of the Lithuanian state in an appropriate extent. The objective reasons also lead to the fact that the provisional basic law of the Republic of Lithuania had not yet provided for a constitutional court, but declared that all Lithuanian laws and other acts of state bodies are adopted on the basis of this provisional basic law. The law approving the provisional basic law stipulates, in Lithuania, only legislation that is compatible with the provisional constitution shall be in force. In Lithuania, the concept of the Constitutional Court evolved in over 2 years of debate in society and in the parliament, the Supreme Council. It was formulated and published in the current constitution of the Republic of Lithuania. It can be said that this concept corresponds to those democratic expectations that were fostered and were expressed in Lithuania before World War II and among the Lithuanian diaspora in the pre- and post-war period. Thank you. Sorry for taking so much time. I just used the opportunity to speak.
Thank you, Professor. Thank you for your insight about the very beginnings of the constitutional review in Lithuania. Now let me give the floor to another keynote speaker, also one of the founding fathers of our Constitution. This is Professor Dr. Gidus Jarashiūnas. I guess it would take another presentation for me to make in order to tell the positions that Mr. Jarashiūnas had taken previously. Well, Mr. Jarashiūnas used to be a lawyer. He is a human rights advocate. He was elected to the Supreme Council of Lithuania back in the 1990s. He's also signatory to the Act of Independence. Later, he was a member of the Lithuanian Parliament until 1996. He's also a justice. He was the Justice of the Constitutional Court from 1996 to 2006. It should also be mentioned that Professor was not only the representative of the Constitutional Review here in Lithuania, he also was the Justice of the European Court of Justice for several years. So he, well, in a sense, was conducting the constitutional review of the European Union. And thirdly, let me mention that he is a well-known researcher and author of many articles on legal affairs. He has also translated from French he's also the Doctor Emeritus of Mykolas Romeris University. He was the Dean of Law Department in that university. So, dear Professor, the floor is yours. And you are going to speak about the constitutional review in the draft constitutions of a restored independent Lithuania. Thank you, dear colleagues. Well, we've been taken very consistently to the second stage of the presentations. Now I'll take you to the period of 1990 to 1992, and I'll be speaking about the constitutional review in the draft constitutions of restored independent Lithuania. That means I am going to speak about the period when there were a lot of draft constitutions. There were a lot of opportunities to adopt decisions, and actually I will be speaking about the most important and the most interesting period, because at that time we had to decide which route we have to take, which direction we had to take. If to talk about the constitutional review, there was one thing that was clear. So the judicial constitutional review of laws was indispensable in the constitutional system. However, what its concrete embodiment would be was still to be decided. And all those drafts, well, some of them were deliberated and submitted to the reconstituent Seimas. That means they were submitted to the parliament, whereas other drafts were deliberated and submitted by various political parties and even by our adversaries. During the fourth wave of constitutionalism, and well, we were at the very beginning of it, Lithuania, just like many other countries, was a typical Central and Eastern European state, where the developers of the constitution, well, we had to think of the new standards that did not exist before us, but which were crucial for the period that we were working in. So the constitutional review the idea of the constitutional review is related the model of constitutional review was very necessary. So we try to look at this necessity at the beginning of the 20th century. So we had some ideas, however, we did not have any practice. Therefore, we had to refer to foreign practices. We had to look at foreign jurisprudence examples, and when choosing the model, we had to either adopt the foreign models mechanically, or to copy paste the model, or to adopt a creative approach. And before the adoption of the Constitution, there were quite a lot of discussions with regard to the model of the Constitution itself, whether we should adopt the American constitutional review model or the European constitutional review model, that is to have a special court for constitutional review. Well, both the models have various advantages, because, for example, the American model is based on case law. Of course, there are many critics when it comes to the American model, but let me say that this model is perfectly functioning in Denmark, Sweden, and other countries. The European constitutional review model with the Constitutional Court, the institution that in the European continent has practically become dominant. And when discussing various drafts of the Constitution of 1992, we already knew the weight of the Constitutional Court in the legal system of many Western European countries. Therefore, we had a question in front of us. Well, it should be noted that every who contributed to the drafting of the Constitution were in favor of the constitutional review. There was no one against that idea. But there were differences with regard to the model of the constitutional review to be chosen. Well, some believe that any court could address the issue of constitutionality, whereas some believe that only the Supreme Court could do this. If we had to choose the European model, we had to think of the composition of the court, the requirements for the justices of the court, and so on and so forth, the scope of the cases that the court will be dealing with. Some believed that, for example, then there would be a need for the law on the Constitutional Court. But if the Constitutional Court is the institution that is to review the decisions taken by the government, the provisions with regard to the functioning of the court should be established and enshrined in the Constitution itself, because this would guarantee the independence of the court. Because if the entity that you are to control can amend the provisions in the Constitution, then the efficiency of the court would be much less. So in the discussions, the issue of the constitutional review was out of question, because everyone believed that the constitutional review was needed. During this period, there were new requirements for the drafting of the Constitution and for the adoption of the Constitution, because previously it was believed that it was the nation that had to develop the text of the Constitution, and the text of the Constitution had to be adopted by the nation, whereas during the period between 1990 and 1992, the citizens had to be engaged in all the stages of the drafting of the Constitution. And that all the mechanisms had to be engaged in order to ensure the broadest possible consensus, and the discussions guarantee that the final outcome is the outcome that is the best for the state. Because in the absence of discussions, the outcome will be mainly based on trust to those who were to draft the Constitution. So what were the models that we looked into, and what were the proposals? Some of the models, as I have mentioned, were deliberated in the Parliament, that was called the Supreme Council then. Other draft proposals were made by lawyers. But both of those had equal significance. If we looked at the context of all those deliberations, we have to take a look at the first proposal that was made in 1991. The first of them was drafted in May 1990, and it was published as a separate book by the authors who were members of the Lithuanian Lawyers and Philosophical Society. In this draft, we will not find direct provisions on the supreme power of the Constitution. This was just the first draft, but in Chapter 5 of the draft, there was a framework for the organization and operation of the courts, whereas Article 71 provided that the courts shall have the right to review the Constitution. So, in fact, all the courts established had the right to review the Constitution. In June 1991, American researchers Laurie Wyman and Barnab Johnson prepared a draft, and this draft was published in the Lithuanian newspaper Atgimimas. This draft offered the presidential governance of the state, and in this draft we can find that the Constitution of Lithuania can only be the supreme law of the Republic of Lithuania, and no law, no municipal regulation, no administrative rule, no instruction, no act of government or any other decisions that are contrary to the Constitution can be adopted. This draft had a very huge theoretical weight. Very often the things that are defined in the Constitution very briefly were defined very extensively in this draft. Moreover, the translation of the draft document that was prepared by American researchers was not very good, because the translation was done not by lawyers, but by linguists. And they used the concepts and terms that were not appropriate for our legal system. So, again, it was explicitly said that all the courts in Lithuania could engage in constitutional review. There was also a third draft of the Constitution. That was the draft proposed by the Liberals, and this draft provided that where the court sees the unconstitutionality of the law, it has the right to suspend the law and refer the case to the Supreme Court. And according to that draft constitution, the constitutional review would have to be carried out by the Supreme Court. There was also another draft that was prepared by the Council of the Democratic Labour Party of Lithuania. The draft clearly enshrined the supremacy of the Constitution and that the Constitution was subject to constitutional review. It also provided that the Constitutional Court should be an independent authority that had to administer justice in Lithuania. The draft also provided for the competences of the court. There were other drafts as well. Not all of them were copy-pasted. But I'm not going to look into them. Now, let us move on to the parliamentary deliberations of the draft constitution. During the first stage, the members of the parliament, the lawyers had to look at the very concept of the Constitution. The Supreme Council established a commission for that, and this in this process, questions of consolidation of constitutional review were also raised. There were proposals to have a French variant. However, it was thought that there will be a court with 9 members, and the competences of the court had to be established by a separate law. During the second stage was the considerations of the resolution of the 6th of November 1999 on the development of the constitutional process. There were 2 processes, so one in the Supreme Council, and there was a referendum organized by the Sąjūdis. In the model of a constitutional review supported by the majority, the Provisional Commission submitted 2 projects. Majority of the Commission offered a typical European constitutional review model. The representatives of the reform movement Sąjūdis proposed a hybrid model of the constitutional review. When it comes to the first model, the Constitution was to be treated as the supreme law of the Republic of Lithuania, where the Constitutional Court had the role to to control whether the laws of the Republic of Lithuania were in compliance with the Constitution of the Republic of Lithuania. So according to that proposals, there had to be 9 lawyers elected for the period of 9 years. Well, of course, there were quite a few ideas as to how these justices had to be elected. And there were proposals that it was the Lithuanian parliament that had to nominate justices to the court. So, but it was also envisaged that the 1/5 of members of parliament could apply to the Constitutional Court. Also, members of government could apply to the Constitutional Court. The Majority Commission of the Lithuanian Reform Movement Sąjūdis proposed a hybrid model. That means they offered to establish a supreme tribunal and this majority group believed that the Supreme Tribunal should have some specific features of a constitutional court, and it was believed that if the law was against the Constitution, the laws had to be suspended. At the same time, the tribunal could work as a constitutional court, and this tribunal court had to look at international treaties, at the constitutionality of national laws. At the same time, the Supreme Tribunal had to act as could determine whether laws have been violated during the elections of the members of the parliament, and at least 1/10 of the members of the parliament, the president and the government could go directly to the High Tribunal and to challenge whether certain legal acts were constitutional or unconstitutional. So there were attempts to establish a hybrid institution. There were discussions as to which option should be chosen. Also, the drafters of those documents had to ensure that the institution that would be responsible for the constitutional review had the power to resist the influence from the government. And in the final stage of constitutional compromises, The political forces in the Supreme Council agreed that there should be a general, a normal constitutional court without experimenting. I believe that the country with this judicial experience was the most rational variant. The constitutional review that is carried out by the Constitutional Court and the results of that constitutional review is well known to us. We can only discuss what would have happened if we had introduced other constitutional review models and what their efficiency would have been. But I believe that the operation, the establishment of the Constitutional Court will be discussed immediately by other honorable speakers. So I thank you for your attention and hope that the others will speak on the topics.
Thank you, Professor. I would like to take all the time with you. We have heard many interesting things, but I believe that we will still have a chance to hear even more interesting facts. Thank you for your interesting presentation. My apologies to our audience. We will have a coffee break, and breaks are a constitutional right, so please be patient. It will be a little bit later or delayed. Now I would like to invite the last speaker in this part of the conference, Professor Vytautas Sinkevičius. He is not here with us, but we have the recording of his presentation. I would like to briefly introduce Professor Vytautas Sinkevičius. He is also former Justice of the Constitutional Court, signatory to the Independence Act of Lithuania of the 11th of March 1990, and also member of the Commission of Drafting Other Documents, and also member of the Constitutional Draft, Professor of Mykolas Romeris University, Professor Emeritus and Honorary Professor of Mykolas Romeris University. He will speak about the establishment of the Constitutional Court and the beginning of its activity.
Ladies and gentlemen, when it comes to the establishment of the Constitutional Court, we must return to the beginning of 1993. It was a very interesting process from a legal and political point of view. On the 17th of February 1993, the Seimas held an extraordinary session, and one of the issues of the agenda was the appointment of justices of the Constitutional Court. 3 nominations were being considered, submitted only by the chairman of the Supreme Court, Mr. Mindaugas Lošys. He proposed that Stasys Stačiokas be appointed for 9 years, Juozas Žilys for 6 years, and Liudvikas Sabutis for 3 years in office. Other entities entitled to nominate candidates, that is the President of the Republic and the Speaker of the Seimas, have not submitted their nominations. The results of the secret ballot were announced as follows. 127 ballots were issued, 127 of them were returned. Liudvikas Sabutis received 52 votes in favor with 75 votes against. Stasys Stačiokas got 57 votes in favor with 70 votes against. Juozas Žilys received 125 votes in favor with 2 votes against. So only one justice, namely Juozas Žilys, was elected. Sabutis and Stačiokas were not appointed. No one doubted that they were highly qualified lawyers, but they were criticized for being politically very engaged, and many had doubts about them being independent and objective. Why was the chairman of the Supreme Council the only one to submit nominations, while the President of the Republic and the Speaker of the Seimas failed to do so? Well, let us remember that the 25th of October 1992 saw not only the referendum on the new constitution, but also the elections to the Seimas. They were overwhelmingly won by the left political forces, or the former communists, as deemed by the world all over. Their leader, Algirdas Brazauskas, was elected Speaker of the Seimas with Česlavas Juršėnas as his deputy. In accordance with the law on the procedure for the enforcement of the Constitution in Article 89 of the Constitution, until the President of the Republic is elected, the Speaker of the Seimas acts as an interim president or acting president, and the Deputy Speaker of the Seimas temporarily holds the office of the Speaker of the Seimas. So, Brazauskas started acting as President of the Republic, while Juršėnas as Speaker of the Seimas. There was a discussion as to whether, according to the Constitution, candidates for the position of Justices of the Constitutional Court could be nominated only by the true President of the Republic and the true Speaker of the Seimas, or whether this right was also reserved to the persons who temporarily hold these offices. The opinions of the lawyers were not unanimous. In order to avoid casting even the slightest doubt on the legitimacy of the appointment of justices of the Constitutional Court, Brazauskas, as the acting President of the Republic, and Juršėnas, as the acting Speaker of the Seimas, decided not to nominate their candidates. Or perhaps it was necessary not to rush to appoint justices and wait for the election of the true President of the Republic and the true Speaker of the Seimas, so that they could also submit their nominations? No, waiting was not an option. Brazauskas was elected President of the Republic on the 14th of February 1993, and according to the Constitution, the oath of the President of the Republic must be administered by the Chairman of the Constitutional Court, or in his absence by one of the Justices of the Constitutional Court. Thus, at least one Justice of the Constitutional Court had to be appointed before the inauguration of the President, which was due to take place on the 25th of February 1993. Otherwise, there would have been no person to administer the President's oath. Thus, the results of the secret ballot were announced, the Seimas approved the results of the vote, and it was necessary to adopt a resolution of the Seimas on the appointment of Juozas Žilys as a Justice of the Constitutional Court. Member of the Seimas, Mr. Julius Beinortas, noted that the draft resolution of the Seimas did not specify the time limit, that of 6 years, for which Juozas Žilys was appointed, and requested clarification of the draft resolution, asking what the position of the Chairman of the Supreme Court was. However, the chair of the Seimas sitting unexpectedly asked the Chairman of the Supreme Court quite a different question, that is, whether he leaves the same time limit for the justice's term in office or proposes another term. The Supreme Court's chairman's answer was astonishing. I quote, "I would ask the Seimas to adopt an additional resolution in this case and, instead of the recommended 6-year term, set a 9-year term for the Honorable Juozas Žilys." As if the recently held secret ballot of the Seimas to appoint Juozas Žilys for 6 years in office had no significance. As if it were possible to adopt an additional resolution of the Seimas by open ballot and to set a 9-year term instead of 6? Well, it got even better. The chair of the meeting says, "I will read the revised draft resolution of the Seimas that read, 'The Seimas of the Republic of Lithuania decides to appoint Juozas Žilys as a Justice of the Constitutional Court for 9 years in office.'" Well, it is clear to everyone who has at least a little knowledge of the law that the Seimas cannot adopt a resolution that does not correspond to the text voted for by secret ballot of the Seimas. And the Seimas, as mentioned above, did vote that Juozas Žilys was to be appointed for 6 years in office. The Chairman of the Supreme Court continued with the following. "In the event of a change in the situation, I would like the Seimas to reconsider the issue of the length of the term in office and take another decision. Whether it's through secret or an open ballot, it's up to you to decide." That was clearly an unconstitutional proposal. But that idea was soon caught by the chair of the Seimas sitting, who said the following: "We can cancel or annul the results of the secret ballot, and we can decide whether to vote by open or secret ballot on the length of the term in office." To which Kazimieras Antanavičius, an MP, replies, "Can we also cancel the results of the election of the President of the Republic?" Members of the Seimas, Petras Giniotas and Kazys Bobelis, also intervened with their arguments that the issue of the duration of the term of office of Juozas Žilys has already been resolved when the members of the Seimas voted by secret ballot for him to be appointed for 6 years, and that the Seimas cannot change the results of the vote, for it would be illegal and undemocratic. The chair of the Seimas sitting finally submits to the vote a draft resolution of the Seimas that Juozas Žilys be appointed as Justice of the Constitutional Court for the duration of 6 years in office. The resolution was adopted. On the 25th of February 1993, Juozas Žilys administered the oath of Brazauskas as the President of the Republic of Lithuania, and the Seimas elected Juršėnas as Speaker of the Seimas. Brazauskas, as President of the Republic, nominated Kęstutis Lapinskas, Vladas Pavilonis, and Stasys Šedbaras for the candidacies of justices of the Constitutional Court, while Juršėnas, as Speaker of the Seimas, nominated Algirdas Gailiūnas, Pranas Rasimavičius, and Zigmas Levickis. All of them were appointed as justices of the court on the 18th of March 1993. The 7 judges were appointed, and 2 more were still to be appointed because, as mentioned before, the 2 previous nominations submitted by the chairman of the Supreme Court had been rejected by the Seimas. The chairman of the Supreme Court presented to the Seimas the candidacy of Teodora Stoigaitienė, a justice of the Supreme Court, and again the candidacy of Stasys Stačiokas. There was a fuss in the chamber. Is it possible to nominate the same candidate which has just been rejected for a second time? Neither the Constitution nor the law in the Constitutional Court provides for such a prohibition. Therefore, from a legal point of view, repeated nomination of the same candidate is possible. How many times can the nomination be repeated, though? 2, 3, or even more times, maybe as many times as it takes until a person is appointed. There is no legal answer to this. It is a matter of self-esteem, political and legal culture of the Seimas. Irrespective of how it should be, in my opinion, it created a very bad precedent. It was, in fact, a different kind of nomination process. This time, Stačiokas was nominated for 3 years instead of 9 years in office, as it was put on the ballot the first time. The leftist majority of the Seimas, which did not withstand the criticism arguing that Stasys Stačiokas was not appointed for the first time solely for political reasons, gave way. On the 18th of March 1993, as many as 104 members of the Seimas voted in favor of him. Teodora Stoigaitienė's candidacy was also approved. This completed the process of appointment of all justices, so the date of the 18th of March 1993 is considered as the date of establishment of the Constitutional Court. All that remained was to appoint the chairman of the Constitutional Court. By the way, during the drafting of the Constitution, consideration was also given to the fact that the chairman of the Constitutional Court is elected by the justices of the Constitutional Court themselves, perhaps not entirely for a term of office as a justice, perhaps only for 3 years in office. Such a provision received criticism because it would have created the preconditions for the division of justices into groups, for internal disagreements of justices, making the chairman of the Constitutional Court dependent on the justices, otherwise he or she might not be elected. So the idea of that provision was abandoned. According to the Constitution, the chairman of the Constitutional Court is appointed from among the justices of this court by the Seimas on the recommendation of the President of the Republic. So, on the recommendation of Brazauskas, President of the Republic, the Seimas appointed Juozas Žilys as chairman of the Constitutional Court on the 23rd of March 1993. The resolution of the Seimas did not specify the duration of his tenure. This gave way to a constitutional tradition to appoint the chairman of the Constitutional Court for a period which coincides with his term of office as a justice of the Constitutional Court. The Constitutional Court needs its offices. Now, where and what kind of offices were found? During the drafting of the law on the Constitutional Court, consideration was also given to the fact that the seat of the Constitutional Court could be located not in Vilnius, but rather in Trakai or Klaipėda, believing that this would ensure greater independence of the court and that politicians would have fewer opportunities to interfere in its work. However, the rational approach prevailed. The permanent headquarters were to be located in Vilnius, with the hearings being held only at the court's permanent office. Whether it was because of the lack of understanding as to what the Constitutional Court was and what premises should be allocated to it, or perhaps of open representation of the interests of business and finance groups, some members of the Seimas began to talk about the fact that in the beginning it would be sufficient to allocate several rooms in the Ministry of Justice or another ministry for the Constitutional Court so it could start functioning. There were proposals to allocate the former House of Political Education, now the Library of Medicine, the buildings of the Ministry of Economy, or other buildings to the court, such as the building of the former Communist Youth Center Committee, which the perfume shop Christiana is currently operating, the building in which the Architectural Board of Vilnius City Municipality, now Merchants Club, was located at that time, the building near Lukiškė Square, where the Tax Inspectorate is currently operating. None of them were fitted for the Constitutional Court. The Seimas ultimately formed a special commission which proposed to allocate to the Constitutional Court the building in which the Lithuanian Academy of Sciences was located at that time. It's in Gediminas Avenue 3. Now the Research Council of Lithuania operates there. It was not the best option because it set the stage for a conflict with the Academy of Sciences and the scientific community, so this option was rejected. It was finally agreed with the then Prime Minister Adolfas Šleževičius that a building located at Gedimino Avenue 36, the current building, could be designated for the Constitutional Court. At that time, it belonged to the Ministry of Energy, with the Nuclear Power Safety Inspectorate operating in it. On the 22nd of April 1993, the Seimas adopted a resolution as a matter of absolute emergency on the designation of that building with all the inventor included for the Constitutional Court. The resolution of the Seimas has entered into force since its adoption. The issue seemed to have been resolved, but the resolution of the Seimas did not specify when exactly the Ministry of Energy was to transfer the building to the Constitutional Court. The Nuclear Power Safety Inspectorate did not wish to move, and so the building was transferred to the Constitutional Court only on the 1st of August 1993. On the next day, the Constitutional Court informed the public that as of the 2nd of August 1993, it officially accepted applications for the verification of compliance of the legal acts with the Constitution. The very first ruling of the Constitutional Court, which was on the 17th of September 1993, recognized that the Seimas resolution on the dissolution of the Vilnius City Council was unconstitutional, based on the admission procedure. At the time, the left-wing majority of the Seimas was shocked with the decision, while the right-wing applauded it. At the same time, both groups of politicians realized that their omnipotence had come to an end, and that the times when they were able to pass any law or decision without paying greater attention to the Constitution had passed. From then on, the legislation had to be much more carefully aligned with the Constitution and could not deviate from it. And if it deviated, the Constitutional Court would bring everything back in line with the Constitution. Now we can enjoy the fact that the Constitutional Court has been doing this successfully for more than 30 years, ensuring a reliable and authoritative protection of the Constitution. Congratulations to all of you on the upcoming day of the Constitution.
Ladies and gentlemen, we have completed the first part of the conference on the beginnings of the constitutional review in Lithuania. We heard the esteemed speakers, and now we will have a coffee break, and we will have 20 minutes for the coffee break, and at 11:20 we come back to continue.
Good afternoon once again, ladies and gentlemen. Let us continue with the second part of the conference. During the first part of the conference, we talked about the beginnings of constitutional review in Lithuania. And now we're going to speak about the constitutional review and a living constitution. This session features 4 keynote speakers, and they will be speaking about constitutional review, about a living constitution, and I do hope that those watching us online can both see and hear us. Myself and my colleague, professor at the Law School of Mykolas Romeris University, Milda Vainiūtė, are going to moderate this session. At the same time, Ms. Vainiūtė is the Seimas ombudsperson. Good afternoon once again, ladies and gentlemen. And let me introduce the second moderator, co-moderator of this session. And we have with us Professor Dr. Aurelijus Gutauskas, who is the Justice at the Constitutional Court of the Republic of Lithuania, and a professor at the law school. So I'm still looking forward to other people join us so that I could congratulate everyone on the 30th anniversary of the Constitutional Court. Thank you, Milda Vainiūtė. It is particularly encouraging that this conference is organized not only by the law school of Mykolas Romeris University, but also the Constitutional Court, the Seimas of the Republic of Lithuania and its Committee on Legal Affairs, as well as the Lithuanian Bar Association. Now, without further ado, I'd like to introduce the first speaker of this session. This will be Professor Dr. Egidijus Kūris, Judge of the European Court of Human Rights. He's a former president of the Constitutional Court of the Republic of Lithuania. Simultaneously, Professor Kūris is working at the Faculty of Law of Vilnius University. We are well aware of the contribution of Dr. Kūris in the development of the constitutional doctrine. Unfortunately, Mr. Kūris is not able to be here in person, but he is going to be with us remotely. He's going to read his presentation on the integrity of the Constitution and constitutional review. The floor is yours, Professor.
Ladies and gentlemen, organizers and participants of the conference, thank you for the invitation to speak at this conference dedicated to the 30th anniversary of the Constitutional Court. In my professional activity, the work of the Constitutional Court was an exceptional phase. It was a period of constitutional development. Without modesty, I can say that I recognize the terminology and wordings created during this period when reading the Court's acts today. It's true that by saying I recognize, I need to clarify. It's true that I recognize the words, but I do not recognize the meaning behind them. Sometimes I fail to recognize the research methodology. The continuity of the form is evident, and yet the content is not always so. I wish to have the minimum such experience, but it would be naive to expect none at all. And to achieve this, I hope that judges will be professional, independent, and from external influences have insufficient motivation to develop the constitutional doctrine as a critical work, and to remember that Lithuania's official constitutional doctrine is not only visible by today's couch commentators, but also by the international professional community, and grasps a particular meaning of their work. Late László Sólyom, former president of the Hungarian Constitutional Court and the president of the country, described the meaning of the activity of justices as follows: "We are professional idealists in the real world. All people are imperfect. Everyone makes mistakes that need to be repaired later. Therefore, the mission of the authors of the interpretation of the Constitution is mission impossible. Being imperfect in their own right, they have to develop official constitutional doctrine as an ideal intellectual product. But the ideal is unachievable by definition, so there can be no mistakes in this work. It is said that errare humanum est, but I will remind you that often we omit the continuation of that sententia, said perseverare diabolicum. In one of the opinions of the then President of the Supreme Court of Israel, Aaron Barak, wrote, I quote from the English translation, "When we sit at trial, we too stand trial." Today I will discuss one of the fundamental principles of the Constitution, its integrity. I say one of the fundamental, and I'm aware that I'm not being accurate, as all the principles of the Constitution are important and of equal power. We cannot compromise other principles for the sake of interpreting one. But we know that among the variety of principles of the Constitution, we have the so-called coordination principles, which not only guide ordinary lawmaking and the application of the law, but also determine the relationship between the provisions of the Constitution. They are but few: the supremacy of the Constitution, the rule of law, the integrity of the Constitution, which brings together all the provisions of the Constitution in a coherent set and requires it to be understood and interpreted in such a way that there is no internal contradictions or loopholes, even if such shortcomings exist in the text. Paragraph 1 of Article 6 of the Constitution provides that the Constitution shall be an integral and directly applicable act. It therefore lays down even two principles, and I will only deal with the integrity of the Constitution. If I'm not mistaken, integrity is given less focus in our constitutional legal literature than it deserves. The integrity of the Constitution does not mean that each provision of the Constitution has a direct link with each other, but sometimes, not entirely inadvertently, the real or perceived link between the two provisions is underlined without seeing the surrounding picture. For example, it is argued that the content of Article 38.1 of the Constitution, which refers to the family, is determined solely by paragraph 3 thereof, which refers to marriage. The other articles seem to be irrelevant, including Articles 22 and 29 and Article 38.2, let alone the preamble. We sometimes also inadvertently forget the integrity of the Constitution and call into question the existence of legales generalis and leges specialis. This leads to strange initiatives. For example, a decade ago, the idea was that in order to legitimize multiple citizenship as an option open to all, it is not necessary to amend Article 12 of the Constitution, but to supplement Article 32 with a provision to the effect that a citizen of the Republic of Lithuania who has acquired a citizenship of another country may not lose the existing nationality as against his or her will. And for instance, the recent interpretation that under the 2019 amendments to the Constitution, the Judicial Council also has the right to bring an individual constitutional appeal before the Constitutional Court. But these are private examples. But the most surprising was Vilnius Regional Administrative Court, with one justice delivering a judgment on the 23rd of July 2023, the operative part of which reads as follows: another resolution of the government of the Republic of Lithuania of the 22nd of June 2025. That order imposed a service penalty on one official. Its content is relevant here. The media reported that the official, now former official, had won in court against the government. It did not happen to hear that at least one member of the legal community would have commented publicly on that judgment. After all, the court relied on the Constitution, cited provisions such as public institutions serving the people or limited by the Constitution, and referred to the principles of the rule of law and responsible governance. However, it failed to take into account Article 105.1 of the Constitution, according to which the compatibility of the government resolution with the law is to be determined only by the Constitutional Court, nor Article 110 of the Constitution, according to which a court may not annul it if it has doubts to its compliance with the law, but must suspend the proceedings and refer the matter to the Constitutional Court. It has already been marked by Vilnius Regional Administrative Court, this anniversary of our Constitutional Court. The court annulled the Constitutional Court so far only ad hoc. The integrity of some provisions are cherry-picked from the Constitution, and the other ones are not being taken into account, and this is the mistake. If we ignore the integrity of the Constitution, its entire construction this is a fault. Constitution and its principles form a coherent system, or for example, another provision. Any provision of the Constitution cannot be interpreted in such a way as to distort or refute the content of any other constitutional provision. This would distort the substance of the constitutional regulation as a whole, undermine the balance between the constitutional values. But before giving examples of the separation of different provisions of the Constitution, I have to explain what the principle of constitutional unity means for the Constitution itself as a legal act and its structure. It is common knowledge, but it is absent from textbooks or distorted, to be more precise. It is stated that, I quote, "The text of the Constitution shall consist of first preamble, second the main part, sections 1 to 14, and 3 final regulations, and 4 constituent part. These parts do indeed form the text of the Constitution." The text of the Constitution, but the Constitution is a legal reality rather than a text. It is a law stipulated in the text, imperfectly though it may be. But this imperfection also poses a greatest challenge to the Constitutional Court and makes its work special, as you have to uncover a perfect law from an imperfect text. Saying that the text of the Constitution consists of those 4 parts means saying nothing about the Constitution as a law, as a document, but only as a text. Such a description of the structure of the Constitution as something mechanically consists of 4 parts gives little explanation. It explains the composite parts of the text of the Constitution rather than the law. The Constitution of the Republic of Lithuania has a very specific structure. It consists of 5 acts adopted at different times, with the exception of 2 adopted by the referendum of 1992. 5 number did not exist from the start. Initially, there was 1 act which was later declared an integral part of the Constitution. So we initially had only 1 fragment of the Constitution. It was followed by the adoption of a 2nd act of the Constitution, which also later became an integral part of the Constitution. They both coexisted with a provisional basic law, which was not referred to as the Constitution, but in fact it was one, but they were not part of it. Finally, an act entitled Constitution was adopted, which incorporated the 2 fragments without making any changes to the text. At the same time, the law on the procedure for the entry into force of the Constitution of the Republic of Lithuania was adopted. It was signed separately and was not considered an integral part of the Constitution for a long time. If the draft Constitution submitted to the referendum had not been drawn up with such urgency, the provisions of that law could have been incorporated into the Constitution per se. But what happened? It was only in 2003 that the Constitutional Court clarified that the law was also an integral part of the Constitution, which was done by the Parliament in Article 150 thereof. Failure to do so may have given rise to a number of difficult legal questions, including with regard to the Constitutional Court itself. I will mention only one. Had this law not been recognized as an integral part of the Constitution, albeit ex post, it would be difficult today to practice a popular impeachment procedure. It may be initiated against a member of the Parliament when a member of the Parliament breaks an oath. But the text of the oath of a member of the Parliament is not enshrined in the so-called fundamental part of the Constitution, which does not exist because there was a lack of time to think about everything those days. But in the law on the procedure for the entry into force of the Constitution of the Republic of Lithuania, if it was not an integral part of the Constitution, the breaking of the oath of the member of the Parliament would not be considered a serious breach of the Constitution. This could not have been done without a convenient opportunity. The newly adopted Constitutional Act on the membership of the Republic of Lithuania to the European Union. It had to be inserted in that article together. The Constitution is a set of these 5 articles. This is a convenient arrangement, as one of those acts is entitled Constitution. This offers a question that how come the Constitution is both part of itself and something bigger than this? This is perhaps also understandable to mathematicians engaged in the set of theory and familiar with Russell's paradox, but is not so clear to a random lawyer, let alone the participants of the annual constitutional exam. So let us ask how to classify such a constitution in the context of common typologies in legal science. My answer, which I have interpreted more broadly in a pair of publications, is as follows. As law, the Constitution of the Republic of Lithuania is the body of rules laid down in those 5 acts. It is a complex codified constitution. Codified because it consists of normative acts adopted by referendum or adopted by the Parliament. and is complex, since those acts are several and they are all equal, since the provisions of either of them must be understood in the light of the provisions of the remaining four. The Constitution is therefore a uniform act in the sense of the term act, not as a document, but as a normative order. Whatever this was what was precisely meant by the authors of the text, we will never be able to discover. But it is precisely the concept of a constitution as a uniform act that is enshrined in case law of the Constitutional Court, which is another constituent part of the Constitution. Without the Constitution, would not be a living constitution. In fact, in the ruling of the 30th of July 2020 on referendums, the resolutions of which I agree with, the court examined the structure of the Constitution, discovering, or rather inventing, the so-called extra-constitutional acts, and referred to them as primary sources of constitutional law. What is the Constitution itself? It follows that the other acts are secondary source. What a terminology! It makes you wonder. This is a separate topic which raises many uncomfortable questions, but lawyers, for a variety of reasons, raise them modestly. But as a commentator has rightly observed, it is difficult to understand the logical paradox of how an act can be constitutional, pre-constitutional, and supra-constitutional, extra-constitutional at the same time. That ruling, which was adopted on the same day as the ill-fated amendments to the rules of the Constitutional Court, then advertised as a new constitutional ban on giving lectures by judges, but withdrawn after a few months, is not among the best examples of constitutional development. At the time of delivering the ruling, the Constitutional Court, or rather someone in the court, drifted on a bend. I quote one of the honorable constitutionalists with whom I happened to work together for many years in the Constitutional Court. I have said that of the four historical acts referred to by the court, it would be possible to justify the inclusion of three historical acts in the constitutional system as a supreme legal order. To do this, we should not be trying to surprise the world, but rather be guided by a recognized methodology for the interpretation of law, such as that used by French Constitutional Council in 1971 when interpreting that the relevant part of the Constitution of 1958 was a previous 1946 preamble to the Constitution and the 1791 Declaration of Human and Civic Rights. We can also recall the case law of the U.S. Supreme Court, which considered the Declaration of the Independence as the source of the interpretation of the Constitution and the source of inspiration. Such or similar methodology would have allowed for the constitutionalization of three of those historical acts, but the fourth one not. I refer to the 1949 Declaration of the Union of Lithuanian Freedom Fighters, which was not known in 1992 because it was found only a few years later, during the adoption of the Constitution. One might ask, what is the relationship between the Act and its supra-constitutional with the first sentence of the Act of the 11th of March 1990? But I shall confine myself to matters relating to constitutional control. For example, do supra-constitutional acts regulate anything? If not, how can they have legal effects even higher than the Constitution itself? And if they do, what and how they regulate? Under what circumstances can they be applied, and how to determine whether the provisions of the Constitution itself derogate from their requirements? Who has the power to determine it? What is the procedure for such determination? No one has answered such questions so far, neither has explained why the resolution, which detailed records of the constitutional and supraconstitutional provisions, cannot be amended, and which amendments can only be made in a more difficult manner, did not contain any information as to whether the preamble of the Constitution could be amended. Apparently, the turn on which the driver drifted was so sudden that he failed to notice that something fell off the vehicle. This happens when you still want to drive very much, even though your driving license has expired. Since, as I said, errare humanum est, it is possible that the principle of constitutional integrity remains in the backward plan, but in any case, there have been few deviations over 30 years. The importance of this principle has been understood by the Constitutional Court from the outset. It understood its constitutional power to decide whether acts or parts of acts under this investigation are unconstitutional, as an obligation to determine whether they are in conflict with the Constitution as a whole rather than individual articles. Admittedly, applicants dispute the compatibility of the ordinary regulation only with certain articles or parts of articles of the Constitution. This is clear, since they are required to put forward arguments substantiating the unconstitutionality of that regulation and must therefore identify the specific provisions of the Constitution to which it is alleged to be contrary. However, if the court does not find any conflict, although the motivation part of the ruling stipulates that the court examine the compatibility of that regulation with only certain provisions of the Constitution, the resolution part states that the regulation is not unconstitutional in its entirety. If the court were to confine itself to establishing the compatibility with the individual constitutional provisions, the integrity of the Constitution would be broken. For example, if the Parliament unjustifiably restricts a human right, it will be in breach of the constitutional article that enshrines it, but probably not in conflict with the principle of the separation of powers. Of course, the court does not in fact examine the compatibility of the regulation under investigation with each provision of the Constitution in any case. It is presumed that having a set of arguments to support the compatibility of the contested regulation with one or more articles of the Constitution and without any mention of its relationship with others, it is established that there is a prima facie and no inconsistency with those articles, in particular if the applicant has not demonstrated it either. Therefore, the resolution part reads, not in conflict with the Constitution in its entirety. However, the court has departed from this principle as many as 3 times. Here I'm obliged to thank the esteemed Dr. Jolita Miliuvienė, who checked numerous rulings and found 2 which I had forgotten. I had only 1 in my memory. Its resolution reads that the provision under investigation is not contrary to the principle of equality of persons enshrined in the Constitution. This error arose from the copy-paste of the text from the motivation part into the resolution. The court has always considered this to be an error. Here I refer also to the rulings of the 10th of February 2000 and the 23rd of February of 2000. I find it difficult to explain how this happened. It took part in both cases. Perhaps that is why they were blocked in my memory. However, no further such errors were made by the court shortly. In its ruling of the 13th of June 2000, it clarified that it found that the contested regulation was contrary to articles of the Constitution or parts of articles of the Constitution which were not mentioned by the applicant. It had the power to make such a finding. This doctrine has been developed by emphasizing that the examination of the compatibility of an act with the articles of the Constitution to which the applicant refers is accompanied by an examination of its compatibility with the Constitution as uniform and coherent system. However, the court examined the constitutionality of the provisions of the law on the spelling of person's first name and last name in documents. According to those provisions, the names of citizens of non-Lithuanian nationality may be spelled in documents with letters Q, W, and X. The group of members of the Seimas requested an examination of the compatibility of several provisions of that law with Article 14 of the Constitution. To that extent, the request was accepted. However, it was also requested to examine the compatibility of those provisions with other articles of the Constitution, including Article 29, as well as the constitutionality of some of the provisions of the law. That part of the application was returned to the applicant by a decree of the President of the Court. One of the grounds for the return was that the applicant does not take into account the relevant provisions of the official constitutional doctrine cited in the decree, does not put forward legal arguments in support of doubts, does not provide legal substantiation of some of its assertion, and does not put forward any arguments in one of its claims. Therefore, the court examined only the compatibility of the contested provisions with Article 14 of the Constitution. The resolution of the 5th of July 2023 stated that the provisions under investigation were not in conflict with the Constitution in its entirety. That ruling of the Constitutional Court has received critical comments, but they were not professional. If someone analyzed it professionally, in legal sense, findings would be abandoned. For example, that according to the court, the Seimas, in deciding contrary to what the State Commission for the Lithuanian Language wrote in its conclusions, had nevertheless taken them into account. The word "has taken into account" is used here contrary to the meaning used in the presidential decree, by which the majority of the application was returned to the applicant. I do not, however, argue that the provisions under investigation could not be held to be compatible with Article 14 of the Constitution. This was justified by the Language Commission itself, which in its conclusions constantly moved from the area of linguistic competence to the area of legal competence. The ruling also makes some reference to this. The principle of the integrity of the Constitution requires that there should be no contradiction in the official constitutional doctrine. By contrast, the previous doctrine on the spelling is widely quoted, but ultimately is stunned 100% without any statement of reasons. Even the court has repeatedly held that the requirements to state reasons for the reinterpretation of doctrine, and even more so its correction, also applies to it. The court is committed to do so. No mention is made of the court's ruling of the 10th of May 2006 and of the 13th of November 2006. The constitutional doctrine of the civil nation treats the Lithuanian people as a state community formed on the basis of the Lithuanian people, in which the ethnicity of a citizen cannot determine his or her rights. The biggest issue is the following. As mentioned above, the court was asked to examine the compatibility of the legal provisions not only with Article 14 but also with Article 29 of the Constitution. To that extent, the application was returned to the applicant. By contrast, it must be determined whether the act is compatible with the Constitution as a whole. Thus, even if the applicant's request for an examination of the compatibility of the contested provisions with Article 29 of the Constitution was returned, its compatibility should still have been examined ex proprio motu. Article 14 of the Constitution is narrow in content. It enshrines the status of the Lithuanian language, nothing more. On the other hand, Article 29 is very broad. It enshrines equality in all areas, including regardless of ethnicity. Once the provisions in question have been declared compatible with the Constitution, we have the following. The name of a non-ethnic Lithuanian citizen can be spelled with letters Q, W, and X, which does not apply to ethnic Lithuanian citizens. What if, for example, ethnic Lithuanians would also be permitted to do so? It is hardly necessary to fear that the various institutions would be overwhelmed by families of Lauksminas, Maksimaitis, Paksas requesting to change their documents and to spell their surnames with X. I promise not to request that my name be spelled with Q, one of the students wrote in a funny journal. I mean that if, for example, Weberis, Wagneris, whose possibly German ancestors spelled their name with W, but who consider themselves to be ethnic Lithuanians, wish to do the same, they would have to declare officially in the register that they are not ethnic Lithuanians, that they belong to an ethnic majority. If, for example, a Lithuanian Polish Wojciechowski spelled with V would remember that his grandfather's surname was spelled with two double U's, he would be allowed to this spelling. And if his third-line cousin Vaicekauskas wished to do so, and Vaicekauskas considers himself to be ethnic Lithuanian, he would not be allowed to do so. That law does not only undermine the principle of the civic nation, but it forces Lithuanians who want to restore the non-Lithuanian spelling of their name renounce their Lithuanian identity. Is this equal treatment of citizens regardless of ethnicity? Is it a civic nation? I don't think so. However, the court ruled that those provisions are compatible with the Constitution in its entirety. There was a significant legal error, and it will need to be corrected. There is another case pending it, which not only the Seimas, but also the government's regulation divides Lithuanian citizens of non-Lithuanian ethnicity between those who lived east of Vievis and those who lived west to the Vievis in the pre-war period. I wonder whether the present case will be used as an opportunity to correct an error or whether it will remain in the limbo. Here's another example. Article 2 of the Constitutional Act on the Accession of the Republic of Lithuania to the European Union lays down a conflict of law rule which gives priority to the application of EU law in cases where its provisions arising from the treaties on which the EU is based are in competition with the legal regulation laid down in Lithuanian national legislation, irrespective of their legal effects, with the exception of the Constitution itself. This rule enshrines the algorithm of coexistence between the EU law and Lithuanian law, where priority of the application of EU law rather than primacy of one of the legal systems is relevant. In this general rule, there is an important reservation. A provision of EU law does not have priority if it is in competition with the rules laid down in the Constitution itself. But a few years ago, the Constitutional Court had changed this long-standing doctrine. In its decision of the 20th of December 2017, it stated that the EU law is the source of interpretation of Lithuanian law inter alia the Constitution in areas in which, pursuant to Article 1 of the Constitution, the Republic of Lithuania shares or entrusts to the European Union the competence of public authorities. So, there is no reason to interpret the provisions of the Constitution relating to the agriculture and the internal market differently from those governed by EU law. That judgment makes no reference to the conflict of law rule. Article 2 of the Constitutional Act is quoted with some essential omission. Moreover, EU law as a whole is referred to as European Union law, as if the Constitution is not obliged to see its internal hierarchy. There are no differences made between EU primary law, including the treaties on which the European Union is founded, and the secondary law directives and regulations whose conformity with EU primary law in themselves cannot be presumed a priori without reservation and which are constantly amended. However, shortly after that case, on the 6th of February 2020, the court, in its judgment of the 8th of April 2020, returned to the previous principle, turning that 2017 doctrinal anomaly into an aberration which is not to be followed. Was the publication of an elegant criticism by Professor Toma Birmontienė or any other help was made to correct that error? I think that we all make mistakes. We all err. And courts too. But sed perseverare diabolicum. I have taken too much time. I thank the organizers of the conference for their invitation. I thank the esteemed audience for their attention. I wish the Constitutional Court, which I hold dearly, every success. Honest, wise, and professional performance of its mission would be the greatest success. And I wish the entire constitutional community the very best of luck. Thank you.
Ačiū profesoriui už tikrai įdomų.
Thank you, Professor. A very interesting and comprehensive presentation indeed. Well, the speakers who are reading their presentations online have some certain advantage against those who have to speak here in the hall because we cannot stop them or interrupt them. Now, from the presentation by Professor, we heard that Mission Impossible is not relevant for the Constitutional Court. It has to be Mission Possible. He also mentioned that the Constitutional Court is aimed at formulating the official constitutional doctrine. The Constitutional Court ensures the viability of the Constitution, and it has to adapt to various legal changes and to overcome modern challenges that we face. And now, thank you for giving me the floor. And I have the honor of introducing to you a very famous researcher. Well, the global leader of scientific thought. We have Dr. Richard Albert with us. And Professor is going to speak about constitutional dismemberment in Constitutional Court. We have very brief information about this professor. We know that Professor is from the law school at the University of Texas. Now, to contribute to what has been written in the agenda, let me express my appreciation of the fact that yesterday, Mykolas Romeris University had an opportunity to hear a public lesson by Professor Dr. Richard Albert. And I'm looking at our director. Most probably there is a recording of that lecture. So hopefully you will be able to listen to that lecture. You will have that opportunity. Moreover, the website of our university have some more extensive information on this keynote speaker. But, well, let me note the fact of his spectacular scientific activities. Hopefully that the activities that have been listed is not exhausted. It's written that has written 25 articles. He studied in Yale, Oxford, and Harvard universities. Well, it doesn't mean to mention to anyone what those names mean to us. Moreover, I think that, well, he is also the director of constitutional studies in the University of Texas, of International Lawyers Society chair. He's also founder of the Forum for Constitutionalism for Future. So there's a lot of information available on the professor, and we are truly happy to have you here, and we are truly happy to listen to your presentation. The floor is yours.
Good afternoon, everyone. Congratulations on the anniversary of the Constitutional Court. We gather to celebrate the 30th. Next week, we'll be celebrating the 31st anniversary of the Constitution. I want to thank the organizers for including me in this marvelous program. Thank you. I want to thank the moderators for chairing the session. And I want to give a special thank you to two dear friends, Professor Dr. Justice Choma Bilmotiene and Dr. Yolita Miluviene. Thank you to the two of you for being so generous to me. The organizers of this conference have chosen a fitting topic to mark the 30th anniversary of the Constitutional Court. Constitutional review as an essential element of a democratic state. The Constitutional Court of Lithuania has indeed been essential to the project of consolidating democracy. The court has reinforced the democratic foundations and the democratic aspirations of the Constitution. A Constitution, as I mentioned a moment ago, will mark its 31st anniversary just next week. 31 years may seem like a short lifespan for a constitution, but already at 31 years old, the Lithuanian constitution has exceeded the average duration of all constitutions of the world, because the average lifespan of a constitution is 19 years. Like virtually all constitutions in the world, the Lithuanian constitution incorporates a technology within it that allows it to endure, a technology that makes it possible for the constitution to adapt to new challenges, to withstand shocks and crises, and to manage internal tensions. That technology, of course, is an advanced procedure for constitutional reform. This technology of constitutional reform makes it possible for the Constitution to live longer. Because when the Constitution is not performing as anticipated, or if the Constitution is lacking in some way, we can reform the Constitution instead of replacing it altogether, instead of starting all over again with a brand new Constitution. Now, constitutional reforms are not always done correctly. Sometimes they defy the requirements of the Constitution. And when this happens around the world, constitutional courts have often exercised the power to declare that that constitutional reform is unconstitutional. In my remarks today, I'd like to discuss several grounds upon which a constitutional court can invalidate a constitutional reform. And then after going through a number of grounds upon which a court can invalidate a reform, I want to ask a question that I think has a fascinating answer here in Lithuania. And that question is, can a constitutional court review the constitutionality of a new constitution? All around the world, supreme and constitutional courts have asserted the power to invalidate a constitutional reform. Just to give you a few examples, courts in India, in Colombia, in Brazil, in Belize, in the Czech Republic, have asserted and declared this power. And when these courts and other courts have determined that political actors have improperly tried to use the procedures of constitutional amendment in order to enact a constitutional dismemberment, these courts have declared those reforms to be unconstitutional. But what is a constitutional dismemberment? And how does it differ from a constitutional amendment? And moreover, why does this distinction between a constitutional amendment and a constitutional dismemberment, why does it matter for democracy, for constitutionalism, and for the rule of law? That is the ground that I hope to cover in the time I have remaining for these short remarks. There are two major kinds of reforms around the world that one can make to a constitution. First, a constitutional amendment, and second, a constitutional dismemberment. A constitutional amendment is a constitutional reform that keeps the Constitution consistent with its existing design, with its existing framework, with its existing presuppositions. A constitutional amendment, in other words, continues the Constitution-making project in line with the Constitution as it exists at that time. Think of a ship sailing at sea. A constitutional amendment makes adjustments to the ship, but it does not change the form of the ship, nor does it change the course of the ship. All things inherent about the ship remain largely the same, though with some non-intrusive modifications. Now, in contrast to a constitutional amendment, a constitutional dismemberment exceeds the boundaries of the existing Constitution. It makes a transformative change to the Constitution in terms of one or more of its fundamental constituent elements, like, for example, the identity of the Constitution, or the fundamental rights and freedoms of the Constitution, or the basic structure of the Constitution. That is a constitutional dismemberment. It's a transformative reform that seeks deliberately to disassemble the Constitution's elemental parts. It is a self-conscious attempt to reject the essential characteristics of the Constitution and to destroy the foundations of the Constitution. And so one can think of a constitutional dismemberment as the demolition of the basic structure of the Constitution, while at the same time rebuilding the Constitution on a new foundation that is rooted in principles contrary to the old. And so a constitutional dismemberment is a much more intrusive kind of constitutional reform than a constitutional amendment. And when courts around the world have determined that political actors have tried to enact a constitutional dismemberment using the procedures of constitutional amendment, that is when courts have declared a constitutional reform to be unconstitutional. And the reason why involves the scope of the reform. As I mentioned, a constitutional dismemberment is a transformative constitutional reform that extends far beyond the modest, incremental reforms that are typically associated with a constitutional amendment. And so as a result, a constitutional dismemberment requires a different kind of procedure to enact, a more deliberative procedure, a more democratic procedure, a more inclusive procedure in terms of its proposal, its approval, and its enactment. And so with this understanding of these two kinds of reforms, an amendment versus a dismemberment, we can understand why courts have exercised the power to invalidate a constitutional reform when political actors have used the wrong procedure to enact a reform, when they've sought to enact a dismemberment to the Constitution while using the procedures of amendment. That's one ground upon which a court can invalidate a constitutional reform, but there are several other grounds upon which a court can say that a reform to the Constitution is unconstitutional. Let me just identify 4 of them, in addition to the one I've just identified. When the Constitution contains an unamendable rule, it is usually enforced by a court. We've seen the Turkish Constitutional Court invalidate an amendment that has violated the Constitution's unamendable commitment to secularism. That's another example. When there is a procedural irregularity in the vote on a reform, the court can invalidate that reform for failing to satisfy the requirements specified in the Constitution. We've seen the Taiwan Constitutional Court invalidate a reform on that basis. In addition, when a constitution creates multiple procedures of constitutional reform, and where each procedure applies to a different part of the Constitution, the court can review the reform to ensure that the proper procedure has been used. And if the improper procedure has been used, the court can invalidate that reform. And we've seen this happen in the Constitutional Court of Ecuador. The last example I'll raise is when a country is a member of an international organization, and that international organization has a charter of rules. There is usually an adjudicatory body that's responsible for enforcing those rules. And when a country that is a member of this international organization violates this charter of international rules with a reform to its own domestic constitution, the international adjudicatory body can find that that reform is unconstitutional. Unconstitutional from the perspective of the International Charter of Rules. In other words, incompatible with the Charter. And we've seen examples of this in Nicaragua and in Togo. So these are just a few examples of how a court can exercise the power to invalidate a constitutional reform. So we've so far been discussing a conventional problem that many countries have confronted, including Lithuania. What happens when political actors use the power of constitutional reform improperly? Courts can step in and invalidate that reform. But now I want to close by asking a different but related question. Can a constitutional court go beyond the power of reviewing a reform and invalidating that reform? Can a constitutional court go beyond that power to review the constitutionality of a new constitution, raising the possibility that a new constitution could be unconstitutional? The answer is generally no. Because when it comes to creating a new constitution, the authority of a new constitution maker is vast and virtually unlimited. Now, however, there are some important exceptions to this general rule in modern constitutional history. And the most prominent exception comes from South Africa, as some of you may know. In 1994, South Africa had an interim constitution on its journey to becoming a democracy after the horrors of apartheid. And the country's 1994 interim constitution created a two-step process for the enactment of a new constitution. Step one, the Constitutional Assembly would write a new constitution that was required to respect 34 constitutional principles enumerated in the interim constitution. Step two, the Constitutional Court would review the draft constitution to certify that it complied with the list of these 34 constitutional principles. And so in 1996, the Constitutional Assembly prepared a draft constitution, sent it to the Constitutional Court for its evaluation, and the Constitutional Court declared the new constitution to be unconstitutional because it violated 9 of the principles that were codified in the 1994 Constitution. And so as a result, the Constitutional Assembly had to go back to the drawing board and try again. And indeed it did, by creating a second draft constitution, sending it again to the Constitutional Court, and at last, in December 1996, the Constitutional Court certified the constitutionality of South Africa's new constitution. Now, that's the South African example. Let's now come back home to Lithuania, because I think it is possible, it's possible, that the Constitutional Court of Lithuania could at some point in the future do the same thing, which is to say, to review the constitutionality of a new Lithuanian constitution, if ever it is proposed. And here's why. Here's why. In 2020, the Constitutional Court of Lithuania issued a groundbreaking ruling. The ruling on the compliance of the Republic of Lithuania's law on referendums. In that ruling, the court recognized that there are restrictions on the constitution-making power here in Lithuania. The court recognized that any new constitution would have to respect certain basic commitments. The court declared that the fundamental constitutional acts of the state of Lithuania are, quote, the primary sources of constitutional law, and accordingly, quote, may never be altered or repealed. May never be altered or repealed. Those acts include the Act of Independence, the resolution of the Constituent Assembly of 15 May 1920, the Act of the Supreme Council of the Republic of Lithuania of March 1990, and the Declaration of the Council of the Lithuanian Freedom Fight Movement, 1949. According to the Constitutional Court, each of these is a pre-constitutional constituent act that was, one, adopted by the supreme institutions that represented the people, and two, expressed the will of the people to restore the independent, democratic state of Lithuania. And so, according to the court, these documents are so deeply constitutive of the state of Lithuania that they may never be repealed, never be altered, must always endure forever as primary sources of Lithuanian constitutional law. And so, it is possible. It's possible if ever political actors choose here in Lithuania ever to replace the Constitution, no reason why you should, but if the choice is ever made in the future to do that, it appears that the court will have a role in reviewing the constitutionality of a new Lithuanian constitution. That would be an extraordinary exercise of judicial power, but it would not come as a surprise because the court has already told us that it has the power to do that. As I close now, as we gather to mark the 31st anniversary of the Constitution and the 30th anniversary of the Constitutional Court, it's appropriate, I think, to pause to admire the success of both. Constitutional endurance does not come easily. Constitutions, as you all know, have to withstand extreme conditions. They're tested all the time by social and cultural pressures. And in order for constitutions to perform at their best, they must be resilient in the face of local, national, and regional emergencies. And all of this is easier said than done. But through it all, the Constitution of Lithuania has endured for 31 years, and it has grown stronger as it has survived its many challenges. And so too has the court, the Constitutional Court of Lithuania, now celebrating 30 years. The court has proven itself, just as the title of this anniversary conference suggests. The court has proven itself to be an essential element in the infrastructure of democracy in the Republic of Lithuania. And so as I close, I wish a long life for the Constitutional Court. I wish a long life for the Constitution. And I look forward to gathering again with you to mark many more anniversaries as both the Constitution and the Constitutional Court continue to advance the values of democracy. And before I close, my final word is a greeting to the first semester law students here at the university, the future of the Constitution of Lithuania. Thank you to all.
Thank you very much for our speaker, for a very lively and interesting presentation. It is very inspiring for all of us. It was interesting to hear different experiences of other countries. And the speaker actually also mentioned all the relevant issues concerning the Constitution in Lithuania. Well, I agree with Milda. Professor made his presentation in a very modern style and speaking about the experience of different countries, but not stepping away from Lithuania and from the United States of America. So this is really very impressive. And this was presented through the rule of law and the protection of human rights standards. And this is really very impressive. Thank you very much, Professor, for your nice words vis-a-vis the court, the Constitutional Court and the Constitution of Lithuania. The Constitutional Court is engaged in justice, and this is the institution that has the constitutional supremacy, indivisible from constitutional, legal, and political system principles. And your observations are very important. Thank you very much once again, Professor. And now I would like to give the floor to another speaker. Professor Dr. Gediminas Sagatys, Chairman of the Association of Judges of the Republic of Lithuania, Judge of the Supreme Court of Lithuania, Partnership Professor of the Law School of Mykolas Romeris University. He will discuss the influence of the official constitutional doctrine on the jurisprudence of courts of general jurisdiction. The floor is yours.
Gerbiamas Seimo vicepirmininkas.
Deputy Speaker, Chairman of the Constitutional Court, former Justices of the Constitutional Court, dear colleagues, I would like to take this opportunity and congratulate as well the Constitutional Court on the upcoming 30th anniversary of its activities, and I wish him many more years to come. My topic, meanwhile, will focus on the influence of the official constitutional doctrine on the jurisprudence of general competence courts. However, I would like to say a few general remarks on the relation between the Constitutional Court and the courts of general competence. From the formal point of view, the relationship is quite clear. The Constitutional Court is one of the three judicial systems which is separate from an organizational and administrative point of view from the other two systems, those of the general competence court system and the system of specialized courts. On the other hand, all of the three systems have very important connections between them. Let me mention a few of them. First of all, each general competence court, as an applicant, has the power to initiate constitutional justice cases before the Constitutional Court. Secondly, all general competence courts are bound by the requirement for the rulings of the Constitutional Court on matters falling within its competence to be final and non-appealable, as enshrined in Article 107 of the Constitution. And thirdly, all general competence courts are bound by the official constitutional doctrine established in the jurisprudence of the Constitutional Court. This relationship, which at first glance may seem rather simple, is not so simple in practice. When it comes to the global context, Lithuania is no exception. The biggest challenge, though, is the overlap between the constitutional and general competence judicial functions. Scientific doctrine indicates that this difference, this overlap, is determined by the following factors. First of all, it's the emergence of more complex constitutional procedures. Now, everything was quite simple in the 1920s in the Kelsian model of abstract constitutional control, which was established in 1920. It was a very quite simple system back then. However, today, different states have established very different combinations of constitutional control models, the most extreme of which is the conversion of the Constitutional Court into the judicial institution of the fourth instance in a dispute. Now, another reason in this overlap is the technique of constitutional justice that has changed. There is a tendency for a constitutional court to no longer limit itself to a straightforward answer as to whether the contested provision of the legal act contradicts the Constitution or not. In the case law of the constitutional courts of today, an approach which is known in French as déclaration de conformité sous réserve tends to prevail. On the basis of that approach, the Constitutional Court tries to seek an interpretation of the contested norm of law in such a way that it is consistent with the constitution of the country, even if there are alternative interpretations of that norm, sometimes even more in line with the linguistic expression of that norm or the purpose intended by the legislature when adopting it. For example, in 2017, the Constitutional Court refused to recognize the incompatibility with the Constitution of the composition of the crime of unlawful enrichment established by the Criminal Code by interpreting the law in a different manner than it was interpreted in the application by the Supreme Court, contesting the retroactive validity of the Criminal Code. The Constitutional Court said that the law does not apply retrospectively, and that with this understanding of the contested and related legal regulation in mind only, there is no legal basis to claim that the legal regulation establishes the retroactive force of the Criminal Code, that it violates Article 31.4 of the Constitution, that is the constitutional principle of a state under the rule of law. Another thing that influences this overlap between the two judicial systems is the importance of the decisions of the Constitutional Court. This is related to a number of different reasons. First of all, it is the emergence of a phenomenon that could be described as the constitutionalization of law. Professor Nekrošius once said that the constitutional law until 2006 lived a rather quiet life. However, two rulings of 2006 introduced some more chaos in the peaceful life of the court. Another reason is the direct application of the Constitution in the general competence case law. To mention some of the recent rulings, the Supreme Court applies the official constitutional doctrine, that is, the rulings of the Constitutional Court regarding the expenses for retaining a lawyer. The Supreme Court applied the case law of the Constitutional Court when addressing the matter in a case of its own in this field. The years 2006 was a good example of the possibility to directly apply the Constitution. The Supreme Court stressed that the constitutional principle of equality of persons it justifies the need for equal protection of the rights of the children of both married and unmarried parents. In view of the absence of a rule of law directly establishing guarantees of the rights of the children of unmarried and unregistered parents with regards to the maintenance of the right to use a dwelling, Article 3.71 of the Civil Code, which lays down those safeguards for the protection of children's rights where the parents of a child are spouses, is applicable by analogy in accordance with the Constitution. Another reason to explain the gap, the overlap between the courts of general competence and the Constitutional Court is the constitutionalization of various branches of general competence law, which is determined not only by the development of national constitutional doctrine, but also by the practice formed by international human rights institutions. For instance, the Supreme Court this week opened a civil case in which a person is demanding anonymity in the online media outlet. This was related to a 10-year-old article describing the crime he committed, including a passage on his trial. In this case, the case law of the European Court of Human Rights in the judgment Herbain versus Belgium was applied. So the application of the official constitutional doctrine is not that simple. We have to talk about a model of cooperation between the different systems of the judiciary. In this case, the recommendations of the Venice Commission are very important. I would like to mention some of them. Some constitutional courts, according to one of the recommendations, having implemented the handling of individual constitutional complaints, face the problem of interference in the general courts. The possibility of reviewing judgments of the general competence courts can lead to tensions and even conflicts between the general competence courts and the constitutional court. It therefore seems necessary to avoid a solution which would provide for the constitutional court being treated as a Supreme Court. Its relationship with the so-called normal higher courts must be clearly defined. Second recommendation says that an explicit statutory or even constitutional provision making the interpretation of the Constitutional Court binding on all other state bodies, including the lower courts, is an important element in the clarity of the relationship between the Constitutional Court and the courts of general competence. Now let us come back to the situation in Lithuania. Over the 30 years of the existence of the Constitutional Court, The official constitutional doctrine has evolved, and today it would be difficult to find such institutions of general competence that were not affected by the activities of the Constitutional Court. In general, the official constitutional doctrine could be classified into the general one and the special one. The general competence is the one that is related to the administrative justice, for instance. Since today we're having a scientific event here, not only a jubilee event, I would like to focus on some of the challenges faced by the Constitutional Court as a justice of a court of a general competence. First issue is related to the official constitutional doctrine on precedents and their implementation. As we know, back in 2006 and 2007, the Constitutional Court introduced into the Lithuanian law the concept of precedent. When ruling on the relevant categories of cases, the courts of general competence are bound by their own precedents, that is, judgments in similar cases. When ruling on the relevant categories of cases, the courts of lower general competence are bound by decisions of the courts of higher general competence, that is, precedents in those kinds of cases. And secondly, the courts should follow the concept of the content of the relevant legal provisions, as well as of the application of these legal provisions as it was formed and which was used for the application of those provisions in previous cases. Finally, in implementing the rulings of the Constitutional Court, the courts should follow the interpretation of the rules of the law. Now, when many years have passed, we now can observe a certain problem. That is, in many cases, the official constitutional doctrine is mistreated or misused, especially when it comes to the documentation, the process documentation that is presented to the court. In other words, a paragraph of previous case law is simply incorporated into the submitted application, stating that this particular rule needs to be followed, without even providing a context for when that rule was once applied. All of this presents a problem, especially when it comes to submitting applications for appeals, because 2/3 of those applications actually divert from those precedents that are being referred to. In other words, no context is provided in those applications. So I believe it is high time we go back to the explanation of the content of a precedent. My vision of my own would be as follows. Today we have too general of an understanding of a precedent. Yes, on the one hand, it is a certain rule. However, it has to be provided with the context as well. It cannot be taken from the context. You cannot take a rule of law, however abstract it may be, and apply it in a different case, simply because the two cases might be quite similar. So the concept of precedent cannot be overgeneralized. And another issue concerns the official constitutional doctrine and the way it is being applied to the Constitutional Court and implementation of its decisions. The doctrine itself has been developed over many years, and Professor Norkūnas has quite rightly observed that there seems to be less dialogue between the different judicial systems. Out of the 16 applications to the Constitutional Court, only 2 of them came from the different courts of the country. Let's look into the reasons for that. Professor Norkūnas says that perhaps this can be related to the introduction of an individual constitutional complaint established in 2019, which provided the possibility to present applications to the Constitutional Court on an individual basis. And perhaps this could be one of the reasons, although I believe it is not the most dominant one. Another reason that one could think of is the fact that the courts now have the right to lodge an application to, let's say, the European Court of Human Rights. Although the reason for addressing an international court are related to the violation of international norms, however, the issues related to the compatibility of the legal norms with the Constitution may also be included in those international applications. Another objective reason is time. A justice of the courts of general competence realizes that time is of the essence for ordinary people. And we have to bear in mind that the time for filing an application to the court and the time for hearing the case are included in the total amount of time dedicated to the hearing of the case at a constitutional court, which is why the justices at the courts of general competence opts for applying the official constitutional jurisprudence himself without addressing to the Constitutional Court. On the other hand, in the case Reinau versus Lithuania, the European Court of Human Rights stated, among other arguments, that there was a breach of Article 8 of the Convention on Human Rights. The court noted that the Lithuanian courts have properly assessed the accusations by Inga Rinau, and they were simply to order the return of the child in the case. However, by postponing the return of the child, they risked the welfare of the child. The fact that the Supreme Court asked the special institutions to hear the case as a matter of urgency, and the latter applied an expedited procedure, does not release the defendant, that is the state, from liability. And finally, the technique for applying the official constitutional doctrine has also changed. Professor Sprogis quite recently has eloquently explained his judicial philosophy, and I quote, "My judicial philosophy has recently changed because of the need for an active referral to the Constitutional Court. I essentially of the view that the meaning of a legal act can be revealed through a correct interpretation, that is, by interpreting a legal act in a manner consistent with the Constitution. Certainly, this method does not always help me and cannot always help me." So my final remark concerns the changed technique in applying the official constitutional doctrine. Well, this phenomenon merits a SWOT analysis. So, without going too deep into the analysis, I would like to focus on the strengths of the changes in the official constitutional jurisprudence. Certainly, we should talk about the respect for the legislative entity, then the stability of the legal acts. So these are some of the strengths that we should mention. What are the weaknesses? Well, some of them can already be seen. That is a decreasing number in the applications to the Constitutional Court. An opportunity would be the questioning of the quality of norms. Which is granted by the Constitution to the Constitutional Court. And finally, flexibility is another opportunity that could be singled out. As for the threats, I would identify a few of them. Interpretations of the courts of general competence may not conform to the system and principles of the relevant branch of the law of general competence, but it will be binding on the general and administrative courts. This might be considered to be a risk. And finally, will the methodology applied be consistent with the practice of the Constitutional Court, and will stability be ensured? That is will the same principle be applied as regards the analysis of compatibility of the legal act with the Constitution? Now, before I finish, I would have to say that for the proper functioning of the judicial power in the state, it is necessary to ensure a stable and productive relationship between the individual systems of the judiciary, that is, the Constitutional Court on the one hand and the general competence and administrative courts on the other. The official constitutional doctrine has undeniably contributed a lot to the case law of general competence courts, and the overall level of interinstitutional cooperation should be considered as appropriate. Thank you.
Thank you for an interesting presentation. You presented the parameters of the depth and width of the constitutional doctrine of the court, and also some guideline on the case of law. Thank you very much for this. Now our next speaker. Thank you, Professor, for being ready to present your speech. We don't have to give a special presentation to Professor Dr. Birmontienė. She was the moderator of the first part of the conference, and now she's the speaker. She will speak on challenges to constitutional review and its prospects. Ladies and gentlemen, I'm in a very difficult situation because we should be having lunch now, and actually we should be having dessert now. By choosing this topic, I'm balancing between two necessities, and I would try to present my topic as certain ideas. This is not a presentation per se, but rather the presentation of my ideas. Well, the challenges is clear. We're speaking about the problems, and Gediminas, my colleague, illustrated well the problems faced by the Constitutional Court and courts in general. But speaking about perspectives, we have to be magicians. We cannot foresee the future. But the issues or challenges we're addressing today show certain visions of the future. So I would try to briefly present my ideas on that. So my first idea is that constitutional court and time. What is the relation between time and constitutional court? We say young constitutional court, old constitutional court in place for many years. We have a colleague from a country which has its constitutional review in place for centuries, or for more than a century, for example, in Austria. But even the Supreme Court of the United States, that has so much experience, is still being criticized, especially its recent decisions that actually are destroying the case law and proceeding law. On the other hand, if we look at the decision of 1803, Marbury versus Madison, this is a classical example. And when we compare those different decisions, it is difficult to give a clear conclusion. So, to my mind, time and constitutional review are not connected directly. It doesn't matter how old the Constitutional Court is, that old age or old standing does not guarantee quality. For example, if the Constitutional Court has formulated the doctrine, it might seem that its work would be easier. But every case is seen as a challenge. If that was so simple, we could use different doctrines, legal regulation. In that case, we should ask the help of artificial intelligence, which would find the legal regulation, would apply the doctrine. And in this case, we would think that the age of constitutional review is relative. And we might wonder, maybe in future, we will not need this constitutional court. But still, I think that artificial intelligence will not replace any of the courts. Even though artificial intelligence is attempting to writing our letters, treating us, writing our love letters, but can artificial intelligence love for us? So I believe certain ideas coming from the ancient times and the professions of a teacher or justice or judge will not be replaced by artificial intelligence. We see certain challenges in terms of time and constitutional court, and artificial intelligence is very challenging here, but I believe that artificial intelligence will not replace the court. Another aspect is development of constitutional review and democracy. And in this area, we face a certain paradox. We cannot equate between the development of constitutional review and democracy, especially in the 20th century. The last decades of the 20th century, with different processes in Europe, we might think that democracy is constitution and constitutional court. The Venice Commission has explained that. And we might think that Constitution guarantees democracy. I'm actually against the metaphysical attitude towards the Constitution. Unfortunately, in the 21st century, constitutional courts might be exploited by totalitarian regimes that use the constitutional review and constitutional courts to disguise undemocratical changes in their regimes. For example, in Belarus, in Russia, in Georgia, we know the developments in this country and in others. Constitutional review mechanism and the constitutional review has to be related to the democratic foundations of the society itself and democratical culture of the society. And any artificial understanding of a constitution, a constitutional review does not guarantee democracy. Speaking about constitutional court and independence, this is a very important topic. We should not be talking about this in the 21st century, but we see what is happening around the world. And we were also preoccupied with the Constitutional Court some time ago because some justices did not know what positions they had taken. And we had some uncertainties concerning the term of office of the justices of the Constitutional Court. The example of Poland is a classical one. Since 2015, we can see the developments in Poland and the abuse of the Constitutional Court by the politicians. Our colleague Marek Zubik will be speaking about that. So we can see here that politicians find ways how to make the Constitutional Court working to its needs. We should not be idealistic only. For example, if we have the chamber of the Constitutional Court, we should not think that these people will take necessary decisions. The independence of the Constitutional Court can be influenced by various factors, including the composition of the court. For example, Poland is an excellent example here. We had parliamentary elections in Poland, and let us hope that the situation will change. But what will happen to the Constitutional Court? Should it be demolished? Should it be deconstructed? What should we do with the rule of law and some constitutional imperatives? Should we have the Constitutional Court that has taken the decisions that people have to live with for some time? I have in mind decisions concerning the European Union Court of Justice. When we see undemocratic changes, we understand that correction will be much more difficult. And what should we do with such a court, for example? Now, speaking about Constitutional Court and its competitors, my colleague Gediminas Sakatys helped to discuss this topic too, because the Constitutional Court competes with the European courts, with courts of general jurisdiction, with the Court of Justice of the European Union. Gediminas gave a very good example that he could have referred to either of the courts. The Constitutional Court has to realize that the EU courts have acquired wider competences. And in some areas, we would believe that, well, this is the competence of a nation state, but the European courts also deal with these issues now. We should also remember that the Court of Justice of the European Union also safeguards the Charter of Fundamental Rights of the European Union. Speaking about this competition between the Constitutional Court and the Supreme Court, Professor Kouris spoke about this. In 2017, the Constitutional Court ruled that the EU law was the source of the interpretation of the Lithuanian constitution. So this would mean that we don't need Lithuanian courts or the Constitutional Court in Lithuania. Finally, I want to point out that constitutional courts should not be taken for granted. And it is important that the Constitutional Court itself, when it takes decisions and formulates a certain doctrine, and when it builds its relations with other courts, it should realize that the decisions of the Constitutional Court also compete with the decisions of other courts as well. Speaking about constitutional review and the pandemic or the state of emergency has brought many issues. The decision of the French Constitutional Court was very important here when deciding on the COVID passes, where some people were given the rights, others were not. Why I'm speaking about the French Constitutional Court or the French Constitutional Council? We know that the French Constitutional Council has a right of preliminary ruling. And the pandemic has shown that the preliminary constitutional review is equally important. The Constitutional Court and its rulings were very lengthy in terms of the pandemic and the state of emergency, and the rulings were finally achieved and reached years later. And in 2021, the French Constitutional Council managed to deliver the ruling on preliminary constitutional review. Maybe we should think about the future and possible future states of emergency, possible wars or terrorist attacks. And maybe we should think about the possibilities of preliminary constitutional review and this role given to our Constitutional Court. Another aspect I wanted to focus on is that the powers of the government are becoming even stronger. If we look at the rulings of our Constitutional Court, it seems that the government has a much bigger power than the parliament in, for example, limiting or restricting the rights of people's rights and human rights in terms of emergencies or pandemics. This might be causing some concern, or this might also become a future tendency, especially that we are living in these complicated times. This might mean that we will have to trust the government even more and allow the government to take decisions that it could not have taken before the pandemic. And my last point is the relation between the Constitutional Court and international law. And I see a great gap here. On the one hand, if we look at the case law of constitutional courts, we can quote and quote them. The wordings are very beautiful and there are numerous quotations. But in the 21st century, we see the war being waged in Ukraine and in another part of the world, as well as the threats of terrorism. The United Nations mechanism established in the 20th centuries as the aftermath of those two wars, and the regulation of the United Nations is based on the implications of the 20th century world wars. And now the situation has changed. And there's no mechanism in the international law to stop the aggressors. And then we question whether the value of international law, well, it was important in the case of the protection of human rights in Europe. But maybe today, when we see the crisis within the international law, I believe that the constitutional courts should take a greater responsibility here. And change the attitude of regarding the international law to be supreme in all the cases. Constitutional courts in future, I believe, will have to take certain responsibility and a greater burden. Possible challenges for the Constitutional Court. We have the Ukrainian Constitutional Court, and we see the situation which is difficult to imagine. How can the Constitution and the Constitutional Court protect human rights and the Constitution in times of war? In this situation which forces us to think about the new attitude. We need a breakthrough here. We need a change in doctrine here. We're speaking about war, not the pandemic here. And all the principles and the doctrine is that the Constitutional Court is operating in the times and in the situation of war. We have colleagues from Ukraine who will speak about this in more detail. But I just wanted to point out that the Constitutional Court faces many possibilities of development. The court can become strong, or it might appear to be weak. And the protection of the Constitution in the 21st century against the backdrop of our today's development form a huge challenge. And I hope that our Constitutional Court does not face those difficulties that we now see in the world, and that we will be able to find the way out of any difficult situations. Thank you.
Profesoriai, tikrai už įdomias ir vertingas įžvalgas dėl.
Thank you, Professor, for very meaningful insight. And I would like to express my gratitude to all the keynote speakers of the session for their valuable presentations, making use, taking advantage of the rights of the moderator, and would like to illustrate the conclusion of this part by the words of President of the Constitutional Court, Mr. Goda, who said that the Constitutional Court defends the democratic order, supports the stability of democratic values, and prevents the abuse of the constitutional values. I thank everyone. Our lunch break is until 2 p.m. and so we are starting our work back. We resume work.
Good afternoon. Let us continue our conference. Well, presentations are interesting and they become lengthy, and our agenda is being delayed. Now we open part 3 of the conference, where we discuss the protection of human rights and freedoms. This is one of the most important issues of Constitution and the case law of the Constitutional Court. I co-chair this part of the conference together with Professor Algis Norkūnas. Good afternoon. We have heard a number of interesting presentations about the past of this esteemed institution. which marks its anniversary, and also about the activities and challenges of the institution. And now we will move to some more narrow issues. Institutional and composition issues are significant in general, whereas human rights in today's world have become extremely important personally to everyone, independently of the place you live in. We moderate this part of the conference together with Professor Dr. Edita Žiobienė, who is Children's Rights Ombudsperson in Lithuania. And we have an hour of presentations and discussions. We heard many issues that we agree or disagree with, and we hope to continue this challenging atmosphere. The weather is really bad outside, therefore there's no need to rush, so we can really take our time and enjoy this conference. Well, actually, bad weather guarantees good discussion. When we speak about human rights, it is my honor to introduce the next speaker, Professor Dr. Danutė Jočienė, former Justice of the Constitutional Court and Professor of the Law School of Mykolas Romeris University.
Thank you. Well, I am very pleased to be here in this hall, although it has emptied somehow. Hopefully, there are many more people listening to us online. But still, I'm very happy to talk about the activities of the Constitutional Court. Well, of course, my presentation contains 14 pages, and I guess this will be enough for 1 hour. Luckily, I'm not going to read the presentation, and I'll only focus on a few aspects which are, to my opinion, very important, and later I'll invite you to a discussion. Like very few speakers, I'm not going to criticize the Constitutional Court or its justices. Today, we are celebrating the anniversary because I still have the Constitutional Court in my heart, and I congratulate it on the occasion of its 30th anniversary. And I hope that the court will continue carrying out with dignity, pride, and responsibility the highly responsible Constitution mission. I do wish every success to the representatives of the Constitutional Court who are going to implement this mission. Let me draw your attention to a very important thing that was stressed by Professor Jarašiūnas. Lithuania is part of the so-called fourth wave of constitutionalism in the world at the end of the 20th century, which, according to Professor Jarašiūnas, pays great attention to the protection of human rights and democratic institutions. Now, it is also important to mention that for the constitutional protection of human rights in Lithuania, the Constitution of the Republic of Lithuania, adopted on the 25th of October 1992, established for the first time in the history of Lithuania the Constitutional Court as the institution of constitutional review. The court was tasked with ensuring the principle of the supremacy of the Constitution and implementing constitutional review, and at the same time ensuring the protection of human rights, which, according to Professor Jarašiūnas, can only be implemented with the proper functioning of state authorities. In its ruling of 19th of December 1996, the Constitutional Court stressed that only real implementation of the principle of the separation of powers can effectively strengthen human rights guarantees. It is therefore the purpose of the official constitutional doctrine to ensure these guarantees in practice. The case law of the Constitutional Court has also pointed out that the protection of individual rights and freedoms is one of the essential features of the rule of law. Professor Toma Birmontienė states that the Constitution of the 25th of October 1992 reflects not only Lithuania's historical constitutional traditions, but also the experience of global human rights protection, which is enshrined in international instruments. I'll speak about that more. This reflection is particularly pronounced in all 3 decade-long activities of the Constitutional Court, when international law has quite clearly influenced the development of the official constitutional doctrine of the Constitutional Court. I'll mention a few rulings. The first ruling adopted on the protection of and limitation of property rights. That's the ruling of the 13th of February 1996 and of the 6th of May 1997, as well as the conclusions of the 25th of January 1995 on the conformity of the European Convention on Human Rights with the Constitution. In the conclusions, the Constitutional Court focused, among other things, on revealing the nature of inherent human rights, examining important aspects of the protection of human rights, and it stressed that the human rights are innate, and this right was enshrined in one of the articles of the Constitutional Court. Moreover, the Constitutional Court has also focused a lot on the prohibition of discrimination and other principles that contributed greatly to the such as the principles of equality of persons and the prohibition of discrimination, which contributed significantly to the doctrine of the Constitution subsequently formed by the Constitutional Court as an anti-majoritarian act protecting every individual. But it should also be mentioned that there are some of the things that have not been mentioned in the Constitution, and these related to discrimination on the grounds of gender identity, sexual orientation. It should also be noted that the Constitution is interpreted as a living constitution, as a living instrument. And this has been, well, borrowed from the European Court of Human Rights, and it uses the word living instrument, using the dynamic principle of interpretation of the provisions of the Convention, which means that one should take account of the real situation and look into the various violations. Therefore, I believe that the Constitutional Court has developed very vividly the doctrine of the Constitution as a living instrument. For example, the perception of the Constitution as a living mechanism has enabled the Constitutional Court to issue rulings of such great importance as perhaps one of the most fundamental rulings on the abolition of the death penalty provided for in Article 105 of the Criminal Code. This ruling was adopted on the 9th of December 1998. This ruling refers to all possible sources of international law in this field, and the I would also like to mention the resolution of the Constitutional Court on the concept of the state-family policy that was adopted on the 28th of September 2011. This concept expands the concept of the family. I should also mention the resolution of the Constitutional Court on the temporary residence permit in Lithuania to foreigners on the basis of family reunification, taking into account the international obligations to Lithuania under the Convention for the Protection of Human Rights and Fundamental Freedoms and European laws. The aforementioned decision stressed that such a permit must also be issued to persons of the same sex without discrimination where they entered into a cross-border marriage in order to guarantee the principle of free movement of persons applicable to them under the EU law. Let me also mention the ruling of the 7th of September 2021 on the granting of a time limit for religious associations to apply for their recognition, which highlighted, among other things, the importance of religious freedom and religious pluralism in a democratic state, and which focused a lot on the case law of the European Court of Human Rights. In this hall, we have Linute Bieliūnienė, who does not participate in the Seimas Commission on behalf of the Constitutional Court. It is particularly important that, according to the Constitution and the official doctrine of the Constitutional Court interpreting it, the recognition and respect for human rights and freedoms are among the unquestionable values, together with, and most importantly, the sovereignty of the nation, democracy, states' independence, Lithuania's geopolitical orientation, respect for the rule of law, the obligation of government institutions to serve people, and their accountability to society. For example, in its ruling of the 11th of July 2014, the Constitutional Court emphasized that the Act of Independence of the 16th of February 1918 established a modern state of Lithuania as a subject, as an entity of international law. This ruling, it also established the irreplaceable fundamental principles of Lithuania's constitutional order, which include independence and democracy, from which the inherent nature of human rights and freedoms is inseparable. These are such constitutional values that form the foundation of the Constitution as a social contract and the common life of the nation is based on. The state of Lithuania. Nothing can call into question the provisions of the Constitution which enshrine these fundamental constitutional values, as this would amount to negating the very essence of the Constitution. Therefore, amendments to the Constitution that destroy the inherent nature of human rights and freedoms of democracy, of state independence, cannot be adopted. That was the ruling of the 30th of July 2020. I'll move on to the third aspect, and I am going to speak about the constitutional right of people. I will distinguish 8 aspects. I would like to introduce them. I'm not going to go into detail. First and foremost, in the Constitution, we have a legal system which means that all the provisions are interrelated and therefore they have to be interpreted inseparably. Therefore, it should be notioned that the Chapter 2, called The Human Being of the State of the Constitution, follows the basic chapter, The State of Lithuania of the Constitution, and begins with a fundamental human rights perspective. Chapter 4 of the Constitution also speaks about economic activities, and one might argue whether this should be understood as the human right. I would also like to draw your attention to one of the rulings of the Constitutional Court which based its decision on the constitutional doctrine for the restriction of the human rights, especially when it comes to the pandemic. The legality and proportionality of restricting the exercise of human rights and fundamental freedoms has been particularly debated both at the constitutional level. The Constitutional Court has stressed that making use of one human right cannot negate the human's right to another right. When talking about the classification of human rights, Article 18 is very important because it enshrines the inherent nature of human rights, and to my opinion, this article should be interpreted with the Article 29 of the Constitution relating to non-discrimination provisions. The constitutional rights are related not only to political and civic rights, but we also have economic, social, and other rights. When it comes to social rights, such as the right to choose employment, to have unsafe and healthy conditions, it should be noted that in the Constitutional Court has developed a solid official constitutional doctrine throughout its 3 decades of operation, and one of such examples could be the ruling related to the maximum amount of maternity allowance. The Constitutional Court found that the so-called ceiling set by the legislature for calculating the maternity allowance infringe Article 39 of the Constitution, which establishes that a guarantee for paid leave for working mothers before and after childbirth. So I guess I'm not going to get deeper, and now I'll move on to general principles and of human rights, and one of such principles is the innate nature of human rights. And the resolution of the year 1998 on the abolition of death penalty can be deemed as the foundation for the development of the protection of human dignity, because in this case, the court ruled that it is one of the important human rights. Most probably, some of the things have been borrowed from the German documents, from the German Constitution. Now, I believe that the innate nature of human rights is one of the human rights that cannot be negated. Therefore, it cannot be replaced when, let's say, in the form of certain amendments. And we were very happy to hear the speech by our American colleague on constitutional dismemberment. I would like to stress that we have the principle of harmonious or friendly interpretation of the Constitution to international law, as the same was mentioned by Birmontienė. And the official constitutional doctrine of the lawful restriction of the exercise of human rights is yet another principle. We also have some other principles, and I do disagree with Birmontienė and with the criticism she expressed with respect to the reality of the international law and with regard to the standards. But in the reply, we'd like to say that we have to base our work on the standards that have been developed, and we have to try to implement those standards irrespective of the political environment and challenges. But in the context of political challenges, we have to raise another question. What would we do if there were no international standards? Well, today I heard that Russia was angry because about the arrest orders for those who were investigating war crimes in Ukraine. So if not for the international standards that are in place, we would not be able to talk about the rule of law and the human rights. Well, still, this international law, to my understanding, should remain the foundation for the constitutional doctrine in the field of human rights. When it comes to the EU law, I have my own vision. I disagree neither with Professor Birmontienė nor Professor Kūris, because I believe that I believe in the principle of supremacy. I have participated in many conferences, both at national and European level. So if we told European lawyers that we have a collision rule, they would not understand this. But again, this is a separate topic. I believe that the Constitutional Court should go further in developing the human rights doctrine, and the EU law should be applied directly, and the standard should be transferred into the Lithuanian law. Now, when it comes to the system of constitutional human rights and fundamental freedoms, let me refer to the things that has already been mentioned. On the restriction of human rights, the Constitutional Court has not established anything new, because we are following the case law of the EU law. We adopted the classical method, and first of all, we raise a question whether such interference was legal, and if the interference, whether such interference was provided for in the laws, and whether such interference was necessary for the democratic society. And we also have to answer whether it was such interference was proportional to achieve the objective. We have the doctrine in the conditions of the economic crisis, and the Constitutional Court developed its own special doctrine with regard to the restriction of human rights in times of crisis. But because of the pandemic, during the pandemic, there were quite ardent questions whether we are going to base our restrictions on the classical models, or whether we are going to formulate our own special constitutional doctrine, just like we did in the cases of economic crisis. Majority of international bodies and courts adopted the classical approach. They believed that such restrictions and the rules for restrictions were sufficient. So Lithuania also did the same. For example, when people were not if people did not have COVID passes, were not suspended from work, and so on and so forth. I'll finish at that. I know that I've already used more of my time, but still, you are well aware that human rights will never be implemented if we do not have a real life to access courts. We did hear the problems courts face if they want to refer the case to the Constitutional Court. So the Constitutional Court has developed a very good doctrine on the protection of individual rights, and there are quite a lot of rulings on that case, and there are two rulings that are very important. One of them is of the 1st of March 2019, and another ruling, one of the recent rulings that was adopted on the 30th of December 2022 on the cassation, where the Constitutional Court adopted an opposite decision when adjudicating the disputes. And in this case, the Constitutional Court took account of the purpose of the cassation institution, stressed that the lawyers' requirements are not against the Constitution. So I'll stop at that. Okay, the last aspect that I wanted to mention. Most probably everyone would agree that the individual complaint to the Constitutional Court that was launched back in 2019 had a very important impetus for the protection of human rights. Let me note that previously there were approximately 6 to 8% of individual complaints, which is in line to the international practice. But I hope that both lawyers and persons who refer their individual complaints to Constitutional Court looked more carefully at how they have to do, because as far as I know, 60% of their complaints are rejected. So I hope that people will refer to the Constitutional Court more often, but I would also encourage them that their applications, their complaints should be more legally justified. So we have to ensure our utmost not to undermine the authority of judicial institutions. So it seems that I've finished my presentation at page 5. So congratulations once again. Congratulations to the Constitutional Court. I hope that the Constitutional Court will continue the mission, and I hope that the Constitutional Court will not pay attention to unjustified criticism and pay attention to justified criticism, because they will have at least several arguments to make up for the mistakes. Thank you.
Ačiū gerbiamą profesorę už jūsų įžvalgas.
Thank you, Professor, for your insights and the issues that you've raised. This proves that we live in a democratic country, and scientists' opinions may differ. I don't know whether we will have time for a discussion or we will have a separate conference for discussions. Now I would like to give the floor to a representative from a neighboring country, Latvia. that we have very close and long cooperation ties. Therefore, I would like to give the floor to Professor Dr. Sanita Osipova, Professor of the Faculty of Law of the University of Latvia, and she is former President of the Constitutional Court of the Republic of Latvia. The Court of Latvia, the Constitutional Court of Latvia also has the experience of 30 years, and it should be noted that the individual complaint has been existing much longer in this country compared to Lithuania. So this was the example that we not only cooperate but also have the possibility to learn from. Now our speaker will speak about human dignity in Latvia.
Pleasure to be here, and special thanks for organizer, especially Professor Birmontiene. I would like to speak today about human dignity. Human dignity has been the central concept, the main reason, the foundation for the establishment of a democratic state governed by the rule of law in Western civilization since the late 18th century, with constitution, separation of powers, constitutional court, but most importantly, respect for and guarantee of the fundamental rights of every human being. Human dignity has been discussed in writing by theologians, secular thinkers, politicians. However, they view concept from various perspectives, and its content is not unified. It appears to be blurred. With lawyers, it is different. This concept must be clearly applied by lawyers because it is stated in the constitutions and international human rights agreements. Legally, the protection of human dignity is essentially founded on two human rights: the right to equality and the right to freedom. Freedom is consistent with human nature and helps to live a life with dignity, but it can only be attained by all people being treated equally. So far, everything appears to be simple, but it isn't, because human dignity has dual nature in the Latvian legal system. Human dignity is both a constitutional value, principle of law. However, human dignity is also a fundamental right enshrined in the Constitution of Latvia, Article 95. Article states, "The state shall protect human honor and dignity. Torture, other cruel or degrading treatment of a person shall be prohibited." This is the narrowest understanding which primarily protects person from inappropriate punishments or degrading criminal proceedings. This construction of human dignity is inherited from Soviet law, which did not recognize the grand concept of dignity as a value binding on the state, but civil and criminal law protected the narrow scope of human dignity in tandem with honor. Article 7 of the Civil Code of the Latvian Soviet Socialist Republic regulated the defense of honor and dignity, stating that, I quote, "A citizen or an organization has the right to demand through a court the restriction of information that offends his honor and dignity. A fine of up to 50 rubles shall be imposed," quotes end. It is in the commentaries of the Civil Code of the LSSR that the content of the honor and dignity in Soviet law can be found. In that passage, it is said that honor is the social judgment of a person arising in connection with his conduct in society. Dignity, on the other hand, is translated as a person's self-esteem. It was further emphasized that only citizens with legal capacity and organizations that are legal persons could claim the defense of honor and dignity. Not everybody has dignity. Under Soviet law, both personal honor and dignity were protected only from those spreading false news. Also, the Soviet state was committed to implementing the principle of Universal Declaration of Human Rights. It didn't know that fundamental concept of human dignity, which is the basis of the all legal system. And the provisions of the Constitution and laws didn't ensure the protection of human dignity because they did not create equal guarantees of freedom for every human being. If it is a legal principle, as well as a fundamental right, may human dignity be one of those. Each and every right, including each fundamental right, must be compared to human dignity. Is human dignity then a fundamental right that becomes before others? The decisions of the Constitutional Court of Latvia also demonstrate the complex legal content of human dignity, which is constitutional value, a general rule of law, and a fundamental right. I will only briefly cover a handful of the most noteworthy examples. Human dignity has been used as an argument to assess the constitutionality of a legal provision in a number of judgments. First, a few words on human dignity as a fundamental right. Basically, all the cases which have assessed human dignity as a fundamental right relate to the execution of sentences in prisons and rules governing the detention of persons in criminal proceedings. However, the majority of constitutional complaints from individuals have not been about the legal provisions, but rather about the regulations of a cabinet of ministers, which detail the process of detention, how to ensure a person's stay in custody prior to trial, and how to ensure their basic needs in prison. For example, person submits a constitutional complaint because he or she is not provided with pillow and a towel in a place of temporary detention before a trial. It is judgment fresh 2022. The Constitutional Court concluded, I quote, "The fact that person don't have access to a towel and have to clean up in their clothes after taking a shower may deter prisoners from taking a shower. It also contributes to the creation of unsanitary conditions in the place of temporary detention." Second sentence from this judgment. The second sentence of Article 95 of the Satversme includes the obligation of the state to ensure conditions in places of deprivation of liberty which are compatible with human dignity and to prevent cruel or degrading treatment of a person, quotes end. Similar findings can be found in older cases assessing prison conditions, prisoners' food, access to hygiene products, and so far. Unfortunately, there are no new prisons in Latvia until now, and the Soviet-era code of execution of sentences is still in force from Brezhnev's time, which even after many amendments does not meet European human rights standards. Human dignity as a constitutional value and a principle of law is difficult to separate because constitutional values are embodied in principles of law. It is difficult to draw the strict line here. However, there are judgments which clearly state that human dignity is a constitutional value. For example, I quote, "It follows from the fundamental norm of Latvia as an independent, democratic and law-governed state that human dignity is a constitutional value of the state," quotes end. A number of judgments assessing compliance with human dignity as a principle of law is significantly higher than the number of judgments assessing compliance with Article 19.5, human dignity as a fundamental right. The Constitutional Court has emphasized that quote, "The fundamental norm of a democratic state governed by the rule of law implies the obligation of the state to respect the principles of a democratic state governed by the rule of law in its actions, including the principle of human dignity." Quotes end. Compatibility with human dignity as a legal principle has been reviewed in a wide range of cases. Just few examples with citations which constitute an important case law of the Constitutional Court of Latvia in this issue. First of all, soon after the introduction of the constitutional complaint, the Constitutional Court laid the foundation for human dignity as the measure of all things, I quote, "By supplementing the Constitution with Chapter 8, Fundamental Human Rights, the legislator has established a system of values in the country which recognizes the protection of human dignity and freedom as the supreme aim of all law." Quotes end. This idea is also underlined in the judgment in year 2019, I quote, "A fourth paragraph of introduction of the Constitution of Latvia Satversme states that Latvia is a democratic, law-governed state, is based on human dignity. Human dignity and the worth of each individual are the essence of fundamental rights." Quotes end. In 2020, the Constitutional Court evaluated a number of cases following applications by the Latvian Ombudsman that the system of social support for persons in need, persons with disabilities, etc., who need to receive at least a minimum level of state support in order to survive, is unconstitutional because it places these persons in an unequal situation. The Constitutional Court, in its assessments of these cases, applied the concept that state support must be such as to enable the persons surviving the support, I quote, "to satisfy at least their basic needs and to enable them to lead a life which is compatible with human dignity." Quotes end. Moreover, the Constitutional Court, when ruling on decent standards of living, included not only the satisfaction of biological needs, food, medicine, shelter, etc., but also the possibility for every person to participate in the life of society and enjoy culture. I shortened my examples, and now I'm going to some conclusion. The Constitutional Court's case law has much more to say on human dignity. Some years ago, the judges of Constitutional Court of Latvia met with the judges of the German Federal Constitutional Court to examine recent ruling. When the Latvian judges indicated that they employed the concept of human dignity frequently in their reasoning, the German responded that they didn't. They say such powerful argument that it should be only used in the most crucial cases. Why is German case law different from Latvian case law? Are we less capable? Or maybe we are just more passionate persons? My response is that in a post-Soviet nation, the extensive use of human dignity as a justification is not only comprehensible, but also important. After half a century of totalitarianism, when the human person was worthless and legally defenseless against the state arbitrariness, the Constitutional Court has a duty to raise awareness in society and among legislators of the content, comprehensiveness, and legally binding nature of human dignity. Thank you.
Ačiū gerbiamai profesoriai.
Thank you, Professor. We wish every success to our Latvian colleagues, and we are very happy to have an invitation to an annual meeting with our Latvian colleagues in early December. This will be a good opportunity to exchange our views, so this will be very useful. And from your presentation, I found it useful to hear the achievements of Latvian colleagues. And as we've heard from our colleagues, ombudsmen were mentioned, and it should be mentioned that ombudsmen have the right to apply to the Constitutional Court, and this brings new topics into the Constitutional Court. Maybe the topics, the cases are related to various economic and other ideas. The Constitutional Courts cannot choose the cases themselves. They simply have to deal with the cases that are referred to their court. Now, when it comes to the protection of human rights, procedural things are very important indeed. And now we have to come back. Therefore, we have to come back to our keynote speakers of this part. Therefore, it is my pleasure to give the floor to President of the Supreme Administrative Court of Lithuania, Professor Dr. Skirgailė Žaliminė, and she's going to speak about the multi-layered protection of constitutional human rights and freedoms.
Taip, ačiū labai. Na, iš tikrųjų, labai malonu kalbėti šioje konferencijoje. Ir iš ties reikia pripažinti, kad Lietuvos vyriausias administracinis teismas turi labai daug bendro ir su pagrindiniam teisėm, ir su žmogaus teisėm, ir taip pat su Konstituciniu teismu. Tai iš tikrųjų, žiūrint, pavyzdžiui,
Good afternoon. It is a pleasure to speak in this conference. The Supreme Administrative Court has much in common with the Constitutional Court, with human rights and fundamental rights. And our court refers to the Constitutional Court very often with different requests. But it must be said that the Supreme Administrative Court of Lithuania also refers to the European courts and has a certain dilemma whether to refer to the Constitutional Court or to the Court of Justice of the European Union, or to do first with the Constitutional Court and then with the European Union Court. I don't know how much time I have. We are lagging behind with our timetable. My presentation is made up of 3 parts, and first I would like to stress the fundamental rights and human rights in the practice of our law, of our court. Another issue, well, this is a scientific conference, therefore I would like to discuss the relation between the fundamental rights and the European fundamental rights. Danutė Jočienė spoke about the relation between the EU law and Lithuanian law. And finally, I would like to present certain cases where we have a certain collision, where we have to follow the European Union law, but we also have to follow the doctrine of the Constitutional Court. The matrix has already become the rule that the purpose of administrative justice is to protect human rights against unlawful acts of public administration. There's no doubt that the main objective of administrative courts is to ensure justice and respect of human rights in administrative legal relations. First of all, this is justified by the Constitution of the Republic of Lithuania, which states that constitutional democracy cannot exist without an effective mechanism for defending human rights. Secondly, the instruments establishing administrative courts suggest that the primary purpose of administrative courts in Lithuania is to strengthen the guarantees of judicial protection of human rights and freedoms. Indeed, the draft laws establishing administrative courts have assessed the specificities of administrative court systems and the legal status in different European countries. And in Lithuania, we base on the example of the standards of all European countries. Defending human rights and freedoms is a constant priority for the court since its very beginning. Violations of human rights and freedoms are most frequently addressed by the court when it comes to the proper protection of the right to property, the right to respect for private and family life, freedom of assembly and association, the right to a fair trial. In ensuring justice and respect for human rights, the Supreme Administrative Court relies on the Constitution, the provisions of various international agreements, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Universal Declaration of Human Rights, the Convention for the Protection of Human Rights and Fundamental Freedoms, and the Charter of Fundamental Rights of the European Union as a source of law. Human rights and freedoms are one of the core values enshrined in the Constitution and guaranteed by the Constitution and other legislation. Human rights, the preamble of the Constitution states that Lithuania's nation promulgates the Constitution in order to achieve an open, fair, cohesive civil society and the rule of law. In the Supreme Administrative Court, international law has become an important source of law and standard for administrative proceedings. It is recognized that the Convention for the Protection of Human Rights and Fundamental Freedoms can be applied directly, and I would like to mention some examples. For example, a case of 2010, the case on a gay parade where the court followed the practice of the case of Boskovsky and others versus Poland, and stated that the prevention of the gay parade was proportionate. The Lithuanian Supreme Administrative Court also ruled on the violation of Article 8 of the European Charter of Human Rights in respect of private and family life. This was in relation to the failure to establish adequate legal conditions for receiving health care. We have other examples here. The Charter and the Convention are both important to our work, and the EU law and Charter are also very relevant. And when we speak about the Charter, one of the main examples is Bechter case, where Article 47 of the Charter was referred to. And we wanted to figure out how to interpret a certain regulation. If we look at the EU law, it must be said that the EU law is based on the assumption that every member state shares with other member states the majority of values on which the EU is built, and which is also stipulated in the EU treaty. This assumption means that member states should have a mutual trust principle, meaning that member states trust each other when implementing the principles and implementing the law of the European Union. Both the Lithuanian Constitution and the European Union Treaty refers to the principle of the rule of law that are based on very similar values. Article 19 of the EU Treaty should also be noted. This article enables the value of the rule of law from Article 2, which requires also ensuring judicial control. And according to this, the Court of Justice of the European Union has a constant practice that national and international courts have to provide a specific effect to the rights of the Charter. And certainly the last instance court has more obligations compared to the first instance courts. When we look at the situation of the Supreme Administrative Court in protecting human rights and fundamental rights, the role of the court has not been static, and it has been changing from the passive observer to the active protector of human rights, when human rights have become part and parcel of the system. And our court has the power to go beyond the national level. The protection of the fundamental rights in the European Union is protected in the multi-layered way based on constitutions on the national level, international system, for example, the convention, and also the EU system based on the Charter. So all the EU member states have several systems with 3 layers of the protection of human rights: national, international, and EU with Charter. Without any doubt, one might ask that probably one of the systems is superior to others, and how courts should evaluate the superiority. We know that every of that systems has its own legal content, its own institution that interprets legislation. In any case, the Charter of the Fundamental Rights seeks unified operation of EU laws in harmony with national requirements for human rights. But courts may face in practice with different level human rights that are enshrined in all those three sources mentioned above, and face certain problems when a tension between different levels of human rights protection may arise. Without any doubt, it is important the role of EU law is of paramount importance here. It must be noted that constitutional courts of member states and supreme courts over years have contributed a lot to the legal content of the Court of Justice of the European Union by enriching the content of the fundamental European rights. The case law of the Court of Justice of the European European Court of Human
pagrindinių teisų apsaugos sistemos. Tai ši vadinamo
European Court of the Court of Justice of the European Union followed the examples of Germany, France, and other countries. Despite the fact that the European has the main protection system for the protection of human rights, and its court doctrine is clear, cases of Germany and Italy in their constitutional courts preserve the right of a final decision, even if they are related to the EU law with certain modifications, and this is reflected as the constitutional and court practice. EU courts and national courts share responsibilities in protecting human rights and fundamental rights. From the European Union perspective, the main articles in the Charter that should be noted are 53, which says that the Charter cannot be violated, and also Article 52.4, which states that all the provisions of the Charter should be interpreted in accordance with the practice of the national constitutional courts. This means based on those traditions. It means that the provisions of the Charter came from somewhere or from national law, therefore they should be interpreted in light with the national tradition. Court practice in many countries, as we know, is not even in this area. The scope of application of fundamental rights is not equal in all the countries. When we speak about the fundamental rights in one country, they might be different in the tradition of other countries. We see a clear rule that the Charter should not weaken the systems of national human rights protection. Speaking about the Court of Justice of the European Union, the German Constitutional Court should be mentioned where it refers to the fundamental constitutional rights and its relation to the rights enshrined in the Charter. The ruling of the German Constitutional Court speaks about the coalition of all the rights, but reserves the right of checking those rights. Now, speaking about the practice of the Court of Justice of the European Union, the Charter is aimed at the European standard and considers it to be value. But we see that in certain cases, in certain circumstances, the Court of Justice agrees that some divergence from the mutual trust of member states is possible. This is a Meloni principle. We can diverge from this European standard when there's a possibility to believe that the country violates certain European standards. Speaking about Lithuanian Supreme Administrative Court, it must be said that in our case law, we follow the Constitution, the European Charter, and we do not, in our doctrine, we do not make an opposition between those rights. The EU law conflicting to national law should not be made artificial. On the other hand, it should be pointed out that national interests sometimes should be not taken for granted. We know that the interests of national identity and arguments can be used to limit fundamental rights in the European Charter. Without any doubt, both the EU courts and national courts are moving towards direction that this is a friendly two-directional interpretation way when there is no conflict or division of interests. But in practice, without any doubt, for example, a Supreme Administrative Court, when applying the European standard, the court might ask whether this is not in conflict with the Constitution of the Republic of Lithuania. Maybe the Lithuanian Constitution has a certain national identity that cannot be ignored, and in any case we should see and examine carefully the circumstances, and the Constitutional Court here can help us. We have some conflicting situations as well. I don't have much time to expand on that. The use of name and surname was one of the areas as an example here. Another area was the indivisibility of the right to private life. I just want to say that in this case, the Supreme Administrative Court examined legal regulation by taking into account the EU regulation and also respected the jurisdiction and competence of the Constitutional Court, and also respected both systems equally and ruled the case in a proper manner. My other example is related to the benefits for children. And here the court too followed the Constitution of the Republic of Lithuania and the European Charter and its Article 24, which speaks about the consensus of member states when adopting all the interests of children, which should be considered as a priority. I will not mention any more examples. I just want to say that the Supreme Administrative Court, or any court in Lithuania, both our court and other courts, are faced with the obligation to be wary, to be careful, and to apply both the Constitution, to be vigilant, and to apply international standards, especially when we speak about the fundamental rights and the European Charter. My question is, how can we help courts with their difficult and complex task in order to avoid mistakes and to avoid errors and ignoring national interests? National identity fundamentals are approved from time to time in the EU case law. Previous speakers spoke about this. I have in mind Mr. Jarashunas. He spoke and he wrote a lot of publications on national identity and other problematic aspects related to that. Thank you.
Thank you, Madam President. I believe that your presentation gave us food for thought. Well, our next keynote speaker will be speaking about the problems of the defense of human rights and freedoms and the activity of advocates. So it's my pleasure to give the floor to Mindaugas Kukaitis, chairman of the Council of the Lithuanian Bar. The title of the presentation seems rather mysterious, therefore it is very difficult for me to guess what will be in the presentation itself. So the floor is yours, Mr. Kukaitis. Well, I guess you have perfectly described the mission of the advocate. But first and foremost, let me thank you for the opportunity to speak in front of this audience. I believe it is the right place and the right time for me to speak on this topic and actually appreciate the achievements that have been done over the 13 years. It is also the place and the time to talk about the criticism because it avoids to repeat the mistakes in the future. And from this podium, I've used this podium for quite a few years to talk about the disrespect to the client's secret, to the disrespect for or intervention into the confidentiality between the advocate and the person, into the illegal surveillance of the suspected persons, about the pre-trial investigations, about the pre-trial investigations that start out very loudly and end very silently. I also talked about the problems related to legal aid, free legal aid. When I received an invitation to deliver a speech during this the conference, I was asked to talk about the independence of the Bar Association, and I was prepared to say that the Bar Association and the profession of the advocates has been mentioned in the second statute of the Grand Duchy of Lithuania. So the Bar Association in Lithuania is also celebrating its anniversaries. I also want to mention that the objective of the Bar Association is to ensure the right to defense. We also have to speak of the respect for the principles. I wanted to speak about the importance of independence of the judiciary. I wanted to draw your attention to the fact that following the independence, during every parliamentary term, there were attempts to interfere into the Bar Association, into the activities of the Bar Association. One might wonder why. And the reason is because the Bar Association contributes to the both legislature, executive, and judiciary power. And as the advocate sees all those change, he becomes intolerant to the violation of the various human rights principles. Sometimes advocates are not very convenient for politicians. I also wanted to say that the laws on advocates have been amended 9 times. I wanted to talk about the enduring desire to open investigations and flagrant violation of presumption of innocence. I wanted to talk about the cases when the state interferes in the work of the Bar Association. But I'm not going to say to talk about that. But I'm going to speak about different things. A few weeks ago, I participated in the Council of Bars of Law Societies of Europe, and I was listening to the leaders of the Polish Bar Association. This Council of Bars of Law Societies of Europe brings together millions of advocates. And the Polish Bar Association said that we were already lagging behind to speak about the performance of professional duties because we had to do this much earlier. The principles that we cherish so much are often very consciously circumvented by politicians. You know, in peacetime, we often observe that instead of becoming more transparent, instead of strengthening and respecting the principles of separation of powers, we are trying to regulate the things that have not been regulated. Today, as lawyers, we must be talking about the experiments that are conducted in many areas, including the healthcare, education, legal system. We have to be courageous and say that independence of courts is also at stake. And the things that have been enshrined in previous documents is no longer valid. Today, the participants of the conference recalled when the first constitutional court was assembled and when politicians tried to interfere with the activities of the constitutional court. Unfortunately, such attempts by the public authorities to interfere with the judiciary is still being repeated. And as we keep silent, we simply observe that the rule of law is slightly becoming the non-rule of law. we tend to forget that presidents of courts are appointed, which have to be appointed for, let's say, 9 years, serve for longer, let's say, serve for 10 years, and we still keep silent. Let's talk about the political cooling off period before taking new positions. For example, in the kingdom, in the United Kingdom, there's a mandatory 6-month cooling off period. In Norway, this period is 6 months, whereas in Spain and Cyprus, this period is 2 years. Well, it seems that everyone wants to have everything that is cheap and that is fast. We try to merge courts. We try to bring our hospitals or services further away from our citizens. It seems that we stopped seeing the human being himself. At the meeting of the aforementioned council in Poland, I also heard very interesting ideas on the judicial reform in Romania. And, for example, in Romania, an advocate will have restricted timing for their final speeches to be made. Is that the justice? Is that this kind of justice we are aiming at? It seems that all the reforms are like an eclipse, like a punishment, because they come down from a high level. Even when we give our own expert insights, we become a kind of an enemy to those pushing for such reforms. But then you have one has to answer the question, is there any legal accountability for such reform experiments? Maybe this is just a utopia, but, well, unfortunately, we haven't taken any measures to ensure that we no longer have such accounting scandals in municipalities that have come to light recently. The Bar Association has been and will continue to be strongly opposed to the strengthening of state surveillance powers. So we are against. We are against surveilling. The military surveillance means against civilians. Therefore, it is fair to say that individuals do not have sufficient means to defend themselves against digital surveillance. Street cameras, body integrity, voice and face recognition procedures have not been regulated, but the data has been collected irrespective of that. I find it difficult to believe that this is in line with the European Convention on Human Rights and the principles enshrined in our Constitution. We fail to hear our people. We fail to listen to the situations related to domestic violence. Instead, we carried out a very sad experiment. From the 1st of July, in the very first 3 months, $12,000 times 6,000 violence orders were issued. We have launched hundreds of thousands of proceedings related to domestic violence. We still do not have the measures to help both the victim of domestic violence and the perpetrator. We have not started working sufficiently with both the sides to the domestic violence to help them. And the statistics is as follows. If people apply for a violence order, half of them are satisfied, but half of such orders were denied by courts. Yesterday, the president of the Konf County Court expressed his public opinion with regard to such violence orders. And I hope that the politicians will hear his call for help, because the implications after this violence order can be very sad. There is yet another, even more painful topic. School children and drug use in schools. Lithuania is not the only country in the world that faces such a huge problem, but the opinion in the society is that it is the problem that should be addressed here and now. The only argument from the law enforcement institutions is that we have to strengthen, to impose more stringent penalties or even change the age limit. The legal responsibility is imposed for the minors below the age of 14 age for violent offenses. Now we've heard the ideas that minors below the age of 14 should also be imposed legal responsibility for possession of drugs. Well, just like our children also undergo stress. Some of them choose to go to the gym and to, let's say, do some boxing, whereas others use force and violence against those who are weaker than them. Some try various kinds of drugs. So have we done enough to ensure that that minors do not make crimes in the future? You know, I'm very happy about the moderators of this session. I have an idea, and hopefully this idea will be used as a preventive means. For quite some time already, we have one measure. And that is, we have the law on the whistleblowers. The law on whistleblowers states that if he contributes to identifying the offense or the crime, that person, that whistleblower, will be awarded. We spoke quite loudly about that measure. Unfortunately, in 2022, the prosecutor's office and the police department each gave one award for valuable information on criminal offenses, while the financial crimes investigation services did not have any whistleblower rewards, and in contrast, the Special Investigation Service awarded monetary reward to 57 persons. Why can't we use this law when it comes to drugs in schools? It is our task to dismantle drug dealing networks, and instead of harming the lives of those minors, we have to ensure that we help them understand what crime they are committing. To conclude, I hope that the founders of the Constitution has given us an instrument to protect the constitutional values. Let us use it wisely. Let us use this instrument to ensure that we protect people. We have to stand up for those constitutional values. I am sure that advocates will continue to stand up for the legal values as long as there is a person who needs their defense. I have to admit, however, that if constitutional principles are violated by all three branches of government, it is not the advocate, but the court of public opinion that is the ultimate authority to adopt the decisions. Thank you very much.
Thank you for an interesting presentation with the social and legal insights and challenges raised. Constitution is a living being. It is being developed, and I hope that members of parliament will remain to be active in wishing to regulate more and more social spheres.
Ačiū. Gerbiami kolegos.
Dear colleagues, we are continuing our work, and I believe this should be the most interesting part. Well, everyone who were participating in the conference already knew a lot of things that have been mentioned during the first parts of the conference. Now we are going to have the part dedicated to the experience of foreign countries. The fourth and the last session is called Experience of Constitutional Review in Democratic States. We are going to have several presentations here, and we will be very interesting to hear the experience of our colleagues from Poland, Estonia, and in particular in Ukraine, that is at war now. Well, in fact, I wonder whether there. I wonder whether you have any meetings. My colleague, Dr. Vytautas Mizaras, Justice of the Constitutional Court of the Republic of Lithuania, will be co-moderating the session with me. Good afternoon, ladies and gentlemen, participants of the conference. Good afternoon, keynote speakers of the session and participants of the conference, both watching us online and sitting here in the hall. As Dr. Toma Birmontienė already mentioned, I will be the co-moderator of the session. The last session does not mean that it is not important. It is important because we have to get into dialogue
valstybių teismų, labiausiai man aktualu.
With the colleagues from the Constitutional Court. We have to speak with them to analyze similar issues that our courts face. And we have to do this in any time. When we live in good times, our meetings very interesting. We meet in various forums and conferences, and we usually have some very festive moods. Now, in times of challenges, and this is particularly the time that we live in, we face with quite a few problems. The dialogue has become even more important because first, we have to hear about the true problems that the colleagues face. And second, it is important for us to draw experience from the colleagues so that we could avoid making the same mistakes. And maybe to help our colleagues, if there's such a need. How to address various issues when it relates to the protection of human rights or the rule of law or the independence and democracy of the state. Let me also we are running out of time because we had to complete the conference at 4 p.m. But as I was sitting here in this hall, I was thinking how glad I am to participate in such events, because this is one of the very few opportunities when you cannot manage, when you are the one to manage the time. So now we are going to manage the time. We are going to speak further, and we are not going to leave the hall at 4 p.m. Therefore, now it is my pleasure to give the floor to the first speaker of this session. Professor Dr. Marek Zubik is from the Faculty of Law and Administration of the University of Warsaw and a former Justice of the Constitutional Tribunal of the Republic of Poland. Let me also add that Professor Zubik has been member of the Polish Constitutional Law Association since 2005. He's been a member of the International Constitutional Law Association since 2008. He's experienced in working in various public institutions. He's been in the Polish Parliament. He was also working in the office of the Human Rights Commissioner's office. And as it has already been mentioned by me, he's also the former Justice of the Constitutional Tribunal of the Republic of Poland, who was in service from 2010 to 2019. The topic of Professor Zubik is legal and social grounds of the functioning of the Constitutional Court. Warnings from the case of Poland.
Take the floor.
Dear Professor Co-Chairmans, ladies and gentlemen, I would like to express my many thanks to Professor Tomasz Bismuntniene and all your colleagues for invitation and hosting. And I congratulate my colleagues from Lithuanian Constitutional Court, and especially today's anniversary. I wish you interesting cases, but always accurate decisions. And please forgive me, there was a long list of posts I was involved. But last week, the Cabinet Minister of Ukraine nominated an advisory group of experts for nominating new judges of Constitutional Court of Ukraine. It consists of 6 persons, and one of these persons was me, nominated by European Union. And today will be the first meeting of this group, and I should leave and return to the hotel and enjoy this meeting, and please forgive me, just before 5 I need to leave this floor. An ancient phrase said that all law must be made with respect to human being. On the one hand, man creates norms, others, due to their functions, exercise public authority and implement competencies defined by law. They give these norms their current content. Finally, man is addressee of objects addressee or object of norm. This is the most typical use. All these social roles sometimes intersect. Man is a person. He has a free will and reason. Man is relational and social in nature. He strives to live together with others. He creates communities through which he can obtain a certain values that he wouldn't be able to create on his own. According to these assumptions of the Enlightenment, man was supposed to live the times of Fides and move to higher form of existence within the framework or ratio. He had an answer again the questions of where he came from, who he was, where he was going. Copernicus disrupted anthropocentric thinking about the universe. The Earth is no longer the center of space. Darwin pointed to the natural connection between man and the living world. Although Kant pointed out the importance of law, Freud stubbornly pointed to the darker side of human nature. We are at that point in civilization development where, in our part of the world, democratic way of organizing social life is recognized as the one of the most fully allows for people's self-realization and the co-shaping of the common good. However, I would hypothesize the human nature, when confronted with the exercise of power, can be very defective and quickly shows the disastrous effects of the desire to rule. Additionally, human nature is difficult to change, and people are slow to improve their ethical condition. Therefore, the greatest threat of democracy and the concept of the rule of law is man himself. The law, in the sense of system of actual implemented norms, express certain content. Preferably it should be fair. However, it must also create an appropriate structure of public institutions. In a state that respects the rule of law, every body exercising public authority must be established on the basis of law and operate within its framework. This applies to all judicial authorities, including constitutional courts. Every judicial body, including this carrying out judicial review, must have appropriate constitutional legitimacy. The law itself, contained in normative acts, including the Constitution, is definitely not enough for the entire democratic structure to function properly. Legal standing is usually not enough on its own. State authority, especially the courts, must be listened to by everyone, including those in power, and must enjoy social authority. They need them to be able to properly fulfill their social role and effectively resolve disputes. As long as the democratic system of the state functioning properly and the state operates efficiently, at least in the opinion of the significant majority of active citizens, no significant changes should be expected. This will ensure legal security and social peace. Even the constitutional violation can appear there. Provided they receive an appropriate response under the law, the system of government itself will remain stable. However, the state as a whole must respond to the aspirations and needs of citizens. Without active and conscious democrats, no democratic system of governance will be sustainable. A combination of certain legal, political, or social circumstances may lead to a situation where even the judicial authority provided for in the Constitution will not be able to fulfill this basic task. There are enough cases in history when, without a formal change to the normative text, a specific state body lost the qualities necessary to function. In fact, in each case of political transformation, from authoritarian to democratic rule, the questions arose about leaving the power to judge in the hands of people who, as judges, had so far supported governments that violated democratic values, freedoms, and human rights. Then, measures may be necessary to restore to the proper role of the public authority appointed to judge, which in normal situations wouldn't be considered ordinary or sometimes even permissible. We tend to perceive the activity of constitutional courts or judiciary review as a useful and recognized mechanism for maintaining the fair content of enacted law, respect for procedural justice and minority rights when adopting laws, or maintaining the democratic system of state. This point of view was also most often expressed by those who wanted to replace the democratic system of governments with an authoritarian system. At that time, they recognized an efficiently functioning constitutional court protecting basic democratic principles as a serious obstacle to easily taking over all power in the state. They then led to either the suppression of the constitutional court's operation, its liquidation, or taking control over it. There were also cases when constitutional courts, by not assessing in situations soberly enough, paved the way for the installation of an authoritarian system in a given country, and even supported violation of freedoms and human rights. They then became part of authoritarian system of governments. Over time, they usually lose social acceptance permanently, and I would further like to point out 4 different ways in which those in power respect a constitutional court when they consider an obstacle to taking power in entire country. First, ignoring. When it is impossible to change the constitution and remove the constitutional court from it, the easiest solution is to act as if the constitutional court and its jurisprudence didn't exist at all. This method of neutralizing the constitutional court doesn't require any change in the law. However, its effectiveness depends on the reactions of common courts, as isolated constitutional courts has no chance of maintaining its independence if the other authorities want to limit it. Most often, the condition for a constitutional court's rulings to come into force is proper publishing its verdicts. It's no different in the case of constitutional situation in Poland. The Constitutional Tribunal issues a judgment, but its publication in official newspaper takes place through the actions of the Prime Minister. Although it has always happened that the public authorities didn't implement the Constitutional Tribunal's judgments very quickly, but since 2015, it has become a systemic problem. At the turn of 2015 and 2016, against the background of political dispute related to appointment of Constitutional Tribunal judges and ensuring the independence of this state body, the Prime Minister began to refuse to publish the Constitutional Tribunal judgment in the Journal of Law. These actions started a conflict with the European Union. Parliament passes a law in which it ordered the publishing of the Tribunal's decision, its quotation, taken in violation of the regulations. Therefore, the Parliament undertook to evaluate the judgments of the Constitutional Court and at the same time gave a clever opportunity to the Prime Minister to change this procedure. The longest period was the announcement of judgments concerning subsequently acts on the Constitutional Tribunal passed in Parliament since 2015. They were published in June 2018. Even against this background of violation of the Constitution regarding the announcements of the Constitutional Tribunal's judgment, completely exception was the case of the judgment on abortion, which was passed in October 2020. The ruling that one of the grounds excluding abortion from the being punished as unconstitutional sparked long-lasting social protests during the pandemic. The Council of Ministers even published a special position on the date of publication of the judgment. Finally, it was announced in January 2021. The second, the composition of jury. Sometimes the composition of the Constitutional Court doesn't reflect what the Constitution requires. The example of elections of judges of the Polish Constitutional Tribunal in 2015 shows that politicians of each option may be tempted to fill the Constitutional Court with people from whom they expected at least identification of their expectations. This case is quite famous. Let me just remind that in 2015, in the last month of activity, the Parliament elected 5 judges of the Constitutional Tribunal, including 2 judges whose mandate was to expire only within the next term of office of the Parliament. This triggered a destructive avalanche of events. The Parliament of the 8th term, acting without a constitutional basis, with the cooperation of the President elected in 2015, replaced all the above-mentioned 5 judges with new people. The Tribunal tried to save the situation in judgment, declaring the unconstitutionality of the legal basis for the election of the 2 Constitutional Tribunal judges by the Parliament. A month later, he refrained from taking a position on action of the Parliament of 8th term in 2015. The time and passage of terms of office of subsequent judges, including the current President and Vice President of the Constitutional Tribunal, led to complete domination of the Tribunal by a person elected by the Parliament of the 8th term. At the same time, allegations regarding the proper staffing of Tribunal persisted, a problem that exists to this day. These reservations were also shared by the European Court of Human Rights in its judgment Xeroflor against Poland. He found the participation of a person elected by the Parliament in December 2015 to be to that position already held by the Constitutional Tribunal. He found the participation of a person elected by the Parliament in December 2015 to the positions already held by a Constitutional Tribunal just elected by the Parliament of the previous term, in examining a constitutional complaint to be in violation of the Article 6 European Convention. In response to this European Court of Human Rights judgment, the Prosecutor General submitted to the Constitutional Tribunal a motion on a constitutionality of Article 6 European Convention. The Constitutional Tribunal found that this provision of the European Convention doesn't give the European Court of Human Rights the competences to questioning the legality of the election of Constitutional Tribunal judges. The process of nominating judges of the Constitutional Tribunal always arouses political and sometimes social emotions. However, some practices are particularly undesirable. This is about a situation where too low political culture will cause politicians to perceive state body as their political prey. We should avoid electing constitutional tribunal judges from among active politicians, especially those with very controversial public activities. The situation of electing a former MP as a judge who was unable to renew his mandate and a few weeks earlier in the general election, which happened in 2019, should also be considered undesirable. Such a practice is not compatible with the idea of external independence and prestige of the judicial authority. It also arises the problem of the impartiality of such a judge when adjudication on constitutionality of a bill in the adoption on which he participated during the work in Parliament. Finally, within the composition of the Constitutional Tribunal, although it was composed entirely within the arrangements of the ruling party since 2015, there has been internal disputes. They were made public against the backdrop of a large number of judges questioning the legality of the exercising of the function of the President of the Constitutional Tribunal by a person appointed in December 2016, after the expiry of a 6-year term of office. As a result of this dispute, there was internal organizational paralyzing and inactivation of some function performed by the Constitutional Tribunal, in which the regulation requires the participation of at least 11 judges. The third, Constitutional Court arebur. Sometimes a constitutional court is established by politicians who exercise authoritarian rule in a country. This is then the most desirable situation for them. This gives them a chance to maintain an appearance of democracy. However, they do not create it to proper decent order or legal security. The Constitutional Court may then become an element of maintaining the power of the authoritarian regime and oppression. It then serves neither to maintain the principle of a democratic state nor to protect the freedoms and rights of citizens. Such a risk threatened the Polish Constitutional Tribunal, which was established in 1982 during the communist regime. However, subsequent generation of judges adjudication there, through reasonable jurisprudence, have developed considerable social authority of the Constitutional Tribunal. Thanks to the natural replacement of Constitutional Tribunal judges at the end of the term of office in 1989, at the threshold of the political transformation, no decision was made to radically interrupt the continuity of the Constitutional Tribunal. The Polish Constitutional Tribunal avoided the threat rose to the Greek Constitutional Tribunal. This tribunal, Greek Constitutional Tribunal, was established in 1968 Constitution during junta black colonels. The fall of the Greek junta in 1974 opened the questions about the model of judicial control in Greece. Memories of the military dictatorship made centralized model of constitutional review socially impossible. As it was stated then, even a good idea can turn out to be very dangerous in the wrong hands or in an abnormal period. Fourth, social delegitimation. Sometimes the jurisprudence on Constitutional Court will be completely rejected by citizens, especially when they recognize that the judges are not an impartial resolution advocated, but actually confirmed the political will of those who elected the judges. After winning the election in 2015, prominent representatives of the parties forming the government began to spread the idea of the role of the Constitutional Tribunal as the third chamber of parliament. Although such a view had already been formulated in journalistic debate, it was never associated with the desire to transform the tribunal from the ducal model to the general political one. The propaganda slogan used in 2015 to justify violating the constitution was started to be put into practice by politicians. To close personal relation between the new leadership of the Constitutional Tribunal and the leadership of the ruling party were made public. In the press interview from May 2019, the chief of the ruling party referred to the newly appointed president of the Constitutional Tribunal as the, as a quotation, social discovery of recent years. Reducing the tribunal to the role of post-election trophy squandered its previous acquired social capital. Politicians achieved a Pyrrhic victory. They took over a state body but ruined its social prestige. The Constitutional Tribunal itself is slow to take up matter and are inconvenient to the political majority, and especially slow to present justification of its rulings. Moreover, the new jurisprudence of the Constitutional Tribunal in a matter of key importance for the current political dispute began to follow completely new paths, unknown not only in exercising jurisprudence, but also in the basic mainstream of the constitutional law scholarships. The Constitutional Tribunal denied the admissibility of using interim measure of the European Court of Justice on interpretation of the origin meaning of tribunal used in Article 6 European Convention. The Constitutional Court found that the concept didn't apply to it. As a result of this this verdict of Constitutional Court, Polish authorities stopped honoring the judgments of the European Court of Human Rights, in which this European Court recognized a violation of Article 6 European Convention in the context of the defective formation of Polish courts. The Constitutional Tribunal's ruling began to be widely perceived as excesses. The natural role of the Constitutional Tribunal as an arbiter on the constitutionality of norms in sensitive public matters was changed into legitimization of the unconstitutional actions of the government majority through its judgments accepting such actions. The Tribunal has also clearly lost its current position in cooperation with the other constitutional courts. All this situation I mentioned have already taken place in the not so long history of constitutional courts in Europe. This mechanism has undoubtedly made invaluable achievements in consolidating and protecting the rule of law, the separation of power and human dignity. However, it can never be considered as a system whose development is made forever. All public authorities, as well as the judges of the constitutional courts themselves, must remember the social authority, once worn out, cannot be easily restored. Changes in the law rarely are enough. In the end, I would, referring to the President Kennedy's famous words, and I transfer it. Ask not what courts can do for you, as what you can do for protecting independence of your courts in your country. I think it is the most important problem on unstable state. Thank you very much for your attention.
Thank you very much, Professor Marek. It's really very impressive presentation. And now maybe probably bearing in mind the Polish experience, we will have a process of reconstruction, but not only the court, but the trust of the society. I think to reappoint judges, maybe it will be easier. But how to prove that the court, that they hate it probably, or mistrust, it will be different. So it is a very, very long story. So thank you very much. Dėkojame labai, profesoriui tikrai.
Thank you, Professor. I believe that it's rather very difficult to work for the Constitutional Court of Poland, and hopefully the court will regain its independence as well as the public trust. And now I'd like to give the floor to our colleague from Estonia. And I do hope that we're not going to hear of similar problems from our Estonian colleague. Our Estonian and Latvian colleagues live better. Their constitutional review is a little bit different. One might think that there are problems, but they are not that complicated as the colleagues in Poland.
Cernitz, judge at present second national expert by the Court of Justice of European Union, member of the Council of European Constitutional Law Foundation, and former Deputy Chancellor of Justice and visiting lecturer at the Tartu University, to present its findings.
Thank you very much. First of all, I would like to congratulate Lithuania to its constitution and its constitutional court. And as we see on this announcement, there are two crucial elements of constitutional state: democracy and constitutional review. The constitutional review is what makes out of a rule of law, together with democracy, a constitutional state. And this is perhaps one of the most important advancements of constitutional law science. I want also to congratulate you to the relationship, to the respectful relationship between Parliament and Constitutional Court, as we saw in the beginning of today. I think the respect of the Parliament towards Constitutional Court is crucial to make the constitutional state work. And I'm really glad to hear that in Lithuania it works well. I want to thank you, thank the Mykolas Romelis University, the Constitutional Court, the Parliament and the Bar for this excellent conference. And personally, Toma and Jolita, thank you very much for this invitation. Speaking is easy, listening is harder, understanding is very much harder. I want to thank the interpreters for the excellent work as well. But now to the text. I will let the institutional aspect aside, because first of all, it has been told about the unique court model in Estonia, and it might be considered as advantage or disadvantage, depending on the perspective. And come to the aspect how the constitutional or the Supreme Court in Estonia, Riigikohus, applies constitutional rights. I try to make it as brief as possible. Relatively early on, Riigikohus made it clear that constitutional rights are subjective rights. The two most important theories of the construction of constitutional rights are contained in the terms internal theory and external theory. The way in which the implementation of a constitutional right is to be constructed depends on, first of all, whether the implementation of a right is proceeded from the point of view of the internal or the external theory. Excuse me. According to the internal theory of rights, there is only one thing, the right with a certain content. According to the internal theory of rights, the limits of a right cannot be distinguished from the right itself, because a right has an internal limit. According to the internal theory, it is for the implementer of the law to determine the content of the right by the interpretation. If the facts correspond to the normative prerequisites of the constitutional norm, a definitive legal consequence, an obligation, prohibition, or permission follows. The starting point of the external theory of rights is quite different. According to the external theory, there are two things: the right as such, on the one hand, and the limit or restriction of the right on the other. In contrast of the internal theory, the external theory of rights holds that it is possible to imagine a right without any limitation. In such a case, the right is unlimited. For instance, unlimited freedom of expression would include expressions that insult someone's honor or good name. An unlimited right has only an ideal character, because in reality every right collides with other rights, which are also unlimited in their ideal form. The real limit of a person's freedom of expression is an imaginary frontier beyond which the defamation of another's honor and dignity begins. The prohibition of defamation of a person's honor and dignity is therefore the real limit of freedom of expression. Applying the external theory of rights consistently, the first step is to determine whether an activity, characteristic, or condition is guaranteed by an ideal or unlimited right. The second step in the application of constitutional right is to draw a line upon the unlimited right. The location of the limit depends, for one, on the purpose on which restriction, for instance of the freedom of expression, is permissible, and secondly, on the substantive relationship between the purpose of the restriction and the exercise of the freedom of expression. It is only after such a restriction of the right that the real right becomes apparent. Figuratively speaking, the area of definitive protection of the right lies inside the limits, and the area of definitive prohibition lies outside the limits. According to the external theory, there is no necessary link between the concept of right and the concept of limit. The link is created only by the external requirement to make the right compatible with the rights of others and with collective goods. Thus, the way in which the theory of constitutional rights is constructed has an impact on the way on how a breach of a constitutional right is found. I argue that for the scheme of review of the liberty rights, equality rights, and rights of protection, it is correct to proceed from the external theory. However, in the case of constitutional rights to organization and procedure and the social rights, following only the external theory seems not always to be possible. Every legal norm is made up of a composition, prerequisites or assumptions, and of a legal consequence. The composition of a norm entailing a constitutional right constructed in terms of external theory consists of two elements: the scope of protection and its infringement. The legal consequence of a constitutional right is the obligation of the addressee of the constitutional right, that is, the state usually, to justify the infringement of the right. In general, an infringement is constitutional if it is formally and substantively constitutional. To the interpreters, we jump now to page 6. The three-step approach: scope of protection, infringement, justification, applies first and foremost to liberty rights. In case of equality rights and rights to protection, applies some specific features, but the main structure of scrutiny remains the same. The infringement of an equality right consists in an unequal treatment. To establish unequal treatment, it is necessary to form comparison groups. When forming the comparison groups, it is always necessary to focus precisely that in unequal treatment which unconstitutionality seems most likely. In case of protection, the infringement may lie in the lack of state action, but it can also lie in a shift in risk distribution by the legislator. The case of ordinary law underlying the constitutional case is triggered by an act or omission by a third party. In this way, a triangular relationship arises, in the resolution of which only the conflicting private interests, but also the public interest, must be weighed in the balancing process. And now we come to the model of application of that corresponds to the internal theory. The internal theory of rights is accompanied by a narrow theory of composition. In the case of the internal theory of law, the scope of protection of a constitutional right must be determined solely by interpreting the minimum protected. The doctrine of constitutional rights is far less developed in this area. However, there are strong arguments that at least the rights to a minimum subsistence level and the right to access to justice are definitive rights at their core. According to the first minimum subsistence level, according to paragraph 28, subparagraph 2 of the Constitution, every citizen of Estonia is entitled to government assistance in the case of need. Based on this, positive obligations of state authority, including the legislator, deriving from constitutional rights, are no longer disputed today. The general constitutional right of social assistance, in the case of need, is triggered in the event of failure to obtain the minimum means or services necessary for subsistence, and has, as in its essence, the right to obtain these means and services. Riigikohus has interpreted the case of need as follows. Deprivation within the meaning of the Constitution should be understood as a situation where a person lacks the minimum necessary means of subsistence. Elsewhere, Riigikohus has clarified the need for assistance from the state in case of need is linked to a subsistence threshold, the income of which should provide a household with the minimum means to meet its basic needs. These quotations indicate that the minimum subsistence level is supposed to be a definitive right, because if the subsistence minimum is not guaranteed, then it must be guaranteed on the basis of the Constitution. There is no weighing. To the access to justice. The most important case for the access to justice is the Tivek case from 2000. In a previous year, criminal police had conducted a search by the company named Tivek, which traded with offshore companies. It was a very good business idea at that time. Two officials of the tax office were present during this search. In particular, the searchers took allegedly more than 5,000 company documents, several personal computers, seals, computer disks, and metal drawers from the filing cabinet. Tivek sought to obtain judicial protection, including the return of documents and objects, and argued that its fundamental right to property and its right to the inviolability of commercial premises had been infringed. The problem was not only that the criminal procedure laws did not provide adequate remedies, but the administrative courts, which were also approached by Tivek, were unwilling to hear the complaint because of lack of a corresponding legal basis in the procedural law. Riigikohus deduced Tivek's right to obtain judicial protection directly from Constitution and European Convention on Human Rights. As a result, Riigikohus sent the case back to the administrative court for review, finding that the absence of effective judicial control would be worse than control by different courts, and that it is the task of an administrative court to check whether the procedural act did not violate the person's constitutional rights and freedoms. In this way, Riigikohus granted Tivek access to justice without weighing. Furthermore, in the Osmyorkin case from 2011, which is considered as one of the most important cases to the application of the general right to organization and procedure, the pre-trial criminal proceedings concerning Mr. Osmyorkin had lasted more than 10 years. Since there was no special rule for this situation, Mr. Osmyorkin filed a complaint to the administrative court based on the general provisions of state liability law and applied for damages caused to him by the pre-trial criminal proceedings. It was highly disputable at that time whether administrative courts had the competence to try the complaint for damages caused by criminal proceedings. The administrative court and the court to appeal declared the complaint of Mr. Osmyorkin inadmissible. Riigikohus declared the complaint admissible on the basis of European Convention of Human Rights and our Constitution, thereby ensuring the access to justice. Particularly, Riigikohus stated, there is no proceeding which would enable a person whose rights have been violated by an unreasonably extended pretrial criminal proceeding to have recourse to the courts with a claim for compensation for damage. Both cited cases suggest that the right to access to justice is a definitive right. In both cases, Riigikohus justified the need to grant the applicant access to justice with the argument that the applicant could not obtain it in any other way. In these cases, there is no balancing, but a clear decision to grant access on the basis of the constitutional norm when the condition, no access, is present. This is very similar to the application of a norm which is bound, has a bound legal consequence. Despite a strong argument in the literature that the constitutional rights are to be constructed exclusively on the basis of external theory, and they mostly are, because we mostly control a right in this three-step. We have scope of protection, infringement, and justification of infringement. The cases presented and the doctrine developed by Riigikohus seem to prove the opposite. It seems to prove that there are rights, constitutional rights, that have these internal rights structure. It seems to be that there are both types of constitutional rights. The rights constructed in terms of external theory, such as the liberty, equality, and protection rights, and the rights constructed in terms of internal theory, such as, in particular, the right to minimum subsistence level and the right to access to justice. While the doctrine of rights constructed in terms of external theory is well developed, I just let it out today, the 4 pages. There is still much that is unclear regarding the doctrine of rights constructed in terms of internal theory. At this point, the hypothesis should be put forward that the rights constructed in terms of internal theory are similar to rights that have indeterminate or blank legal concepts on the side of their composition, but to which legal consequence is bound. However, as already said, there is much unclear yet in this field, and it remains to be seen how the case law will develop. Thank you very much.
Thank you, dear colleague, for your very interesting presentation and sharing the main aspects and issues and trends of the last jurisprudence of Estonian courts, and giving the main examples to your presentation. I would like to add that very fruitful cooperation and friendship between Lithuanian, Latvian and Estonian Supreme Court, naturally I mean, has been developed during the last years. And in this frame, during our trilateral meetings, we are sharing also very useful information about national practices and jurisprudence. Thank you very much, and I want to turn to our third presenter and reporter and honorable guest, honorable judge from Ukraine. I mean, my big privilege to introduce to all attendees of this conference Professor Dr. Alexander Petrishin, who is currently the judge of Ukrainian Constitutional Court, and professor is an academician of the National Academy of Science in Ukraine. But also I have more information about Professor. He's the head and a member of the editorial boards of the various scientific legal journals, and Alexander Petrishin participated in the development of draft amendments to the Constitution of Ukraine, draft laws of Ukraine on public service, concepts of criminal justice reform in Ukraine, etc. And he worked as a member of a commission of a legal reform under the president of Ukraine, and naturally, as I said, he is a member of the Presidium of the National Academy of Sciences of Ukraine. Dear colleague, very big thank to you that you found time to come to us to share your experiences about activity of the Ukraine Constitutional Court in this very difficult war time.
Thank you very much. Dear Professor Toma Birmontene, dear colleagues, first and foremost, I would like to extend my heartfelt gratitude to the Constitutional Court, the Parliament of Republic of Lithuania, and all citizens of Lithuania for their unwavering support toward Ukraine. And the Ukrainian people in their resistance against the military aggression of the Russian Federation. I will not proceed in Ukrainian to present my report. Слід наголосити на тому, що сьогодні Конституція України вважається.
First of all, it should be noted that the Constitution of Ukraine is considered to be a constituent document that organizes the political governance in the state and consolidates the state institutions and their interaction with citizens. In a number of rulings of the Constitutional Court of Ukraine, the constituent value of constitutional norms were specifically emphasized. And that is why this raises the question as to the necessary set of the most important questions for society and the state that the Constitution should address. In this case, the classical approach through a mandatory list of constitutional laws may be useful, and I believe this would be a very good idea. For example, in the Kingdom of Sweden, there are only 4 of them on the succession to the throne, on the form of government, on freedom of the media, and on the right to information. At the same time, in recent years, we've noticed the trend to expand the scope of public administration of public affairs and therefore government influence. In the past, the Constitution in the Soviet Union was perceived by society and politicians as declarations, programming documents, or general guidelines for the whole system of legislation or legal system. Therefore, the requirements for the constitutional norms were not included. And the constitutional norms were formulated in such a way that it was impossible to apply them in practice. Therefore, the Constitutional Court in its rulings often stresses that the Constitution is the foundation of the state, and that governs political relations. Such provision was included in the Constitution for the first time in 1996. In addition, and again I'd like to stress, the Constitution can be directly applied in relations between private individuals. Our courts of general competence have to directly apply constitutional provisions. Now, I will talk a little bit about the martial law in our country and the work of the Constitutional Court. Let me tell you that the Constitutional Court is operational in Ukraine and in this way resists the aggression of the Russian Federation. Well, you know, we sometimes have such moments when we hold a seminar with the German Constitutional Court, and during this meeting we have to suspend our meetings because of the air raid alarms. So the conditions are very difficult, but functioning of the Constitutional Court is very important. First and foremost, the functioning of the court demonstrates and confirms to the entire society of the country that is waging a severe war that the Constitution of Ukraine is not repealed, that it is in force, albeit with certain reservations, in accordance with the conditions of martial law provided for in the constitutional provision. So the Constitution is operational. There are certain aspects, there are certain exceptions, but these exceptions have been incorporated in the Constitution itself. So under the Constitution of Ukraine, the parliamentary elections cannot be held during in the situation when a martial law is declared. In some cases, municipal elections can be held, but some laws then have to be amended. But parliamentary elections can be held only if the Constitution is amended. But during the times of war, there is a ban to hold parliamentary elections. In our activities during the situation of martial law, we try to apply the concept of a democracy that can defend itself, or as it is also defined in the European constitutional doctrine as defensive democracy or militant democracy. The Constitutional Court of Ukraine operates primarily as an institution that is designed to protect the Constitution and constitutional values, and especially it has to do so during martial law. These constitutional values include sovereignty, territorial integrity, democracy, human rights, and the rule of law. In these circumstances, the Constitutional Court has passed a number of specific judgments directly aimed at facilitating the defense against the aggressor, against the Russian Federation. And I'll mention a few most important judgments. The first judgment is the judgment of the 6th of April 2022 in the case of the constitutional complaint of Serhiy Polishchuk on social and legal protection of servicemen and members of their families. The fact is, the text of the Constitution includes two categories of persons who are subject to enhanced social protection. So the first category is the people with disabilities, and the second category is servicemen. That's why the court adopted a judgment in relation to servicemen, and the Constitutional Court stressed that under martial law, the state has the duty to mobilize all available resources to strengthen its defense capabilities and repel the armed aggression of the Russian Federation. Therefore, comprehensive support of servicemen of the armed forces of Ukraine is considered to be one of the means of expanding the defense capabilities of the state. Another important judgment by the court was adopted on the 27th of December 2022. Again, this is related to the case on the constitutional appeal by 49 members of Parliament of Ukraine. It dealt with full name of religious organizations that are part of religious organization, the governing center of which is located outside Ukraine in a country that is recognized by law as having committed military aggression against Ukraine or in a temporarily occupied part of the territory of Ukraine. The case was very difficult indeed. I was privileged to talk about this with the senior judge, Sergei, about this case. We have several religious organizations in Ukraine. One of them is, in fact, the affiliation of the Russian Orthodox Church. So we wanted this church to be called as the affiliate group of the Russian Orthodox Church. But then we were blamed for persecuting the organization. But our intention was to inform our citizens what kind of church they are choosing. If they think that this was important for them, they have to know the full name of the church. And we wanted to contribute to their informed choices. Prior to the outbreak of the full large-scale aggression, on the 22nd of November 2018, regarding the strategic course of the state for the acquisition of full membership of Ukraine in the European Union and the North Atlantic Treaty Organization. Again, this is one of the most complex problems that the court had to address. The discussions were very lengthy, but we looked into three aspects. We believe that Ukraine has a strategic objective to follow European integration and Euro-Atlantic integration, because these things were included in the preamble of the Ukrainian constitution as a major ambition of the state of Ukraine. Also, certain commitments were undertaken by the president, and the president, under the constitution, is obliged by the constitution to follow the same path. Accordingly, the powers of the Verkhovna Rada of Ukraine, the President of Ukraine, and the Cabinet of Ministers of Ukraine were vested with the authority to implement the strategic course of Ukraine's full membership of the European Union and the North Atlantic Treaty Organization. So this problem was solved at the level of the Constitutional Court. In addition, on the 16th of July 2019, before the war, the Constitutional Court adopted a judgment on condemnation of communist and National Socialist Nazi totalitarian regimes in Ukraine and prohibition of propaganda of their symbols. In such judgment, the Constitutional Court emphasized that the condemnation of the Nazi and communist regimes and the prohibition to use their symbols by the law are justified by the legitimate objective of preventing a return to the totalitarian past. Such a ban is intended to prevent any speculation on the use of the historical past associated with totalitarian regimes and to prevent the glorification of these regimes and justification of their crimes, including the war crimes that are committed currently in Ukraine. Symbols directly related to the tyranny of the state institutions and their arbitrariness are generally associated with negative and destructive political ideas. The implementation of the ideas in the period from 1917 to 1991 pushed Ukrainian society to the margins of civilization, deprived the Ukrainian people of their right to their own state, destroyed traditional moral and cultural ideas. In the context of the realities of martial law, a number of urgent problems have arisen in relation to the need of postponing the judgments of the Constitutional Court, because there was a need for additional budgetary allocations. There are quite a lot of cases, especially in the Constitutional Court, and these cases are related to the defense of pensioners or to the increase in the wages, and we take account of these cases. In this case, there are two approaches. We look at the cases, but postpone the judgment for a period of 3 to 6 months. And if this is related to huge budget allocations, in the judgment, we say that this judgment will be officially declared after the end of the martial law. So this is not a very pleasant thing to do, but still, we have to find a way out. Well, we've heard the way the Constitutional Court in Lithuania works. When it comes to the Constitutional Court in Ukraine, we are trying to ensure our society that their human rights are protected, and in this sense, the Constitutional Court of Ukraine supports the citizens of Ukraine. We have a special website, and we make quite a lot of information available on that website. We inform people as to the cases that we undertake and as to what kind of people we try to defend. We talk about people with disabilities, servicemen, and so on. In all its judgment, the Constitutional Court seeks to make use of the established approaches and standards of the European Constitutional Court, the leading idea of which is to observe the rule of law and democratic principles of state power. Therefore, the issues of protection of constitutional human rights are becoming increasingly important. We make use of some the practice of American, U.S. courts, Lithuania's Constitutional Court, and so on. If we looked at the judgments of the Constitutional Court of Ukraine, one might think that we are already part of Europe, because our mindset and the principles that we applied are directed exceptionally towards European standards, that is, the rule of law, democratic principles, protection of human rights and freedoms. We are guided by these principles when adopting, well, virtually all judgments of the Constitutional Court. In the times of war, the Constitutional Court has ensured that citizens of Ukraine, including those in the occupied territories, have access to information. So the Constitutional Court established a standard form for the institutional complaint, which means that any person willing to submit a complaint can simply contact our website, the website of the Constitutional Court, and can do this in a very easy way. This solution was very efficient because the scope of complaints has increased. So this was thanks to the technological advance. And I'll mention a few things from the 24th of February in 2022 to this day, the Constitutional Court of Ukraine adopted 22 rulings. For example, the Grand Chamber adopted 5 rulings for under the constitutional complaints. These complaints were related to the unconstitutionality of either certain norms or and there was one judgment on a constitutional complaint. They also issued 17 judgments of the Senate of the Constitutional Court. So over almost 2 years, the court issued 22 judgments. Now, to conclude, I'd like to express all my best wishes to Lithuania. During the break, we talked to my colleagues, and I was grateful for the solidarity and for the support of both the Parliament of Lithuania, the government of Lithuania, and the people of Lithuania for their support to Ukraine. I want to express my gratitude to Professor Toma Birmontienė for inviting us from Ukraine, for providing us with the possibility to come here to share our insights. Let the peace be on earth. Thank you.
Дякую. I'm not very good in Ukrainian. Thank you very much. So it was really very interesting and very important that even in a time of war, the Constitutional Court is functioning, and individual complaints, and they are just producing decisions, declaring decisions, and it's very interesting that when we in Lithuania use that notion of the economical crisis, during economical crisis, some decisions were postponed to pronounce and to come into force. So the same practice we can see now in Ukrainian Constitutional Court, because of course human rights have to be supported and have to be, they are. But sometimes economical and war situation, you can't just give everything in 1 day or in 2 days. So that postponement means that you and support and they really exist. So that's very important.
Thank you very much. Because the Lithuanian Constitutional Court has a very long-standing cooperation, and it has been a tradition. And the Lithuanian Constitutional Court made an agreement with the Ukrainian Constitutional Court well before the aggression in Crimea in 2014, and I hope that our cooperation and support will continue into the future. Now let us move further And I would like to give the floor to our dear colleague Jolita Miliuvienė. She doesn't need any wider presentation. She is a teacher at Mykolas Riomeris University, and Professor Zinkevičius have entrusted a great responsibility on her. She is a lecturer on constitutional court, constitutional law, and now she is the advisor to the President of the Constitutional Court of the Republic of Lithuania. So she has a much wide view of the activities of the Constitutional Courts in cooperation with the case law of other countries. Thank you. The Justice of the Ukrainian Constitutional Court mentioned that Ukraine is following the case law of foreign countries. I would like to discuss Lithuania's experience in doing that. Much has been said today about EU and foreign case law, and following this case law by the Constitutional Court, its drawbacks, but the necessity to do that. In most cases, external factors affecting the development of constitutional case law refer to acts in EU and international law. There are other acts that are referred to as a soft law. For example, preparative documents of the EU, Venice Commission, resolutions and recommendations. Not binding soft law acts, in particular those adopted in the field of constitutional law, are often based on generally accepted general principles of constitutional law and on a universal interpretation thereof, on a European constitutional heritage common to all states. And their relevance to the constitutional justice cases should not be surprising either. These have been referred to by the Lithuanian Constitutional Court from the very beginning of its activities. In the order of the 13th of December 1993 on the confiscation of assets under the additional criminal penalty, after interpreting the provisions of the Constitution and following a constitutional assessment and before final conclusion, it reached mentioning a provision of the Tokyo regulations approved by the UN resolution. In this case, a soft law provisions, in addition to binding legislation, have guided the case law of the Constitutional Court in a number of cases that led to significant legislative changes. The Constitutional Court has spoken about the importance of soft law acts and binding acts of the European Union. Soft law sources may also include decisions of constitutional courts of foreign states that deal with constitutional problems similar to those addressed by the Constitutional Court of Lithuania or interpret common constitutional values. The use of case law of foreign constitutional courts in national constitutional doctrine creates a phenomenon of the so-called migration of constitutional ideas. But for what purpose are they quoted? Are they used as a reference? But does this not mean that the reference to the Constitutional Court is not sufficient itself? Are they used to better persuade the correctness of the decisions taken, or are they only a constitutional rhetoric, at best a context illustrating the case? Reasons literally vary. In principle, the decisions of the constitutional courts of the states as a source of soft law for the interpretations of the rules of the national constitution are typical to the states with younger democracies, which, in light of their short experience of constitutionalism, do not avoid using the practice of the more experienced constitutional courts, which have already faced similar problems with constitutional justice, even though this rule is not an absolute. Does not this undermine the uniqueness of Lithuania's constitutional experience and the Lithuanian constitutional tradition? It must be assumed that it does not, because whatever external sources judges may rely on, they are bound only by the Constitution and its provisions when dealing with the cases. If we ask judges of the Constitutional Court of Lithuania when they took the view that foreign court decisions could be useful in resolving the case, they would probably reply that they have always read them and were interested in them, even though the texts of court decisions refer to foreign jurisprudence only since 2008. However, both the first president of the Constitutional Court, Juozas Žilys, and the judge at the time who later became president of the Constitutional Court, Mr. Lapinskas, have repeatedly said that the newly established constitutional control body had to build from scratch, and there was no example in the Lithuanian legal system of how the final acts of the Constitutional Court should be laid down and how to organize the court activities in general. Thus, since its establishment, the Constitutional Court has been active in engaging with and drawing on the experience of esteemed constitutional courts of other states. Over time, this has also been reflected in the legislation adopted by the Constitutional Court. These legal acts indicated that the assistance of the German Federal Constitutional Court was particularly important for the development of the Lithuanian Constitutional Court. Following the recent ruling of the Constitutional Court assessing the constitutionality of the COVID pass, it was noted that the Constitutional Court had copied this decision from the French or Austrians. Although in principle copying as a phenomenon has a negative connotation, since copying means failing to be original, this case should be seen in a different light. In an increasingly globalized world, constitutional courts of different states address similar problems based on the same universal principles and values of constitutional law, which form part of the constitutional heritage, the promotion of democracy, the protection of human rights, and the rule of law. It is therefore not surprising that the Constitutional Court of another state, which has previously ruled on a similar case, can serve as an example, even though its position does not bind the judges deciding the case in any way. Decisions of the constitutional courts of foreign states are thus seen as a source of practical wisdom in dealing with complex constitutional dilemmas where positive legal instruments are no longer sufficient. The fact that foreign constitutional case law became of interest when hearing Lithuanian cases well before references to foreign constitutional decisions were made in the final act is illustrated by the material gathered in constitutional justice cases. In any material of a larger or more complex case that goes beyond national issues, we can find specific constitutional decisions of other states which have shaped in one or another way views and internal beliefs of the justices hearing the cases. For example, the text of the decree abolishing the death penalty of the 9th of December of 1998 refers only to international instruments and to the case law of international courts, but it is apparent from the documents in the present case that a decision of the Hungarian Constitutional Court in that regard has also been carefully examined and translated into Lithuania. An overview of those judgments of the Constitutional Court, which already refer to decisions of the constitutional control bodies of other states that are relevant to the case, shows that the case law of European countries, in particular neighboring countries, is the most frequent used case law. The judgment of the constitutional courts of Germany, Poland, and Latvia are mostly frequently quoted, but reference can also be made to judgments of the Supreme Courts in the USA or Canada in individual cases. It is for the court to decide, taking into account the specific features of the case, whether it is relevant and useful to the case to be referring to the decisions of the constitutional courts of foreign states. The two situations can be distinguished where foreign constitutional case law may have a decisive influence on constitutional justice cases. When addressing a societal and sensitive issue, and the constitutional court solution is likely not to reflect the views and wishes of the majority of the public. In such cases, the constitutional court, in accordance with the case law of foreign courts, illustrates the well-established trends in the development of constitutional thought in order to demonstrate that the decision to be taken is based on the universal principles of constitutional law, which form part of the European constitutional heritage values the content of which should not be called into question. In this case, the use of foreign case laws in the final acts of the Constitutional Court constitutes a solid confirmation of the decisions taken by the Constitutional Court. Such an example can be found in the resolutions of the Constitutional Court, which have been mentioned on several occasions today, which reveal the constitutional concept of the family. Initially, in 2011, the traditional perception of the family that a family can only be formed on the basis of marriage, all the more so since both institutes are governed by the same article of the Constitution, was still very popular. However, it was clear that it did not correspond to the reality of society of modern concept of the family. In 2019, further expanding the understanding of what should be considered a family, in addition to supranational court rulings, the Constitutional Court disclosed in sufficient detail the provisions of the judgment of the Romanian Constitutional Court on the legislation of the relations of the same-sex couples and respect for their private life, as if wanting to show that Lithuania is still waiting for this issue to be settled. Other circumstances when the criminal court is inclined to rely on foreign case law is when it deals with completely new issues in the Lithuanian legal system or constitutional justice, and no formal doctrine on that issue has been drawn up or developed precisely on that particular aspect. In this case, the Constitutional Court does not analyze the constitutional decisions of foreign states in order to justify and reinforce the solutions it has chosen, but rather in order to be inspired by the search for a solution and possibly also the wording of certain provisions of the constitutional doctrine. In some cases in which the borrowing of the rules laid down by foreign constitutional courts is particularly evident, we may refer to constitutional legal transplants from one legal system to another. An example of such a case could also be the latest ruling of the Constitutional Court on the extended confiscation of assets, which raised the question of the presumption of innocence. The case law of the Constitutional Court has so far not fully disclosed the content of this principle, which guarantees one of the most important procedural guarantees. New elements of the principle of the presumption of innocence, namely the inapplicability of that principle in relation to the preventive effect and in the imposition of restorative justice measures, have been formulated and inspired by decisions of the constitutional courts of Romania, Portugal, and Germany. In his decision, sometimes in order to illustrate the context of the case, reference is made to foreign case law. For example, Latvian Constitutional Court ruled on the private life and the control of correspondence between convicted persons when the Constitutional Court of Lithuania had to deal with this issue only in 2015. During the pandemic, many courts were faced with the same issue. Countries may have had different measures for containing the virus, but the constitutional courts were loaded with the cases. And in one of the cases, on the COVID-19 measures, the Constitutional Court of Lithuania was blamed for copying from French or Austrian Constitutional Court rulings. Should the fact that the judgment of the Constitutional Court does not refer to a judgment of a Slovenian court or the decision on the mandatory participation of a lawyer in an appeal on a point of law does not refer to a judgment of the Latvian Constitutional Court, be understood that court was not aware of them? Certainly not. When preparing a case for trial, judges analyze all the information relevant to the case at hand and evaluate the information that can help resolve the case. However, it is natural to choose the solutions best suited to the case, reflecting judges' internal convictions, views, and methods of legal reasoning. Judges would not choose to take into account those decisions of foreign courts that are not acceptable to the majority of judges because of the interpretation or understanding of constitutional values contained in that judgment, or because of the different regulatory context. And I highly doubt that the Lithuanian Constitutional Court would be guided by the recent judgment of the Polish Constitutional Tribunal declaring the convention incompatible with the Constitution of the Republic of Poland, as mentioned by Professor Birmontienė. In the above-mentioned decision on the unconstitutionality of the COVID pass, the Lithuanian Constitutional Court based its position on the restriction of human rights and freedoms during an emergency, essentially on the basis of the principle of proportionality in line with the precautionary principle, a sufficiently new principle for the Lithuanian legal system. This situation was extraordinary. The Constitutional Court, in its case law, differently from evaluated and assessed the restrictions of human rights and used the principle of the precautionary principle, which allowed for the legalization of restricting certain standards. Well, actually, it is quite normal that in emergency situations, the government have more powers to adopt legislation on the restriction of human rights. Emergency situations change, and the government can respond appropriately to this and can decide how many and which restrictions permitted by law should be applied on a case-by-case basis. The Slovenian Constitutional Court remained close to the classical principle, but this does not mean that any of the decisions is incorrect. This means that courts chose different interpretation of the law. Anyway, it is clear that in addition to all the advantages that can be seen in the constitutional courts in their final acts in the light of the case law of the constitutional courts of foreign states have so far been characterized by the skepticism of that practice. As a result, the hot discussion between the two U.S. Supreme Court judges Antonin Scalia and Stephen Breyer, which took place more than 15 years ago, on whether it would be appropriate for constitutional courts to rely on a comparative analysis and to take into account decisions of foreign constitutional courts, is therefore still relevant. According to Breyer's argument that in the constitutional justice cases, it is not only interesting but also useful to know what foreign colleagues have said on similar cases, especially in view of the fact that the aim is the same. It is the protection of human rights, so that it would be simply unwise to ignore it, all the more so since foreign constitutional decisions can only be useful as a source for reflection and not as a binding source. Scalia was not persuaded by that. In the latter's view, the constitutional courts referring to foreign constitutional case law generally select only those which favor their decisions, so that such examples do not reflect the full picture that exists. No foreign court would be in a position to say how best to interpret the provisions of a national constitution. But does that mean that the Constitution should be alive and not static? Despite such and similar concerns, the migration of constitutional ideas both within the legal systems and of states and between national constitutional courts and supranational courts, which also happen to take into account national constitutional decisions, is rather widespread phenomena today. This practice has helped the Lithuanian Constitutional Court to enshrine in the Lithuanian legal system decisions that have sometimes exceeded their time, which over time are no longer called into question by anyone. The adoption of constitutional ideas also contributes to the development of a common understanding of the underlying constitutional values, leading to a later conclusion on the formation of a standard on a practical issue. Constitutional courts cannot therefore ignore not only the developments within the state, but also in a certain external international context, constitutional law developments, or what happens in other states when interpreting the provisions of the Constitution and forming official constitutional doctrine. Solutions to challenges indicated by global constitutionalism found in the constitutional case law of other states can serve as a source of inspiration and help to find an appropriate solution to national constitutional justice cases. The Constitutional Court of Lithuania would not be in a state it is today, and the formation of constitutional doctrine it shapes would not be so diverse in other cases.
Thank you, Ms. Miliviene, for your speech. Unfortunately, and quite a pity, it's the last speech of the day. We heard quite some controversial speeches throughout the day, but the topic that you've covered was definitely worthy of attention. I believe it would have caused a great debate following your speech, because it definitely contains a lot of controversies. I believe the speaker has already referred to it as well, but I believe I could repeat in saying that when the Constitutional Court, from the methodological point of view, chooses to include the approach of the constitutional courts of other countries, I believe this is being done because they try to demonstrate an existing compromise, one that exists in Europe, related to the developed constitutional thought that exists throughout Europe, especially when it comes to the protection of fundamental rights. Or perhaps sometimes the Constitutional Court does that in order to show that a compromise does not exist just yet on a certain matter. Even in the absence of a compromise, the Constitutional Court will continue to develop a position that will be reflected in the official constitutional doctrine of the Constitutional Court. And perhaps in one way or another, the Constitutional Court will contribute to the future compromise that might be found throughout Europe. So thank you very much for your ideas, because I believe that the subjects that you have covered are definitely part of heated debate. Now, let me turn to those present in this hall. Would there be anybody willing here to ask a question, perhaps comment? Because we now enter the concluding part of the conference, focused on discussion and summary of the conference. So I have to use my right as a moderator together with my colleague and offer everyone a chance to take part in the debate. Yes, please. Ms. Ramutė Ruškytė, a former Justice of the Court whose term in office has expired. I would agree with Professor in saying that the final topic of The last speech was definitely important. I would like to express my opinion not only as a former justice. I could not deny the fact that it is bad that a huge share of a ruling of a court is part of the rulings of foreign constitutional courts. It does become a kind of soft law, but I would agree with Judge Scalia. The Constitutional Court is being interpreted on the basis of the Constitution. The Constitution can be interpreted with the help of the case law of other constitutional court. However, we should rely on the Constitution. The interpretation of other constitutional courts could just serve as a background for the interpretations of the Constitution. Thank you very much, Madam Justice. I'm not sure if the speaker would be willing to respond to the comment by the former judge. Yes, another former justice of the Constitutional Court. Yes, thank you very much. I would just like to share the following. When I was working in the Court of Human Rights, European Court of Human Rights, we had debates as to how we should rely on the Convention. There's a European consensus that is being abided by. The court was constantly criticized for relying too heavily on the European consensus and simply stating in some of the cases, let's say cases on same-sex union, on adoption, as well as other very sensitive issues. It has been argued that a European consensus has not been formed on such sensitive matters, which is why the court does not find any violations of the Convention. So the court was criticized a lot because of the failure to execute its main function, instead trying to avoid any difficult situations. And the court apparently is still waiting for the case law of other countries. So do we have some kind of constitutional consensus that has already been formed, including foreign constitutional courts and their case law, as well as the international case law? I, on my part, would agree with Jolita in saying that we have a very clear constitutional doctrine in that the Constitution is a source of the interpretation as well as the case law of other constitutional courts. So I'm truly grateful to all of you who've shared your ideas. I'm grateful to all of the speakers, those from Poland, from Ukraine, from Estonia, from Latvia. It was very interesting to listen to all of them. Thank you. I will just take 1 minute to respond. I'm grateful to all of the justices, former justices, for their comments. The fact that there's a consensus and there's a search for consensus is already meaningful. Should the court decide to ignore the consensus, the court would have the duty to look for arguments as to why it chose not to follow the existing consensus. And the court has never said that it adopted a certain ruling based on a similar case law in other constitutional courts. As Justice Scalia has said, this would not referring to foreign constitutional case law would be an attempt to perhaps avoid explaining something or mentioning something. Yes, thank you. Well, I think we shouldn't stop at that, and we should continue working 24/7. Perhaps stay here until we see the day of the Constitution. But on a more serious note, do we have any other wishes that we would like to express or ideas that we would like to share? If not, then I would like to now pass over the floor to Ms. Birmontienė, who I would deem to be the spirit and the host of today's conference.
Thank you very much. I can assure you that there were many more people behind the organization of this conference. So I'd like to thank the Seimas Committee on Legal Affairs. We have arranged quite a few conferences in the Lithuanian Parliament. We are truly grateful to the Constitutional Court, because if not for the Constitutional Court, such a conference would have been impossible. And we've discussed quite a few judgments. I would also like to express my gratitude to the Lithuanian Bar Association, because the association has always supported the conference, and we had always the opportunity to listen to very interesting presentations. And now it seems that the Bar Association tried to see the situation even beyond. And I would also like to express my gratitude to Mykolas Romeris University. And I will sum up everything very briefly. The conference was broadcast live, so there will be a video of this conference. I am not going to mention everyone's ideas expressed, because my evaluation does not necessarily coincide with the evaluation of the audience. But still, let me draw your attention to the keynote presentation of the President of the Constitutional Court, which gave rise to other speeches. The President of the Constitutional Court overviewed the 30 years long jurisprudence of the Constitutional Court. We traditionally talked about the history of the Constitutional Court. We had our renowned constitutionalists, the first President of the Constitutional Court, Professor Žilys, Egidijus Jerišūnas, Sinkevičius, the people who worked a lot both in drafting the Constitution and in drafting the law on the Constitutional Court. They are the ones who are most knowledgeable in this area, and we are grateful to them for their time and for sharing their ideas with us. The constitutional review and the constitutional doctrine merits separate discussions. Unfortunately, Professor Kouris was not able to take part our conference live, because we would have given him very many questions, but we are truly grateful to him for sending his video presentation to us. His insights were very valuable. Our colleague Ramute can attest to the fact that the professional experience and of Professor Kouris has provided us with very many fundamental principles. Well, he talks about the year 2006, because this was a revolutionary year in the history of the constitutional doctrine. As a former justices, we would expect further development of the doctrine rather than the destruction of the doctrine. Well, but sometimes I think that the doctrine is being demolished. I'm also very grateful to our guest from the United States of America, Richard Albert, for traveling a very long distance to Lithuania from Texas. I guess he hasn't seen snow in Texas, but there was snow in Lithuania, so he must have seen the snow this morning. I would also like to express my gratitude to our well-known constitutionalists, because we want to make sure that those great people see the situation when it comes to the constitutional design, both in Lithuania and in other countries. And we've read the articles by Professor Albert, and he sometimes reflects on Lithuania, and we are grateful for his contribution in disseminating the information on the Constitution of the Republic of Lithuania. The case law of courts of general jurisdiction is also of great importance, and I'm grateful to Professor Dr. Gediminas Sagatis, chairman of the Association of Judges, and he told us about the approach of the judges we hope that when there is a question which court to resort to when interpreting the Constitution, certain legal norms, our Constitution would be the primary source. We are grateful to Danutė Jočienė, former president of the Constitutional Court. I'm grateful to the former Latvian the former president of the Latvian Constitutional Court. We took account of the insights of the Latvian colleague, and just we heard how the fact that it was not easy to achieve this change of mindset from the Soviet times to the times of independent Latvia, and the changes were great in the jurisprudence of the Latvian Constitutional Court. I was really impressed, and I guess we all were impressed by the presentation by Professor Dr. Skirgailė Žaliminė, who focuses on European law a lot, and I was very happy to hear that the Supreme Administrative Court of Lithuania relies on European law, and I was particularly pleased to hear what issues the courts deal with, and the rulings that the court adopted and as I have mentioned, I was very surprised by the broad approach by Mindaugas Kukaitis, chairman of the Council of the Lithuanian Bar Association. You know, I thought that he was going to speak about some budget, about tax reforms, because I thought that it was a very sensitive question for the Bar Association, but that was not the case. Mindaugas Kukaitis talked about all the problems Lithuania faces, but also how law could help solve the problems. Law is a powerful instrument, but in order to ensure that this law is efficient, there have to be many more factors contributing to that law. Sometimes the law is perceived as a very strict document that governs the life of especially young people, and we should not make use of the law to punish our young people and to take them to prisons, because we make decisions on their future. And when it comes to the last part of the session, we've all participated in it. We've all heard what it was about, and we're grateful to the former Justice of the Constitutional Tribunal of the Republic of Poland, Marek Zubek, for his insights, how politicians influence the work of the Constitutional Court. Well, I can't say that the Lithuanian Constitutional Court had similar experience, but the development of the Polish Constitutional Tribunal would be very interesting for us as justices and as researchers, and we are looking forward to the situation that will develop after the recent parliamentary elections, and we wonder how the ruling majority will be able to govern the state, applying and comply with the rule of law. And I would also like to express my gratitude to the Estonian colleague. We were truly happy to hear the experience of the Estonian constitutional law. Well, we know that Latvian constitution is a very old one, but if we looked at the catalogue of human rights, we would see that Estonian experience is richer. What is interesting is that in 1992, the constitution that was adopted in Estonia already saw the spirit of constitution, and these words are inscribed in the constitution. And that is why we have been arguing for so many years. We were very happy to hear the Ukrainian experience, a very painful one. Our courts cooperate, and the state of Lithuania supports both your country and the Constitutional Court of Ukraine. And we are happy that the Constitutional Court can work efficiently and develop the doctrine and find possibilities for the Constitution to survive the war. This is very impressive indeed. It seems that the last speaker, Jolita Miliuvienė, was the person behind the last discussions. Well, there was a debate as to which jurisprudence we should rely on. But, well, dear colleagues, artificial intelligence will be the one to collect all the rulings that we won't be able to find ourselves, because it will help us. So we are living in a very global space. As I have talked in my presentation, I believe that artificial intelligence can help us, but I don't believe that artificial intelligence can love, can administer justice, or can treat people. Maybe this will be the topic of our discussions of our future conferences. Dear colleagues, to conclude, well, my conclusion was a rather lengthy one. Now, I would like to express my gratitude to the part of expressing my gratitude. So first, I would like to express my gratitude to Aidena Baicevičienė, advisor to the Committee on Legal Affairs of the Republic of Lithuania. We have cooperated with her for many years. I do appreciate the relations that we have had with her, and we are very grateful for her support. We are also grateful to our interpreters as well. We're grateful to Aušra Vielavičienė, Živilė Čiuželytė, and Ona Pometko, as well as our sign language interpreters, because our conference was interpreted in a sign language. Since it was broadcast live, people with hearing impediment also had an opportunity to see sign language interpretation. We are also very grateful to the operators of the Lithuanian Parliament who ensured the broadcast of the conference. The conference was very interesting. There were no slides. Everyone spoke. That was a rather academic conference in this sense. So we're grateful to them, and we hope that those who were watching us online heard everything well. So I'm grateful to Artūras Semakinas, Laimontas Daunoravičius, Eligijus Abarius, and Rolandas Augulis. And my special thanks goes to our photographer, and we're going to have some photographs. Ilona Shilenkova. I would also like to express my gratitude to two of my colleagues from Mykolas Romeris University. That is Kristina Bernatavičienė. Thank you, Kristina. You are the one to help us. And Jolita Milivenė. You have worked a lot. And I do apologize for the things that went wrong, but we merit a round of applause. And the last idea. Let us not forget, and let us not forget to celebrate the 31st anniversary of the Constitution on the 25th of October. So congratulations on